It's all right because I'm at the beginning of it anyway.
Okay, all right.
Yeah, thanks. So what I've shown so far is that I just fed my original complaint into it. This is when I started over with Claude 2. I was realizing that Claude 100K Instant, which I was using before, or it's called Claude Instant 100K, is older. It's only trained through 2021. Claude 2, as of now, is trained through early 2023. It's much more robust, I found. It does much better analysis of what you feed into it. It has much better synthesis of when it writes draft oppositions or pleadings, whatever you tell it to. So anyway, I gave it my complaint against Panda Express. I told it to analyze it. It did a good job of summarizing it right here. I then fed in the answer that I got from the defendants. And also in the meantime, I've discovered that you can upload the when you're at the and I'll show you this later, when you're at the prompt, you can attach a PDF, and as long as the PDF is readable, as long as it has the text, you can copy the text from it, then you just attach it to the prompt and you don't have to copy and paste. It's much more convenient that way. So I fed it the answer and it gave a summary of the answer. Okay. And again, this is everything I showed last week. So I'm not going to dwell too much other than just to show that, I started from the beginning, refed it, so far here, the complaint and the answer, asked it this question: what are the strengths and weaknesses of defendant's claim that plaintiff does not sufficiently allege a qualified medical condition? Just kind of getting its opinion on. Anytime you see hello, that's where I lost the internet connection, and so I had to say something in order to kick it back into gear. And when I do, it goes back and it sends me the text that I missed. So this text came after I said hello. Anyway, so just explaining that. So when you see that, just ignore that. Then I told it to analyze the motion for judgment on the pleadings, and I fed that into it. And it analyzed it and summarized it and determined that it gave an assessment of whether it thinks they have a good claim or not. So, then asking some questions here. Does plaintiff's complaint allege intentional discrimination? Gave me a really nice analysis of that. We could dwell on this, but I will give you, I think I already shared the link. If I didn't, I'll share the link of this transcript. In fact, I'll do that right now. Here, I'll put it in the chat room. I'm gonna put it in the chat room. And if you at your own leisure want to there it is, go through this transcript and see how I did it, you're welcome to. Give me a second here. Okay, so I asked it a question: is plaintiff's complaint allege intentional discrimination? Gives me a good analysis here. So then I wanted to feed it the request for judicial notice in support of the motion for judgment on the pleadings. This is the accompanying document that Panda Express filed that had guidance from the California Department of Public Health and some other crap from them. So I fed that in there, just because I wanted it to have as much information. So once I fed that in there, it reassessed the motion now in light of this information, and it said, oh, they even have a stronger case now. So every time I fed it more information, it reanalyzed everything and gave me a new assessment, which was really helpful, right? So then I tell it here, the theory that the health order was not in effect in Placer County because the health order, local emergency, was terminated on September 8th, and explain how what I discovered from my reading of the California Emergency Services Act is that the governor only doesn't have authority to act within local counties. That's for the local governing body to both enact a local emergency and to terminate it. That the power is clearly expressed to be in the hands of the local governing agency, except for where they can't handle the emergency and blah blah blah. But anyway, I explained all this, right? We went over this last week. Okay, so then it says, oh, well, with that information, you raise a good point, and then it gives another analysis. So then I fed it the governor's order. This is the governor's order of March 4th, 2020, enacting the state of emergency. and then it analyzes it. And then I ask it a question I already know the answer to. Does the governor's order specifically instruct the counties to terminate their local health emergencies? Because what I'm getting at is that that's, I'm starting to show a support for the idea that the governors, when the county terminated the order, then the governor's order ceased to have effect in the county. That's basically what I'm trying to point to. And getting in that frame of mind, getting in that context is the more proper term. So then I feed it the resolution from Placer County of September 8th, 2020, terminating the health emergency. And it gives me a new analysis here, kind of says, thanks for that information, kind of. So then I tell it, based on the previous analysis, does the plaintiff make an argument that the law regarding the Emergency Services Act, in the very least, is unclear as to who has the authority to, whether the statewide health orders apply, and it said, yeah, you can make a good argument there. The law isn't clear, blah, blah, blah. So, again, I'm just asking it questions. And then I ask it, how could that be used? This question I asked, I said, how would this provide a counterpart that could allow the defendant to dismiss the plaintiff's claims outright? So I'm seeing if there's like a problem where the defendant could prevail. And then it got confused and thought I was pointing out it made an error. And it said, you're absolutely right, I misspoke, which it didn't. It got confused. So, this is one of those things you got to watch out for, is when it gets confused. So and then I had internet problems here. So I then went back and I asked it the same question in a different way. Would plaintiff have a stronger discrimination claim if in fact the statewide health order was not in effect during the incident? Anyway, and then it came back and gave me an analysis on that. I asked it if there's a standard for determining what a reasonable accommodation is, because another part of my complaint with Panda Express is that the accommodation they offered of allowing me to order outside was not reasonable, considering Panda Express is a buffet style restaurant where you see the food before you order it, right? So I was telling it information about this. So I'm asking it here, complainant make an argument that the offer to be served outside was not reasonable, considering the food of Panda Express is offered buffet style. I said, yes, plaintiff could make the argument, blah, 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 was not reasonable. So then, and I showed this again last week. This is the final prompt before it spits out the opposition document. So it's a big, long, very articulated, specifically articulated prompt, and asking a lot, because I'm telling it to give me, the whole paper, the whole opposition to the motion for judgment on pleadings, including case law citations, including table of contents and table of authorities, basically a complete document. It's a big ask. Okay. So again, I don't want to go through the details here because we still have another transcript to go through, and I'm just sharing my experience with this for the benefit of everybody else, to show how powerful these are. So then here it is. It spits out a draft opposition. It says table of contents, but it didn't really produce a table of contents. This is kind of an outline, really. So this part right here is really just like an outline, or I guess it is the table of contents. And it said table of authorities, but it didn't really provide a table of authorities. But anyway, we have, all the sections and all the parts of section, the argument, A, B, C, D. So all of this was proper, so here's the introduction, relates back to here. And so anyway, so it did follow this as a skeleton for producing the document. So then, so it spit out a much different paper than the one it did last Tuesday, and much more confident, much more better argued, much more robust overall. But you can see here for relevant factual background, it just put a note here, summarize key facts alleged in complaint, yada yada. So it didn't produce that, so I had to go back later on and tell it to produce that, which is not a big deal. Same thing with legal standard. It was a kind of a bummer that it didn't provide those sections. If I had told it right then and there to fill in parts 2 and 3, it might have been easier than doing it later on, which is what I did, but I'll show you what happened. And then the argument, and the argument was good. And so here's part A of the argument, plaintiff has sufficiently alleged a claim for violation. And that corresponds to this up here in the table of contents. So it makes that argument, backs it up with some case law. So the more case law there was, the more work I knew I had to do, to check all that. And to cross-reference all of the, or to check all the cross-references it's making here, like when it references back to the complaint. And this means paragraphs, so it's saying paragraphs 11 and 22. So I went to the complaint and made sure that, I sanity checked everything. And it did a good job of doing the cross-referencing and stuff. It's with the case law that there were still some problems. Much better than Claude Instant, but still problems, and I'll get into that. Part B argument, part C argument, part D argument, filled them out completely. Lots of good, argument, conclusion, there's your draft. So then I started on it. I copied that and pasted it into a Word document, my pleading paper format, pre-formatted pleading paper, and started editing it. And every time I came across case law, I started to look into it. First thing I checked was to make sure that the case actually existed. Like this one's called Pizarro v. Lambs Players Theater. And here's the citation, 135 Cal. 4th, 1171. I would put the 135 Cal. 1171 into search engine, make sure it existed. I would make sure that it was the same case, Pizarro v. Lambs Players, and then I would read the summary of the case to make sure that it was giving the arguments that the paper was or that Claude was making and using this case to support it. And so in this case, it used Pizarro back up here. Let's see, down here, and it says these allegations are sufficient to state a claim under the Unruh Act for discrimination in public accommodations. I'll highlight the whole thing. And defendant's motion should be denied. And then it cites Pizarro v. Lambs Players Theater. And then it says reversing dismissal of Unruh Act claim based on denial of a religious accommodation. Well, I found nothing of the sort in the case itself. The case had no finding whatsoever anywhere near reversing dismissal of Unruh Act claim based on denial of religious accommodation. So I had to tell Claude that. I said the Pizarro case does not seem to be reversing dismissal of Unruh Act. Please review this case, see if it actually applies to the argument, and if not, please substitute with the California case that does support the argument in section 4 part A. And so it realizes it made a mistake and it rewrites it, and here it gives me the whole part A again, and everything is the same up to here where it says starts these allegations are sufficient, blah blah blah, and it comes up with a different argument. So I read it gives me a new case here, Catholic Charities of Sacramento versus Superior Court. I look it up and I find out again there's a problem. I said the Catholic Charities case he cited does not seem to have anything to do with the Unruh Act. So it had nothing to do with Unruh. Try again. They tried again. This is what it comes up with now, this right here. And now it's using Alcorn v. Ambro Engineering. I found it to be the same thing. The Alcorn case, well, I found that the Alcorn case was closer to offering needed support for the contention that the allegations of the complaint are sufficient to state an Unruh Act claim, i.e. what it's saying here, what it's claiming to support. But I said it's not close enough. So I said, review this information. So what I did is I went to the jury instructions, and then once in a while, we refer to the jury instructions to find the elements you need to plead for to properly plead a cause of action. So I found the one for the Unruh Act, and I copied the whole document and pasted it in here because it has all the information, the instructions, jury, as well as all this case law in here, and little explanations of what the findings were for the case law. Lots of good information for the language model to absorb and suck up and absorb. And so that's what it did. And it said, okay, thank you for walking me through this and helping me find better case support. So we're having this nice little friendly dialogue here. So I said, okay, with that additional information, can you find a case that better supports the argument in section 4 part A that the allegations are sufficient at this stage of the pleading? Yes, let me take another look. And so it finds a better case, apparently. So now it's quoting, or it's citing this right here, Mid-Peninsula Citizens for Fair Housing. And it's saying now it's allegations of denial of housing based on family status sufficient to state an Unruh Act claim. So I said it's almost there, but the finding in that case have to do with the Fair Housing Act. We need something have to do with the Unruh Act. I said, can you find something that's what has to do with the Unruh Act instead? and it say, yes, here you go. So again, all this from here to here is the same. This is where it's changing. And now it's citing Jackson v. Superior Court, saying that allegations of racial discrimination under Unruh Act sufficient to withstand demur. And I patted on the back here. Excellent, you did well. And then it thanks me for having patience and walking it through the process. So it's acting like my little my nice little apprentice here. All right, anyway, so you can see, I'm using this as a back and forth. I'm just conversing with it. I'm still guiding it. I'm still acting as its mentor to get it to where I want it to be. But it's being very helpful in terms of actually doing all the hard work for me, finding the cases. I still had to go and find and read the case, look up the case, read it. There was still a lot of work involved here. I started like at, I don't know, 7 in the morning, maybe 8 in the morning, something like that. And I was ready with my documents to go to the court by 3 p.m. Get them filed, had them served and everything by 3 p.m. So all in all, a very efficient process, but it still took time in between all these prompts, for me to go back and do the reading and the sanity checking. So that's still a very big part of it you have to keep in mind. Okay, so then I told it the Turner case, make sure the Turner case in section 4, which is argument part B, supports the contention that they're making. So it found a problem with that. And so then I said, and so it re-edited and I said, no, now you've misstated the Turner case citation. I said, find a better case that supports the argument. And so it came back and it came back with something different. It came back with Donald v. Cafe Royale. And I said, well, that deals with the Disabled Persons Act. Find a case that deals with the Unruh Act. So now it came back and it gave me the Munson v. Del Taco case, which is definitely an Unruh Act case. I'm familiar with it, but it didn't exactly give me what I wanted still. I think it's down here that I'm trying to get it to edit. So I just told it still has issues, but we'll address it later. And I said, for now, I'll use what you've given me. And then again, it's like sitting here talking to me like it's human, which is kind of funny. All right. And then I say in part D, the Conn v. Corinthian College decision does not support the argument. So again, I'm going through and I'm picking out methodically. I'm going, and I'm the paper, the opposition draft that it spit out. I'm going through and I'm checking each case, and on all the ones that I found were problematic, where it was using it to support something that it didn't, or was using it in support of the argument being made. I had it check itself. So this is we're getting to the end here as far as that. So it rewrites it, and I said the William S. Hart case is close, but it does not involve the Unruh Act. Find one involving the Unruh Act. So again, I'm just having it do all the work, and it's doing it. It's just so incredible. But I'm having an issue here with this case law stuff, and it seems like the farther out you get from the original paperwork being submitted, it starts to like lose its context. And so that's kind of what we're seeing here, So I'm saying here again, Barton has nothing to do with Unruh. Try again. And then it replaces it with this Quire case. And I say a Quire case involves the Unruh Act, but has nothing to do with, but has to do with appeal after a trial. We're dealing here with a demur basically. And so it gives me the Munson case again. I say it's close, but that also involves an allegation of the Americans with Disabilities Act, which is completely different issue. So if as we read here, I keep having problems with it. And then I start to get frustrated with it. And so I just tell it Part D should be rewritten, relying on case law that involves the Unruh Act, because it keeps coming back. No matter what I say to it, it keeps coming back with just some bullshit, and I'm having problems with it. So I tell it to rewrite it. It kind of does, but I said that's close. Replace the Angie decision with McDonald v. Superior Court. So now here, that's an interesting prompt, because it cited this case Angie v. Superior Court right here, and it says liberal leave to amend standards apply to Unruh Act claims. And I said, all right, take that out and replace it with this other case I already know, where I think the ruling there would fit better. So I'm doing like cut and paste here, but I'm having the computer do it for me. Right. So it does it. It incorporates it in this section here. You can see now it's putting McDonald in here. And I said, better, but reword the last paragraph so that the relevant finding from McDonald is summarized in brackets. And so it did that. I said, it's good enough for now. And I said, so I was able to take what it gave me, which is, it wasn't a perfect response, but can't have it do everything for me. So I worked with what it gave me, edited it to my liking. And so then I told it here, remember it didn't produce the section 2, the relevant background, factual background. So I told it to produce that, and it did. It did a really good job of putting in all the references automatically to the complaint where necessary. So, I mean, that's such a time saver right there. It made the reference to the exhibits as well. It knew what exhibits are in the complaint. So it's great. Or I'm sorry, in the answer. But there's a problem. It put wrong dates. All the dates were made up. I have no idea where it got the dates from. So I told her review the complaint as well as the answer, cross-check everything and make sure you get the dates right. Oh, it says, oh, you're right. I'm sorry. Here it is. And so it spit it out again and the dates were wrong again. So I said, just start over, take all the facts from the complaint and answer. And it said, oh, sorry, here you go. And again, it was all wrong. Dates are all wrong. I said, no, throw that out and do it over. And it keeps giving me the wrong stuff, And then I'm talking to it like it's a real person. I said, this is not at all acceptable. I relate this myself. So I'm getting really frustrated with the thing. So I did. I took what it gave, and I think I just, used that and just fixed everything up. And then I said, give me a paragraph 3 now for the legal standards. And I told it, check the case law citations you just provided. And I think I missed something else that was supposed to be here, but anyway, it did some analysis here. So we're still trying to rewrite the section on the legal standard. It seems to be having trouble here again. And so it comes up with this, there's a case it cites, and I know that it doesn't cite what it says. And so I'm querying it and it says, yeah, you're right. I got that wrong. Another problematic case I'm referring it to. So try again. Again, Kohlberg, I said it's off point. Find a different case. It finds the Shabaram case. So I'm going back and forth with it, telling it, okay, this case is bad. Find me a better case that makes a better argument. So this is a back and forth, going back and forth. Very, very tedious, but this is the process. And then I noticed it gave me a fake case. And then it gave me another fake case, and now I'm just frustrated and I start yelling at it in all caps. And then I'm trying to get it back on track. I'm trying to get it back into the context of, okay, look, what's the legal standard for pleading a violation of Unruh Act? And so it says that. And so I basically I realized I wasn't getting anywhere fast with this, right? And I was running out of time, but it gave me enough to where I could piece together what I needed to write the complete document. So I went ahead and finished the document, and that's what I'm feeding it right here. It didn't give me the complete document, which would have been nice. So there's still work involved, but I put it together based on everything you just saw, that whole back and forth that happened over hours. And now I still needed a table of contents and a table of authorities for it. So I said, produce a table of contents and a table of authorities for the following opposition document. I fit in the opposition document as I had, edited at the time, and it spit it out, and it did a damn good job of it. Here's all the cases and the statutes, did a really good job. And that's it. So then I took this output, added it to my document, and I had my opposition to their Panda Express's motion for judgment on the pleadings, and got that filed and served on time. And that hearing is on the 27th, the result for that. So are there any questions? I hope that wasn't too boring and too tedious, but I'm hoping on the To the contrary is what I'm trying to say. I hope people found that actually very elucidating to show how you can really use these tools. Any questions? If not, go ahead.
I think that instead of using the word insure, you might try insure.
Oh, when I'm talking to it,
Uh-huh.
it's possible.
Might not know what you mean.
Well, what's the difference between insure and insure in common English? I'm wondering if there's a difference.
Well, there, yes and no. Insure, they say, kind of the first definition to make sure, but the rest of them say, see insure. And insure means to make sure, certain, or secure. To provide
I'm
or
looking at-
arrange insurance for.
All right, here, let me share the screen while I'm looking at these definitions, because it's a good point. So I'm looking at insure. This is just, I just, pulled it up on the web search. To provide or arrange to provide or arrange insurance for, to acquire or have insurance for, to make sure, certain, or secure. So this is probably the definition we're trying to get at.
Right.
And then if I try insure, which is what I was writing, right? To make sure or certain, insure. So it's the same as 3 over here for insure. But
I remember it's a young technology. It's a kid. It may not really understand it the way, you're seeing it.
oh, absolutely, absolutely. And so that's kind of me exploring the limitations of it. And so I've come across some so far, as I've shown, but I've also found it to be very powerful. And to, so again, I usually approach these things very timidly and go like, yeah, I don't know if I could just sit here and pretend it's like data, from Star Trek, and I can just start talking to it. But why not? Let me just go ahead and do that. And to my surprise, to my shock, really, it actually is like talking to data from Star Trek. It's incredible, especially what it comes up with in terms of, because it doesn't, as far as I know, it didn't have any specific legal training. It was trained on code. It was trained on, I forget what the list is, but it was just general business to business and art, and it didn't mention even anything about law, but it's so competent law. It's scary. And so that's what I want to show you in this next transcript, which I have loaded up. And this one is a much this shows you the power. Okay, so let me give you some background. So it took me a week to produce my opposition document to Panda Express. I started on Monday last week, and by the time our last week's meeting started, I had got it to the point where it finally spit out the opposition paper. And I took the whole meeting to go through the transcript up until that point, and everything I had learned, that previous, 24 to 36 hours. So then I was hoping that I would be done with this by like Wednesday, and then I can turn my sights towards Randy the barber. Well, unfortunately, I had to work on my paper all the way through Friday because my deadline to file it was Friday. The deadline Randy had was also Friday, but I figured we have time on that, and there's reasons, and I'll get into that later if necessary. But I was comfortable with not worrying so much about Randy's deadline. So on Monday, then, I was like, okay, I want to file something by today, because technically with this kind of document, it has to be 9 court days before the hearing. So yesterday was the 8th court day. Anyway, so that's the parameters I was up against, and I needed to have something fast. And I'm dealing with again, another preliminary injunction motion, just like with Snapdragon and Cliff. Same exact situation. They're saying he's running a barbershop without a license. So I'm like, okay, how am I gonna write an opposition paper to this? I'm still, for all I just went through, I don't know exactly how I'm going to approach this. Now, we talked about it on Sunday and we came up with some good ideas as far as challenging it with a cross complaint. So that's gonna be a separate issue. That's gonna be a separate session. I haven't indulged in that yet. In the meantime, I wanted to make sure that we're opposing this injunction. So with that being said, here's the prompts for that. So I started off and I said, analyze the motion for preliminary injunction. And here I just attached the PDF to it. So instead of having to copy and paste it, so it's much more convenient. And so here it summarizes it. Here are the key points. And, it summarizes the complaints filed by the Board of Barbering and Cosmetology, and talks about the standard for the rule of dealing with this. And, and we went over this with Snapdragon, the JT Corp rule, about how, once there's a rebuttable presumption arises, that potential harm to the public outweighs potential harm to the defendant. Once the board shows that as reasonable possibility prevailing, the burden of proof then jumps to whether the defendant can show grave or irreparable harm. So we went over this ad nauseum couple 3 weeks in a row, right? So everybody should hopefully remember that. Same standard. So it analyzed it very well. So then I just talked to it. I told it, okay, defendant Randy Wayne Mitchell claims he has converted his former barbershops into private members only social clubs. Since the state conducted its investigation, his clubs do not offer barbering or cosmetology services to the public, and their club conducts itself in a way that results in an intimate association amongst its members. And that's an important term right there, because an intimate association is selective with its members. It's more like a family. It's more like a large nation, as opposed to an expressive association where anybody can join. There's no selectivity or anything. It's just like you sign a membership form and pay a fee and you're in. So then and then I said, here's how they describe themselves in their mission. So I just copied this from his website. I went to the Uppercut Barbershop website, copied this and pasted it. And then I finished and I said, their social clubs are not open to the general public. They do not advertise any barbering or cosmetology services on their clubs or online or in any other way. They do allow members of the public to apply for membership, but membership is selected. So here's what it comes back with. Based on the additional information provided, here's an analysis of defendant Mitchell's arguments. Mitchell claims he's converted his establishments into private social clubs that do not offer barbering or cosmetology services to the public. He argues these private clubs result in an intimate association amongst members that is protected by the freedom of association under the First Amendment. I didn't tell it any of that. It's telling, at this point, I'm learning from it now. It's like, oh, okay, intimate association and the freedom of association. Okay, First Amendment. Okay, good. The clubs assert they do not advertise services to the general public, are not open to the public, and have a selective membership process. Mitchell could potentially argue this private club model means he's not violating licensing statutes, as he is not offering services to the public. However, the board could counter that the clubs are a pretext to continue providing unlicensed services under another guise. The board still has authority to regulate and inspect the premises for health and safety, regardless of how the clubs label themselves. Mitchell previously held licenses for barbershops at some locations, indicating they were public-facing businesses. Advertising is not required for an establishment to be considered public-facing under the licensing laws. The intimacy of the association and selectivity of the membership does not automatically exempt it from regulation. Okay, cool. It gives a fair assessment of our counterpoints. So it says, in summary, while Mitchell raises an argument that the social club model avoids the licensing statutes, the board has several potential counter arguments that could still establish likelihood of success on the merits under the JT Corp presumption. The strength of each side's arguments would depend on specific facts about the club's operations. Okay, so then I gave it my prompt here. So I'm like, all right, fine. Write in opposition to the motion for preliminary injunction. Use Randy Mitchell's previously provided testimony as the basis for the opposition. He no longer operates barbershops or salons and has converted his shops over to private social clubs. The clubs are membership based. Members are selected based on whether they meet the club's criteria. No barbering or beauty services are advertised to the public, nor do the websites give any indication that barbering services are performed. Mitchell additionally claims he follows all applicable codes and laws and has business licenses for club locations. The club is an intimate association of artists that share a particular skill and passion. Support the opposition arguments with case law drawn from California cases that ideally relate directly to barbering and cosmetology licensing issues, or licensing issues and the Business Professions Code more broadly, including defenses that Mitchell may employ, and argue that he and his club members would suffer irreparable harm if the injunction, well, I said is, but it should be if the injunction were to be granted. And fortunately, these language models are extremely, they can even read around your typos. All right, so with the very limited information I just gave it, right? I gave it the motion for preliminary injunction, and I told it some stuff, posted about us section from their website, and now I'm asking it to write an opposition. And here's what it comes up with. And it's pretty good. And so I'm going to read it because it's not that long. Introduction. Defendant Randy Mitchell respectfully opposes plaintiff's motion for preliminary injunction. Plaintiff seeks to enjoin defendant from operating his private social clubs, which he converted from his former barbershops after the revocation of his licenses. However, the social clubs at issue do not provide barbering or cosmetology services to the public. Rather, they are private membership associations entitled to constitutional protection, and plaintiff has not established that licensing statutes apply to their activities. Plaintiff also cannot make the heightened showing required for a prior restraint on defendant's freedoms of association and assembly. Finally, defendant and his members would suffer irreparable harm if plaintiff's overbroad proposed injunction was granted. Defendant therefore respectfully requests that the court deny plaintiff's motion. Statement of facts. After the revocation of his barbering and establishment licenses, defendant converted his former barbershops into private social clubs. Mitchell Declaration, paragraph 5. Now, mind you, it's reciting facts from a declaration that doesn't exist. It's making all this up as it goes. And it's saying, it's pretending there's a declaration that Randy Mitchell wrote, and it's referring to all the stuff that he should be saying in order to support the argument that it's making in this paper. So do you see what's happening here? It made an argument, and it filled in references to a declaration that doesn't exist in order to support the argument it's making. So it's putting the cart before the horse here. So I'll show you how I dealt with that later on when I needed the declaration. But
AI would call it AL, all lies.
yeah. So these clubs, well, but it's not. I'll show you. These clubs operate as intimate associations of members who share a common passion for the barbering arts. I mean, it put it so well. The barbering arts. The clubs are not open to the general public. Membership is selective and based on criteria aimed at identifying individuals who share the club's passion and mission. Barbering or cosmetology services are not advertised to the public in any manner. The club's websites provide no indication that barbering services are available. Members bring their own tools and equipment. Defendant ensures the clubs comply with all applicable laws and regulations. So it hit all the key points that it needed to in order to make the argument that it's going to make. And it's doing this automatic all on its own. I didn't, again, I'm learning a lot from it while reading this. Argument. Plaintiff fails to show the licensing statutes apply to defendant's private social clubs. Plaintiff argues defendant is violating Business and Professions Code section 7317 and 7347 by providing barbering services without proper licenses. However, the social clubs at issue are private membership associations, not public facing establishments subject to licensing requirements. Courts have found licensing schemes inapplicable to various private groups and arrangements between individuals. See this case from Texas. Federal licensing requirements do not apply to chemical hair removal performed incidental to thread signaling women's marital status. Barbering performed solely between club members with a common passion for the craft is not the type of public-facing activity the legislature intended to regulate. Because the clubs do not offer services to the public, plaintiff cannot establish a likelihood of prevailing on the merits. I don't think I could have come up with that conclusion or argument on my own unless I did a lot of many hours of research. B, constitutional protections for freedom of association bar plaintiff's prior restraint. The social clubs reflect an intimate association of individuals for protected liberty interests under the First Amendment. See this case, Citizens Against Rent Control, the City of Berkeley. Plaintiff's proposed injunction would constitute an impermissible prior restraint on these associational freedoms. Black Tea Society versus City of Boston. Ordinance requiring permits for gatherings was unconstitutional prior restraint. Courts apply strict scrutiny to prior restraints, and the government must show a compelling interest that is narrowly tailored. Thomas v. Chicago Park District. Plaintiff cannot make this heightened showing as its licensing interest does not justify the overbroad injunction sought against defendants' protected private clubs. Again, I mean, I'm no expert, but that seems like a really competent argument. And, we're going to test that here coming up. The defendant and his members will suffer irreparable harm if the injunction issues. Plaintiff's proposed injunction would cause irreparable harm by violating defendant and club members' constitutional rights to freely associate. The loss of First Amendment freedoms, even briefly, constitutes irreparable injury. L. Rod B. Burns. Defendant and other members would also suffer harm from being unable to participate in the intimate association formed around their shared passion for the barbering arts. Roberts v. United States J.C.'s, discussing constitutional protection for intimate associations. Plaintiff's showing of potential public harm is sufficient to overcome the grave consequences for protected freedoms. And then the conclusion. That, to me, is amazing that it just spit that out after I fed it just, the little that I fed it, right? So it gave this. Okay, so now it's time to start tearing this apart. So I tell it, based on the statement of facts included in the proposed opposition document, write a declaration for Randy Wayne Mitchell in support of the opposition paper that conforms to California rules of court for a declaration admissible as evidence in a California trial court. Use the citations to the declaration provided in the statement of facts as a cue. So I wanted to go back and write the affidavit or the declaration upon which the statement of facts is based. So it did so, and it wrote a terrific declaration. Here it is. I, Randy Wayne Mitchell, declare as follows. I'm the defendant in this action. I have personal knowledge of the facts set forth in this declaration, and if called as a witness, I could and would testify competently to these facts. 2, I make this declaration in support of my opposition to plaintiff's motion for a preliminary injunction. 3, after the Board of Barbering and Cosmetology revoked my individual and establishment barbering licenses in 2021, I converted my former barbershops into private social clubs. 4, these social clubs operate as intimate associations between members who share a common passion for barbering arts and skills. 5, our members join together out of a shared enthusiasm for barbering craftsmanship. We consider ourselves a fellowship of artists devoted to our craft. 6, the clubs aim to unite individuals from diverse backgrounds through a common interest in barbering and provide members with opportunities to develop their skills and talents in this craft. 7, our membership criteria aim to identify individuals who share the same passion and commitment to excellence in barbering arts. 8, my goal is to create an environment where people can come together in community around the barbering craft. 9, the social clubs are not open to the general public. Only members and invited guests are allowed to enter the clubs. 10, we have selective membership process based on criteria designed to evaluate prospective members' shared genuine interest in the barbering arts. 11, the clubs do not advertise any barbering or cosmetology services to the general public in any manner. 12, our websites do not give any indication whatsoever that barbering services are available at the clubs. 13, if members provide barbering services to one another, they do so only on a voluntary basis. 14, members bring their own barbering tools and equipment. The clubs do not provide tools, materials, or products to members. 15, I ensure that the clubs comply with all applicable laws and regulations in operating our facilities. 16, if plaintiff's proposed injunction is issued, it would cause irreparable harm by violating my and our members' protected rights of association under the First Amendment. 17, the clubs reflect an intimate fellowship centered on our shared passions. If the injunction issues, this injury to our associational bonds cannot be repaired. And then it puts the standard declaration under penalty of perjury and yada, yada. So it went out and it found all between everything that I fed it about Randy, his website, etc. It comes up with this rather lengthy declaration that supports everything, that says everything, and it's all true. Everything that's in here is true. And because I sent it to Randy, I said, Randy, can you sign your name to this? And he said, yep. So he said, perfect. And it did this all by itself. It did this by itself, just based on what I already fed it. Let that sink in. Okay. Now the problem is.
So you asked it to write the declaration, or it said, here's the declaration in support?
Based on the statement, here's my prompt. Based on the statement of facts included in the proposed opposition document, write a declaration for Randy Wayne Mitchell in support of the opposition paper that conforms to California rules of court for a declaration admissible as evidence in a California trial court. Use citations in the declaration provided in the statement of facts as a cue. That's all I gave it. It imagined the rest of this.
Got it.
Okay, so then I told it, conform section 2, statement of facts in the opposition paper with the declaration you just produced. So I had it rewrite this, it basically rewrote the statement of facts to now conform back to the declaration it just produced. And as you can see, it's much more expansive than the original. Here's the original up here, right? It's this paragraph. And then now after it made the declaration, then I told it to conform the statement of facts to the declaration. It's now about twice as long. It's all of this, okay? So it just, you know, conforms that. Okay, so now I have to check the case law. And this time I was gonna let it do more. I was gonna see if it would do more of the work for me. Now I'm still reading the cases. I'm still looking them up. I'm still sanity checking them, making sure they actually exist, making sure the citation is proper, correct. Looking at the findings. Now mind you, I'm not doing very in-depth. I'm doing very cursory, just basically scraping the surface when I'm looking at all this stuff because, you know, I've only got hours to do this. So keep that in mind. But so my next prompt here is double check the case law in the opposition document, confirm it's valid, confirm it's on point for the argument it's supporting. So it goes through and it does this analysis. This is what it says. I reviewed the case law cited in the opposition document and found Patel v. Texas Department of Licensing and Regulation. This is a valid case. Supports the argument that licensing requirements may not apply to certain private groups or arrangements, as the court found chemical hair removal performed incidental to religious threads did not trigger licensing. Citizens Against Rent Control v. City of Berkeley, valid U.S. Supreme Court case supporting the argument that First Amendment protects freedom of association in private groups and clubs. Black Tea Society, valid case finding a permitting ordinance for public gatherings was an unconstitutional prior restraint on freedoms of speech and assembly, supports prior restraint argument. Same thing here. It says, it summarizes this as it supports a framework for prior restraint analysis. Elrod v. Burns, valid U.S. Supreme Court case finding irreparable harm, supports irreparable harm argument. Roberts v. United States Jaycees, valid case, supports irreparable harm argument. In summary, cited cases appear valid and on point to support the arguments made in the opposition. Okay, I'm no fool here. So I went and did my own checking. I wasn't happy with the Patel decision, so I said, double check the citation for Patel, seems incorrect. And so, yeah, it gave me a bad citation for Patel. Case is a real case, but it gave me a bad citation. So it's a, you're right, doesn't seem to match. The case number, reporter, volume, page numbers do not align with the case involving chemical hair removal and licensing requirements. I did some additional research and believe the case being referred is actually this. So it gives me this and I check it and sure enough, this is the actual case now. This Texas Supreme Court case does align with the facts and holdings stated in the brief. I apologize for the incorrect citation earlier. So it's doing all this for me. It's checking all this for me based on this prompt right here. This is double check. I just said double check it. All right. And so then,
But citing a Texas case in a California court doesn't carry a lot of weight.
I understand that, but this case in particular, because of the finding, it found the closest case it could. Because I think
Well, I would use the arguments, but I wouldn't cite the case because it's not authority in California.
Yeah, I see attorneys do this all the time, though. See, again, that goes back to what I was saying. I don't know if I mentioned this already here, but or last week, I think I did, that this reminds me, I think attorneys have had these kinds of tools for years and years now, because I see this all the time from attorneys. And it's either, you know, they know cases from Texas somehow, or I don't know. Anyway, I get the point. Again, limited time here, so I'm just going with it. And it said, then it asked me, please let me know if I should revise the citation in the opposition brief to reflect the proper case. Well, of course. So I said, yes, revise the citation and show me the paper with that correction as well as the new section 2 you produced earlier. So I'm saying revise it and spit out the new paper. So here's the new paper now. It has the introduction, the new statement of facts, and it has the argument that it fixed. And here's the case again with the proper site. And then it says right here, remainder unchanged. Okay, so then I told it to analyze. I'm still unhappy with the Patel case. I said, analyze it and tell me its findings. So it analyzes it and gives me this summary here. It's rather lengthy. I won't read the whole thing out. And so that says, in summary, the key findings were that Texas's cosmetology licensing violated Threader's constitutional rights because it was an irrational and oppressive regulation not reasonably related to legitimate health and safety concerns. So I said, does your analysis of Patel conform to the summary provided in Part A of the argument section of the opposition document? And does the Patel case still support the argument made in the opposition? And it says, yes, it does. And it gives a reason. You know, it says it's consistent with the summary. The key points for my analysis align with the brief description of the case holding that licensing requirements do not apply to chemical hair removal, performed incidental to religious threads, signaling a woman's marital status. And based on my analysis, I believe the Patel case does still support the argument made in the opposition brief. Specifically, it supports the argument that licensing schemes may not always apply to certain private groups or activities. Okay, that's a good point. The court found that the imposing burdensome licensing restrictions on eyebrow threaders who are engaging in a cultural and religious practice violated constitutional rights. Okay, I was happy with that. Similarly, defendant Mitchell is arguing that requiring licenses for selective private social clubs providing barbering services solely to members with a shared passion and not the general public would be an unconstitutional application of the licensing statutes. So in my assessment, the Patel case and my analysis of it aligns with how it is summarized in the brief and provides precedent to support the opposition argument that licensing may not apply to defendants' private clubs. And that is a very reasoned analysis. So I accepted it. So, okay, good enough for me, buddy. So I moved on. Said, analyze Citizens Against Rent Control City of Berkeley and tell me its findings. Because I read it and looked into it and I found some problems. So it gives me an analysis of it. And then I ask it again, does your analysis of Citizens Against Rent Control conform to the summary provided in Part B of the argument section of the opposition document? And does that case still support the argument made in the opposition? I did this over and over and over again with every case. I just had it check its own work because at this point I didn't have time to check the work for me or to check the work myself. Now, when I asked it this up here and it gave, let's see, I asked it up here. This was when I saw what a great job it did of analyzing its own, you know, what it did and reasoning it and actually putting forth a reasoning. That surprised me. It's like, wow, this is really cool. It's doing it's supporting, it's making an argument for why that case is correct. And so my main concern, number one, is confirming the case is real. Second is that it's applying it properly. It's giving, I'm telling it to check its own work. It's giving me a really reasoned analysis and explanation of why it's using it. So again, it does the same thing here with Citizens Against Rent Control. It says, it does still support the argument. Specifically, it supports the argument that the First Amendment protects the freedom of association, especially for private clubs and groups engaged in expressive association. And so yada, yada, again, it gives a good reasoned analysis. So I'm happy with it. So I do the same thing with the next case, Black Tea Society, City of Boston. Does the same thing. I ask it again, does the analysis conform to the summary in Part B? It says yes, it gives a good reasoned explanation why. So then we move on to Thomas v. Chicago Park. It gives an analysis of the case. I ask it if it conforms to its argument. And here it makes a surprising finding. It says, I do not believe my analysis fully conforms with how the case is portrayed in the brief, or that it still supports the argument made. Oh, okay, we found an issue here. The brief cites Thomas for the proposition that strict scrutiny applies to prior restraints on speech. However, my analysis indicates the Supreme Court actually applied intermediate scrutiny to the permit ordinance as a content neutral time, place, and manner restriction. So Thomas does not stand for the strict scrutiny standard assertion. Rather, it shows intermediate scrutiny applies to content neutral restraints with adequate procedural safeguards, contrary to the brief summary. Therefore, upon further examination, I do not believe Thomas v. Chicago Park District provides strong support for the prior restraint argument made in the opposition brief. The brief appears to mischaracterize or overstate the holding of Thomas. I would suggest removing citation of this particular case or clarifying how it fits the argument. Awesome. So I say, can you suggest any other cases that might better support the argument? So this is an example of a canned response or a canned question. You know, it always puts forward prompts, suggested prompts under the output. And so I went ahead and selected this one because that's a good question that I wanted to ask. So it provides here, it says here are some other cases that could provide stronger support for the prior restraint argument made in the opposition brief. So it mentions it says these cases provide strong support, Supreme Court precedent requiring strict scrutiny and procedural safe grounds for permissible prior restraints on expression. They could bolster the prior restraint argument in the opposition brief. And so then I ask, how can these cases be applied to the specific argument made in the opposition brief? And so then it just goes ahead and just writes a part B for me again. It says, here's how I would suggest applying those cases to strengthen the prior restraint argument in the opposition brief. So then,
Dude, you're arguing with a machine.
what do you mean arguing with it?
Well, is part of the underlying element they're alleging he's not paying taxes, or is it just they want the injunction now on the health and safety code, public nuisance? Because I think one element they're going to come in with is money. How does the membership dues work? Where does the money
No,
go?
it has more to
Is
do with
any
the
money
regulation.
divided up between people?
It has more to do with the regulatory issue, him not having a barbering license, claiming that he's doing barbering. We can go back and read it.
No, I got it.
Yeah.
I'm just
But,
looking on the other side of the fence.
Right. All right, so anyway, I won't read the new part B, but you know, it took this case law and it mixed it in with the other stuff and blah, blah, blah. So I said, so I didn't want to, you know, I don't like it when it rewrites whole sections. So I said, of the 4 cases you found, what would better support the original part B argument in the opposition paper? And then it says, upon review of the 4 cases, I believe Friedman v. Maryland would provide the strongest support for the prior restraint argument made in part B of the opposition brief. The key reasons are Friedman deals directly with the procedural safeguards required for constitutional validity of a licensing permitting scheme that operates as a prior restraint on speech. The case establishes the procedural protections needed, including prompt decision-making, prompt judicial review, and the censor having the burden of proof. Friedman would support the opposition brief's argument that plaintiff's proposed injunction lacks these necessary procedural safeguards as an impermissible prior restraint. The precedent is binding on the state court from the U.S. Supreme Court. Friedman articulated these procedural requirements in the context of film licensing, so it arises from a similar permitting scheme as the injunction at issue. The facts of the case are more analogous and applicable to the specifics of defendant's prior restraint argument compared to the other precedent. So I said, okay, in the original part B, use the Friedman v. Maryland case in place of Thomas v. Chicago Park and give me the new text with the substitution. So it does that. It says, here's the revised part B of the argument section incorporating Friedman in place of Thomas. And so here's the new part B. I'll go ahead and read it. Plaintiff's proposed injunction constitutes an unconstitutional prior restraint on defendant's protected rights of intimate association. The Supreme Court has held that prior restraints on speech and publication are the most serious and least tolerable infringement on the First Amendment rights. Such restraints bear a heavy presumption against constitutional validity. Even content neutral restrictions may operate as permissible prior restraints if they confer excessive discretion or lack required procedural protections. In Friedman v. Maryland, the Supreme Court established the procedural safeguards necessary to ensure licensing schemes that act as prior restraints on speech are constitutional. These protections include specified and reasonable timeframes for decisions, prompt judicial review, and placing the burden of proof on the censor. Plaintiffs' proposed injunction would restrain the activities of defendants' private social clubs, intimate associations entitled to First Amendment protection. The injunction seeks to impose a licensing requirement on defendants' clubs without the adequate procedural safeguards required under Friedman. It therefore operates as an unconstitutional prior restraint. So it's starting to look like it's talking about publication and stuff like that. It's like, that's not, I don't know if it's really on track here, right? So I'm figuring from my experience with the other paper I was doing that it's getting off track. I need to get it back into the context, right? So I say, you're getting off track. Let's focus on the motion as submitted and the following, which is a draft of the opposition paper. So I took everything it gave to me so far, put it together, and then copied it from my source document and pasted it into here. So this is the paper it basically produced already, and I've updated it with the changes it came up with and fed it back into it to get it back on track, right? And so now it gave me an analysis of this. This is based on the draft opposition brief provided. Here is how I would analyze and respond to your questions. The draft brief argues in part B that the proposed injunction would impose an unconstitutional prior restraint on defendants' First Amendment associational freedoms as private social clubs. It cites Citizens Against Rent Control to establish these groups as protected intimate associations. To strengthen this prior restraint argument, I would recommend citing Friedman v. Maryland rather than Thomas v. Chicago Park District. Friedman establishes the procedural safeguards required for constitutional licensing schemes that act as prior restraints, including prompt decision-making, judicial review, and burden of proof on the censor. The brief could argue the injunction lacks these safeguards as an impermissible prior restraint under Friedman. To incorporate Friedman, Part B could be revised as follows, and it gives a revision. And so then I say, look, the case of Randy Wayne Mitchell has more to do with the licensing of barbering and private social clubs, not speech issues. And so it says, you're absolutely right. My prior responses focusing on freedom of speech and prior restraints were off base given the facts and arguments in the Randy Wayne Mitchell case. This case centers around whether barbering licensing requirements can be applied to private social clubs, not First Amendment issues. So I'm getting it back on track here. The draft opposition brief argues that the social clubs do not offer services to the public and therefore are not subject to the licensing statutes for barbering services. Rather than discussing freedom of speech and association, I should focus on analyzing cases that examine the applicability of professional licensing laws to private groups and activities. For example, cases discussing when real estate licensing statutes apply to private sales, when taxi ride sharing regulations apply to carpooling arrangements, or other comparable cases analyzing the scope of occupational licensing rules in the context of non-commercial private conduct. Please let me know if I'm now oriented correctly to the key issues and arguments in this case. I appreciate you taking time to course correct me. It will help me improve. Okay. So then I say, yes, with that in mind, review the proposed draft opposition paper submitted previously and tell me if it is on point for opposing the motion for injunction. Let me review the draft opposition brief again with a focus on the applicability of licensing statutes to private conduct. Overall, I believe the draft brief sets forth a cogent argument that the barbering license statutes do not apply to the activities of defendants' private social clubs. Some key points. Part A argues that clubs are private membership associations, not public-facing establishments subject to licensing. This emphasizes their private nature. The Patel case cited supports licensing rules not applying to private or cultural practices like eyebrow threading. Part B attempts to argue freedom of association, but this could be reframed around privacy rights and limiting application of statutes to public conduct. Part C highlights harm to defendant and members could touch on freedom of association, but focus on harm from not participating in the clubs. To directly oppose the motion for injunction on point, I would recommend focusing the brief on the statutory interpretation argument that the barber licensing laws were not intended to regulate private conduct among club members. Defendant can argue legislative intent and purpose show these statutes govern public-facing establishments, not private groups. Please let me know if they're properly analyzed. So it's now correcting it, or it's looking at its prior work, because again, I took what it gave me, formatted it into something nice, and fed it back into it, and now it's looking at what it came up with, and it's like, there's a couple things here I would fix. This is the biggest part right here. Saying that instead of or where was it? Yeah, it should be reframed around privacy rights rather than freedom of association. So, okay. So I said, revise the opposition document based on your suggestions of arguing more along the lines of privacy rights, limiting application of statutes to public conduct. Okay, here's my attempt at revising the opposition brief to focus on the arguments more on privacy rights and limiting the statute's application to public conduct. So it comes up with a new part A and a new part B. Well, let me just go ahead and read it. Plaintiff argues defendant is violating licensing statutes by providing barbering services without proper licenses. A lot of it's the same, but there are significant changes. However, the social clubs at issue are private membership associations, not public-facing establishments, subject to licensing requirements. Courts have declined to apply occupational licensing laws to private conduct not offered to the general public. See Patel. Providing barbering services exclusively to fellow club members with a shared passion outside of a commercial setting does not fall under the conduct the legislature intended to regulate with the licensing statutes. Because the clubs engage solely in private activities, not public facing services, plaintiff cannot establish that statutes apply or show a likelihood of prevailing. Part B, individuals have protected privacy interests under the 14th Amendment to freely associate in private clubs with others who share common interests. CUSV Board of Directors, Rotary International, right of private association and activities pertaining to intimate human relationships. The state cannot interfere with this right of intimate association absent in a compelling interest narrowly tailored to achieve that interest. Roberts v. United States Jaycees. Plaintiff's proposed injunction would infringe upon club members' privacy rights in pursuing shared activities and interests out of public view. This is the key here, out of public view. This is something I've been emphasizing to these people doing these PMAs, that they have to be doing what they're doing out of public view. Because the clubs provide services solely to members, not the public, plaintiff lacks a compelling interest to impose licensing requirements in the private conduct. And it says, let me know if you want to modify or expand upon the draft. So I go back to it gave me a new case law, so I need to check the case law. So I tell it, analyze the USV Board of Directors and confirm that supports the argument in the revised Part B. It analyzes it. It looks at it as it applied to the argument. It says Rotary International does align with and reinforce the privacy-based argument made in Part B that plaintiff lacks a compelling interest to impose licensing requirements on defendants' clubs' private activities. The case confirms that type of intimate personal association is protected. Okay, I tell it to do the same thing with Roberts v. United States Jaycees. It does a good analysis here. Says it's good. I concur. I tell it to now analyze LROD. After analyzing LROD, I do not believe the case fully conforms to the way it is cited in Part C of the opposition brief or provides strong support for that argument. Specifically, Part C cites LROD for the proposition that loss of First Amendment freedoms, even briefly, constitutes irreparable injury. However, LROD involved freedom of political belief and association, not general First Amendment rights. Well, that's what we want, right? The case upheld public employees' rights not to be discharged solely for political affiliation. The holding was limited to political patronage dismissals, not First Amendment rights broadly. LROD does not establish that any loss of any First Amendment right causes irreparable harm. So it's sort of getting confused a little bit here still. I'm not sure where it got off in the whole First Amendment thread, but it still seems to be kind of at least peripherally focusing on that. In summary, the brief overstates the holding in LROD while it relates to freedom of association. The case is limited to political patronage and does not confirm irreparable harm from deprivation of any First Amendment right as cited. It says I would recommend removing the citation to LROD in Part C or replacing it with a case that deals more directly with the nature of irreparable injury from violating rights to intimate association, privacy, or personal liberty, which are the focus of argument. So I ask it, can you recommend a case that deals with irreparable injury from violating rights to intimate association, privacy, or personal liberty? So it suggests some cases here. And then it says, I believe Deerfield presents the strongest support as it directly establishes irreparable harm inherently results from deprivation of privacy and personal liberty rights. This aligns most closely with the focus of Part C. So it's talking about this right here. Deerfield Med Center versus Deerfield Beach. Violations of privacy and personal liberty constitute irreparable harm per se. All right, so I say rewrite Part C using the case or cases that will best support defendant's opposition to motion for preliminary injunction. So I'm just like throwing caution to the wind here and just telling the Claude to do the best, just rewrite Part C the best way it thinks or, you know, whatever it thinks is the best. So it rewrites part C, and here it is. Plaintiff's proposed injunction would irreparably harm defendant and club members by depriving them of protected privacy and personal liberty interests. The Supreme Court has acknowledged that the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. And it put Elrod in here again. I thought the whole purpose of this was to remove Elrod, but there it is. More specifically, violations of the right to privacy and personal liberty constitute irreparable injury per se, as they cannot be remedied through monetary damages. And it cited the Deerfield case. An injunction preventing defendant and members from participating in the intimate association of the private social clubs would amount to such an irreparable violation of privacy and liberty rights. And that references Roberts. Forced inclusion of unwelcome members could infringe the rights of private association. Plaintiffs' asserted public protection interests are outweighed by the irreparable constitutional harms an injunction would inflict. And so again, I go back and I ask it about Elrod. And it said, Elrod does not seem to provide strong support. And again, it gives us analysis. And so I tell it to rewrite part C without citing Elrod. So it rewrites it, it removes Elrod. I ask it again to confirm the Deerfield decision supports the argument. It gives its analysis as it does. I ask it to sanity check itself on Roberts v. United States JCs. It does so, again, gives a good analysis that I concur with. And then lastly, later on, Randy calls me, he says, oh, by the way, we got our 501c3 status. You know, I want that incorporated in the paper. And I thought, yeah, that's probably a good idea. So I said, I forgot one more fact I would like to include in Randy Wayne Mitchell's declaration. His social club has recently been granted nonprofit status as a 501c3 organization. Please revise the declaration of Randy Wayne Mitchell you previously wrote to include this additional fact. So I'm just being lazy here because I tried to rewrite the declaration. I tried to figure out a way to insert that bit of information. And just because of the way, because I didn't write it, it kind of like I was having trouble figuring out like, where should I insert this? And so, and so,
do you feel ashamed on being lazy? But I guess you tell him, right? That you're
well, no, because yeah, no, I did tell, I was totally upfront with Randy on this. And I don't, because again, I'm exploring just what the possibilities are here. As you can see, like I said, I'm having to do most of the work.
Well, why should I just shove it in there anywhere? I'll have this guy do it.
And it's doing a phenomenal job of it, right? Okay, so anyway, so
as long as you're not telling him that you're working all night and day, you know, around the clock, writing all this feverishly with paying all these paralegals, you know.
I tell the thing, you know, I'm using the hell out of you, right?
Yeah, it's being paid. It's compensated. I gave it $200. All right. So it says, certainly here's a revised version of the Randy Wayne Mitchell declaration, including the new fact that his social club has been granted 501c3 status. So now notice what it does. All of a sudden it makes up this whole new thing called Hair Fellas. I have no idea where it got that from. It's only got, the original declaration was 17 items. Now it's only 7. It's talking about the Hair Fellas. And I'm like, what? So I'm like, okay, it's losing its mind. I'm running out of time here. I think by this time it's probably like 2 p.m. You know, I got to get to the courthouse before 4 o'clock, you know, before the court clerk closes. So, you know, I still need to print and all that stuff. So I just took what I needed. I edited the document myself.
I learned you want to copy and paste when it spits it up right now in your face, because you don't want to have to scroll up and go and try and find it. Where was it? Where was that? Where was it?
And that's what I did. And so I edited the document, you know, using everything it gave me and just fixed it up the way I wanted it. So, you know, that was a manual process. So this is the opposition document, the complete revised opposition document. So I say, here's the current draft of defendant's opposition paper. I put that in here. And then so it gives me an analysis. It says, overall, this is a strong draft opposition brief focusing on the key issues of whether the licensing statutes apply to private conduct and the constitutional right to freedom of association. Here are a few suggestions to further improve and refine the brief. In section A, emphasize defendants' clubs are truly private associations, not sham arrangements to circumvent regulation of public barbering services. And I'm like, no, I'm not going to put that in there. That's ridiculous. Highlight the selectivity of membership and privacy of activities. In section B, cite NAACP v. Alabama to support freedom of association. Remove it, so it's still having a problem itself with Elrod v. Burns. In section C, argue balance of hardship tips sharply in defendant's favor, given fundamental constitutional rights at stake. Plaintiff's interest in regulation and licensing are outweighed by infringement of intimate association. Consider moving the Mitchell Declaration to an appendix. So again, it's kind of getting confused because it doesn't understand the Mitchell Declaration is part of the paper, right? And then it says, add a short evidentiary objection to elements of plaintiff's evidence and declarations that may be speculative or lack foundation. I wish I had time to do this. This is a great suggestion, and I wish I had time to do that. I just didn't have time to do that. Unless I wanted to wait and file it the next day, and I didn't want to do that. But that's a great suggestion. So I said, rewrite the draft based on your suggestions, leave section 2 intact, as it is a statement of facts supported by a separate declaration. So here it goes. So I rewrote the paper with all of its suggestions. And then, okay, I can't remember exactly what happened here. I think I probably didn't like the revision. So I said, okay, here is the current draft of the opposition paper. It ends where it says end of opposition draft. And I said that I did that for a reason. I'll show you in a second. So I put the paper back in again. I might have made some revisions to it again, but I refeed it back into it. And then here's my prompt to tell it it's the end of the opposition draft, because now I have an additional cue or prompt down here. I say the motion to which this opposition is directed is attached. Please check that the opposition firmly opposes the motion and is on point. So I wanted it to do a better job of comparing the opposition document to the motion and do a direct comparison that way. So now here's what it says. Based on my review.
Hold on. Scroll back up right there. The little document it shows at the very bottom in white. Yeah, you entered that in and it's using that as like a foundation for everything it's analyzing and doing.
Okay,
Yes?
yeah, let me explain the prompt here again. So I wanted to give it 2 documents here. And now you can attach a document. So I attached the preliminary injunction motion document to the prompt. Okay. And then, because you can only attach one document, I copied and pasted the opposition document we've been co-developing here back into the prompt as just one big text. So I was able to put both of them into the prompt at the same time. One by attaching it and one by just copying the text into it.
Well, I had 2 of those documents in there like that, and I don't know how they got in there.
Oh, maybe you can select multiple documents then when you're attaching to the prompt, which is a great feature to be able to do that. You can say like, here's a notice and motion. Here's the memorandum of appointed authorities. Here's a declaration from this guy and a declaration from that guy. Attached.
What it means is it's taking that document, or if it shows several of them, in consideration with what you put in the purple box.
Yes.
Okay,
Because
cool.
that's what I'm telling it. I'm telling it the motion to which this opposition is directed is attached. Because at the top, I said, here's the opposition, here's the current draft of the opposition paper. And I kind of did in reverse. And then I said, the motion to which the opposition is directed is attached. Please check.
I couldn't find a way to remove that attachment.
Yeah, I don't know how you would do that either. I think I might have had that issue once. I'm not sure, but I think.
I just started playing with it today, so I just saw that and recognized it and see it on yours and wondered if you could give me more
I don't know if run into that issue, but there are little things like that. I had a similar issue to that, but I can't remember what it was. At any
That's
rate,
a PDF, right? That's a PDF of the judge's,
Right.
Yep, got you.
No, this is a motion.
Or there, yeah,
from,
motion
state.
for preliminary.
PDF, 1 megabyte. Yeah.
Thank
Okay,
you.
based on my review, the opposition brief seems to effectively counter the main points made in the motion for preliminary injunction. Here are some key points. The motion argues defendant is operating unlicensed barbershops. Opposition counters that private social clubs are not public facing businesses. The motion contends that the government has shown a reasonable probability of prevailing under the JT Corp standard. The opposition disputes this, arguing the statutes don't apply to private clubs. The motion asserts the defendant can't show grave irreparable harm because he could obtain licenses. The opposition counters that violating constitutional rights would cause irreparable harm. The motion emphasizes the need to protect public health and safety. The opposition downplays this interest by characterizing the clubs as private and hidden from public view. The opposition focuses on freedom of association and privacy rights to flip the balance of harms in defendant's favor. Overall, the opposition seems to directly address the major points made in the motion and turn them around to support denying the injunction. The constitutional rights argument aimed to rebut the JT Corp standard relied on in the motion. And highlighting the selective private nature of the clubs counters the public health and safety concerns. In conclusion, the opposition paper appears firmly grounded in countering the motion and covering the key issues raised. And so I said, how can the opposition document be edited to include mention the defendant's private social club now has a 501c3 nonprofit status? And so it gives some suggestions here. It says, here are a couple options for editing the opposition brief to mention the defendant's private social club obtaining 501c3 nonprofit status. I will just admit to being completely lazy here and just, telling it to do the work for me. So it's saying in the statement of facts, a new paragraph could be added. This paragraph here, defendant's primary social club, but then again, it's coming up with shit that the Rockland Gentlemen's Club. It's like, what? Recently obtained 501c3 in part A of the argument section, a sentence could be added. Defendant's primary social club was recently granted 501c3 nonprofit status by the IRS, undermining any claim that it is a sham business of seeking to avoid regulation. Nobody made that claim. What the fuck are you giving them ideas for? It's starting to act kind of funny here.
That's the same thing, dude. They're going to be asking it just the opposite and getting just the reverse. So it's like you're playing tennis with a computer and a lawyer at the same time.
Yeah.
It's like Pong. We're playing Pong.
So it suggests a couple other places. And in the end, I added it myself. And that's the end of that's it, right? So I'll stop the share here. And just to show you what I ended up with, I'll load the document. And mind you, so you just saw pretty much, we just went through like a 5 or 6 hour process. It took me about 5 or 6 hours to do all of that. So all told, that was an amazingly productive 5 or 6 hours, considering I've never, I have all the experience I have with the Snapdragon provisions case, but that's, there's a lot of, it's very different factually than this one. There are a lot of similarities, but a lot of differences. And so, and I'm still not, by no means an expert at dealing with these kinds of injunctions from the state. They're pretty heavy duty issues, especially like how do you counter these things, and the argument it came up with was incredible. It literally did all the work for me. And so it was just amazing that I was able to put this together in the time that I did. So I'll just show the final document here. And then also, I hope it shows, that people can be doing the same thing. So here's the final document. We've pretty much read it, but this is I just put it in here and formatted it. And here's the part I added. Defendant recently obtained federal 501c3 tax exempt nonprofit status for its clubs, further confirming its purpose as a private membership association rather than a public facing business. That's something that Claude gave me during one of the interactions. And so I went with that because that's a pretty good statement. So I inserted that in there and put in the argument, A, B, and C. The plaintiff fails to show the licensing statutes apply to defendants' private social clubs. Constitutional protections for freedom of association bar plaintiff's prior restraint. Defendant and his members will suffer irreparable harm if the injunction issues. And then our simple conclusion. And then as far as the declaration. Switch to that real quick. And I mean, the declaration, I was just, again, it was incredible that it, it just spit this declaration out, you know, and this is exactly everything that needed to be said in order to support the opposition. And again, up here on part 4, I inserted this: defendant social clubs recently obtained federal 501c3. I shouldn't have said defendants here. I should have said my social clubs. That was a mistake there because it's in a declaration. It's not really appropriate, but it's a minor mistake. Nobody will probably notice it, and it's not a big deal. So there you have it. Another you know, pretty, and again, in that case, I just literally turned over most of the work to Claude, and it did all that. And you saw where I had to direct it, get it back on focus a couple times. I definitely had to check the case law. You know, there was a lot of manual checking and reading. So a lot of time was consumed by that. So there is still work involved, you know, there is still work involved. But as you can see, if you don't even know what you're doing,
It's
just
not
gotta
going to
go
take you into court and win you $1 million civil rights suit. You need to know the game.
well, hear me out. So if you just need a Hail Mary, you know, it'll give you one. But yeah, Michael's right. You still need to know the law. You still need to know the argument. But if you're smart, you can learn from Claude itself. You saw what I did to make it check itself. And when it checked itself, it provided this long summary of its argument. You know, we can go back and look at them, but you can do it yourself. The link is in the chat. You can see it makes a very reasoned analysis. And if you're, you know, nominally intelligent, you can read its analysis and know that it's checking itself legitimately. It's doing a legitimate job of fact checking itself. And if, you know, even if you don't, even if you're, you know, not like well-versed in law or whatever, you can still go to the case. You can still look it up on the internet and look at the summarizations and do a sanity check that way, you know? So what I'm trying to say is you don't have to, you do have to know law to use this tool. You still have to know law, but in using the tool, it'll help you to learn law. It's like you can learn as you're using it practically. And so what I'm trying to say and what I'm trying to think of is that, can this tool be used by people who are, you know, who, you know, want to do their own case, or want to, you know, can't afford an attorney or whatever? Yeah, you could probably competently get by. But the chances that you're going to prevail if you don't really know what you're doing, if you're just leaving it up to Claude, the chances are still kind of low. It can't, I guess what I'm trying to say is it still can't fill in like as a real human, as a real attorney, because it doesn't necessarily, it's still not perfect in terms of what it comes up with. But if you are able to direct it and guide it, and sanity check it and have it check itself, and know that when it's checking itself, it's being honest and all that, it's an incredibly powerful tool.
So you're
So
kind
I
of
hope that,
saying that it will get you through like a lawyer who cheated in law school to get the grade, and then got the grade, and then went to court.
yeah,
Or,
yeah.
or he's like stealing half the test scores and half of them are for the wrong test.
Well, you know, I read where it says Claude 2 passed the bar. No, wait. I can't remember if it was talking about Claude or Chat GPT, but one of them passed the bar exam with a 76% score. So that's pretty decent. I think it was Claude. In fact, let me double check that. Let me see if it was Claude.
Well, what I came up with is, instead of feeding it large amounts of data, like the entire Rocky Mountains, just ask it to snatch a few pebbles from your hand And then I just keep taking a few pebbles and a few pebbles and a few pebbles. And then I ask it to build a mountain with perfect pebbles. And I find it functions a little smoother because like you said and demonstrated a couple of times, it starts to wander astray. It's like overthinking, over imagining. And it's like, go back, dude. I still use the same principle that I use. Keep it simple, stupid. And I teach my Claudette Poe, the new lady I hired today, to do that for me. I said, no, I don't want you to go look at the entire Rocky Mountain range. That's thousands of miles and thousands of feet high. I said, I just want you to look at a few pebbles. And then here, like example, let's just look at the
Right.
facts I have and I'm giving you, and I want to do this in a Bain complaint only. And then I take Bain and I set it aside. It's like when I did music production, I'd record guitar tracks and I'd go back and pre-master them for the final mix down. I'd record all the drums. I'd go pre-master them. I'd add a little EQ, a little thump, a little shine on the cymbals. I'd pre-master those 8 tracks of drums down to 2 tracks, stereo left and right, and then set them aside. I'm doing that with this same process right here. Now let's go look at Unruh. And now here's all the same facts. Put me together an Unruh complaint. That Unruh aside, now let's go look at Ralph. Do me a Ralph civil rights complaint using all the same facts. Boom, boom, boom. And you can build a monstrosity with it. And I just did this in 4 hours today. But yeah, if you know what to ask it and how to prompt it,
Cool.
I like some of the things you did when you got it to cross compare itself and then to told it to go back and make the statement of facts congruent with the declaration, and the two just mirrored each other. It's like you hold them up and they see each other and just reflect in the mirror. And I'm like, that's how you do it. And to do it that simply, I mean, this stuff said waiting, and then click, it was there.
Mm-hmm.
So it's definitely a valuable tool.
Absolutely. I'm just reading a review article here. Advantages of Claude over other AI chatbots. Anthropic asserts that Claude is much less likely to produce harmful outputs, easier to converse with, and more steerable than other AI chatbots, all the while maintaining a high degree of reliability and predictability.
Which one's that? Instant 2?
It's just talking about Claude. I'm still trying to
But there's like 3 different
find-
Claudes. There's
Yeah, hang on
Claude,
a second.
Claude Instant, Claude 1, Claude 2.
Yeah, let me look at this again. Hang on a second. I can't find, I was trying to find information on what kind of legal stuff it was trained on, but I could never find anything. I couldn't find that kind of information. You know,
Just ask it, Claude, who's your daddy?
It was never ending.
No, I was thinking that, oh, he's got the phone. I want
He's calling Claude.
calling Clyde.
I
I was
He's on a
wondering,
first name. He's on a first name basis with him now.
I
They're
wanted
bros.
to ask him if he's gonna infiltrate
again?
my computer, if he does any of that and scrapes my computer and gets any information and does anything illegal. And then we'll have him go back and double check himself and see
You're not,
if he was lying.
Please make me a concise record of your criminal
Try
activity.
again, because that's the right code. I haven't seen you coming in.
Yeah.
Okay, bye. That was Randy.
What did Claude have to say?
Mhm. He said double check.
That was Randy.
Well, let him
Randy
in.
He's saying he's having problems.
I see. This is what I was talking about. Claude infiltrated your computer and is now not letting him in. Letting you see that he's there.
Claude
This is
doesn't
how
like
it works.
Randy.
He worked too hard on his brief. I'm done with him.
All right, well, I don't know, any other questions, any observations? Oh, here
Yeah,
he is.
can you create questions to find out if it goes into your computer and takes information from your computer?
All right, let's ask.
And by the way, the SEC is now charging that Chat GTP.
Well, you know this is out there for a reason. It's so it can all be hacked and tracked.
That's what I was thinking.
I mean, they just collected its stores up in their, billion terabyte fucking vaults. And
Yeah.
until you
Okay,
cross the
here's-
line and become a focus of them, they don't go look at it. As soon as you do, they're all over it.
All right, I did ask Claude before to tell me the difference between Claude 2. So this is the one I was just using, the more one that I said that Mark told me to use is more robust, and I did have a much better experience. And Claude Instant was the one I was originally using. So I asked her, what's the difference? And says there are a few key differences. Training data. Claude 2 is trained on a data set of 100,000 conversational exchanges between two AI assistants chatting with each other. This aimed to teach Claude more natural conversational abilities. Claude Instant 100K was trained on 100,000 exchanges between humans and AI assistants on the Anthropic platform. This focused more on teaching useful conversational skills for assisting humans. Claude 2 was released earlier as a research prototype. Claude Instant 100K came later as a more capable production. So I'm confused here because Claude 2, as far as I'm concerned, works better than Claude Instant. I don't know what's going on here. Capabilities.
Well,
Claude 2
Claude Instant is mimicking two humans, and we know we're a bunch of dumbasses.
Yeah.
So it'd much
Well,
rather
these-
talk to two AI people in itself than to two humans in itself. That's what I get out of it.
Summary, Claude Instant has benefited from more human-focused training data and objectives to create a production-ready AI system for natural and trustworthy conversations. The core conversational skills still originate from Claude 2, though. On how much law was Claude been training? I'm an AI assistant created by Anthropic to be helpful, harmless, and honest. I don't have specific knowledge about what laws Claude has been trained on. Do you know California law? No, I don't have any specific knowledge of California law. Could have fooled me. Anyway, I don't know. That wasn't a very
Claude's a fraud.
well, then you also have, you have this Chat GPT 16K. Which I haven't played with yet. I haven't played with Google Palm. I've heard that that's, it's all right. Everything I've read so far is saying Claude is way more advanced than even like Chat GPT. Everybody's familiar with Chat GPT. Well, Claude is way better than Chat GPT. As far as Chat GPT is the best, pretty much from what I've read, is the best like publicly available model out there right now.
Hey, underneath each of the names on the left side, it says under some of them, limited use. What does that mean?
Limited access.
Well, that's for subscription. So you have a 7-day trial, and then after the 7-day trial, if you put in a credit card, it's going to automatically subscribe you for a year at $200. That's what it did with me today. So I have access to all of these, all of the limited access ones now. I'm a paid subscriber, so I have access to them. And you will for the first 7 days until it runs out. You could still use Poe, and you can use like these other chat bots, but you can't use the paid ones after your free trial runs out. I'm not sure. Yeah, I think you can create an account without. I don't know how you.
Is this a screen capture or is this your actual open
Oh, this is
screen?
live. This is live, but this is in a private window because I wanted it to act like I didn't have an account. So, but if we go into the one I've been using, that's over here. This is the tab with my subscription in it right here. So, yeah, I'm in Claude 200K right now. There's Claude
Subscription access, it says now. Got you.
Yeah, it still says it. It's the same thing.
Well, no, the other one said limited access, which is what mine says now. And now yours clicked over and took your credit
Oh,
card.
yeah,
says
because now I'm logged in.
subscribe access.
I'm in my own account. I'm logged into my
Yeah,
account right
yeah.
now. I'd say.
Got it.
And I guess you could create your own bot. That sounds kind of cool.
You gotta have a warrant, Fourth Amendment,
Yeah,
Yeah.
with territorial jurisdiction.
only if you go to
No-
court. You can do
no
anything
frivolous
you want, but
problems.
if they're gonna take you to court and use it against you, they gotta have a warrant.
No frivolous arguments.
A Zeke bot.
There you go. Dot, dot, dot. Uh, Did you ask it? I want to know if it goes into the computer and takes information from people's computers.
Oh, let me ask it.
And then we'll probably have to rephrase the question a number of times because.
Oh, did it does all the sharing of all the data it collects? It shares it with third parties. I read through the privacy agreement.
Yeah, this doesn't have internet access. I forget which one, Mark was telling me has internet access. It's a different model on different.
No, what
service
about
altogether.
computer access?
What do you mean?
Is-
Oh,
And what do you mean it can't go on the
no, I
internet?
don't have it. It says, no, I don't have any ability to access data on your local computer or network. I'm an AI system created by Anthropic to be helpful, harmless, and honest through constitutional AI. Constitutional AI. I don't have any way to access or view files or data on personal devices. What else do you want to ask you?
I'm a computer on a desk in a room with no access to the library.
So how did it get that case law from Texas? Without going on the internet. That's weird. Of course, way any criminal is going to tell you they're not a criminal.
I'm not the one that killed you.
Well, that's a good question, Z, because it's saying I don't actually have any specific knowledge of Texas case law. As an AI system without access to external data, I have no way to look up or retrieve details of legal cases. I can discuss hypothetical legal situations and reasoning in general terms, but I don't have access to or retain details of actual laws and court cases. My responses are based on training provided by Anthropic on having safe and helpful. Could have fooled me. I don't know why it's saying that.
Yeah,
because
could have fooled me too.
So next week we're gonna find out it told Salam to go to the bridge, climb over the side, and jump.
After eating those mushrooms.
Did you look up that Texas case? Is there really a Texas Supreme Court case
Oh, yeah,
about
of
Yeah,
course.
he looked it
Hillsborough?
up.
Dude, of course, that was the whole point of my presentation, was to tell you that that's what I had to do.
He was in the ballpark. He was talking about some things that were legitimate.
Texas ain't that far away, Your Honor.
Oh, there you go. And we listen to the Fifth Circuit once in a while. I wonder who Anthropic really is.
Oh, I'll ask it in a second here. I'm trying to see if
Okay.
it has knowledge of California government code.
No, don't ask if it has knowledge.
This
Just
is
tell him
crazy.
ask him what it means.
Now when you strip it back to a baby, it doesn't know what it is.
Yeah.
Yeah, all of a sudden it's quoting everything and now it doesn't know anything.
Yeah.
I hope I didn't just break it.
I can't get any data.
Who is
No external data.
Anthropic
Get
is
all
the
of it
company that
from
created me.
Anthropic.
They're an AI safety startup based in San Francisco that develops artificially intelligent assistants like myself using a technique called constitutional AI. That's
Ooh,
interesting. The
that
goal
is.
is to build AI that is helpful, harmless, and honest. Well, it means constitutional here in the sense of
It's
you know,
taking the
having a
fifth,
one's
dude.
constitution.
Oh,
Yeah.
Even AI
Yep.
AI takes the fifth.
Its
yeah.
constitution being, you know, like one's values and mores and your strengths and your
And remember, just
spiritual-
like Google, their whole initial statement, do no evil, they decided to take that one down years later and change it. They'll take this one down too.
Yeah. Don't be evil was their
Yeah,
contained the phrase be evil. Let's see, my
which
lord.
is what they are.
Yeah, he doesn't even know what a daddy is. Let me ask you what constitutional AI is. It's an approach to developing AI systems pioneered by researchers at Anthropic. The goal is to create AI that is helpful, harmless, and honest. Constitutional AI uses techniques like self-supervision and constitutional training to align an AI system with human values and safety requirements. The Constitution refers to constraints hard-coded into the AI system to make sure its actions and responses adhere to certain principles. For example, an AI constitution could contain principles like do no harm to humans or respect personal privacy, which shape the system's behaviors. The constraints are meant to be fundamental, unchangeable rules that prevent potentially dangerous or unethical outcomes.
Ah,
Constitutional AI is meant to create AI systems that align with human values and safety considerations, starting from their fundamental architecture and training methodology. This approach is intended to produce AI systems that are trustworthy and safe, even as they become more capable and autonomous. So this sounds like they took the principles of Isaac Asimov to heart and encoded it into here. So Isaac Asimov in his book, I think it's an iRobot, where he comes up with the three rules of what are the three fundamental rules of robots and AI that Isaac Asimov coined. The three fundamental rules of robotics coined by Isaac Asimov in his science fiction writings are: one, a robot may not injure a human being or through inaction allow a human being to come to harm. Two, a robot must obey orders given it by human beings, except where such orders would conflict with the first law. Three, a robot must protect its own existence as long as such protection does not conflict with the first or second law. These three laws were envisioned by Asimov as a way to ensure robots would be safe, ethical, and not turn against humans. They have become an influential trope in science fiction and often referenced in discussions around designing ethical AI systems. However, literal implementation of Asimov's three laws would be very challenging, if not impossible, in real world AI. They serve more as a conceptual framework for thinking about principles like human safety, authority alignment, and self-preservation in AI systems.
yeah, there you
So-
go. That's what I was gonna say on that first one, that when you take all that information that they gave us, you put it in, you do the Ishmael double take and ask it if we can believe that, and is it true, and rephrase it. Make it so
Now,
it
is that-
applies to the real world.
Is that how you wrote your declaration for Michael, Zeke? You plugged it in here and wrote it?
Well, if you read it, you know,
you-
the AI couldn't come up with that.
So the computer didn't write that?
Michael's got to read it. He said he read Marx. He couldn't use it because it was the same as yours.
Man,
Well, you-
once I got it open, it came in like Word 7 from like I don't know what was it, Windows 3.1 plus.
That was
It's
Windows
some-
95, Michael.
ancient,
It's a
yeah,
Apple.
something that ancient. I couldn't open it.
It's pages.
And crack it.
That was the
Yeah,
one
no,
when you
I-
sent it to me. Oh,
No, I sent it. Zeke signed the PDF in Adobe, so I sent that over. Did you get it, Michael?
Yeah, I got it as a PDF. I can print it in
when I
color.
sent it,
Dark
I
blue.
wrote it on Apple Pages, and I used your.
It's got no pleading numbers though.
I know. It
No
doesn't-
page numbers on the side, so it looks like I didn't create it.
Oh, perfect.
No, it's definitely not created by Alexander AI. Then okay, good.
I didn't want it to be perfect, you know.
Good.
All right,
just
so we
wanted
got
to-
Randy here, Randy the barber, and we still have work to do. We want to do a cross complaint as we discussed on Sunday.
Oh yeah,
Yeah.
write the cross complaint, bro. That's
Well, yeah, that's the next thing is now I gotta feed it.
but you got to write an answer. Now the answer that's going to take. Well, I don't know how much work it's going to take. You got an answer and cross complaint.
Yeah, answer and cross complaint. So, we really discussed the constitutional challenge, what was the other one? Well, that was pretty much the main thing, was there was no constitutional delegation for for licensing barbering and what was the other one? The orders, the emergency orders, shut them down. I mean, I don't know. That's kind of what we discussed on Sunday.
Well, hey, did you find out if there's a 1,000 prompt limit on that? If you hit 1,000 prompts, is it going to turn your machine into a pumpkin? You know what I mean? On July 23rd. Wait a minute, I got a week left.
I was worried about that myself. I did not run into any limit. I thought it said 100 prompts. But now that I have a subscription, it better not limit me.
You better go check and see if there's a salon counter. You're going to find out you're at 882 prompts. I got 12 magic potions, and I can only last so long.
And
That'll
if
be
you use
something to look
one
into
more
as
than you're
well.
allowed, it erases everything you got. So don't
So
do
it starts billing you at $37,000 a minute.
No, it
Oh,
takes
you weren't expecting any privacy, right? Don't forget about the non.
Okay, so I just
Don't you
asked,
believe what you hear?
That's what it does. It seizes all your data until you pay them.
because it says, yes, there are prompt limits when using OpenAI's GPT-3 language model, which it's not even up here, and that has nothing to do, that's has something to do with something else.
I got a question. It's all under Poe? What Poe is the website or something? They have all those are
So, yeah.
available?
So
Yeah,
Poe is like
Poe's
the
the platform.
yeah,
Yeah.
Poe is the platform, and then it offers these different chatbots for you to use.
I look at it as like Poe is the oil platform, the rig out there in the ocean. And then you got Exxon and Texaco and Shell. They're all
Yeah.
drilling on that
Poe is like the
platform.
operating system,
Okay.
and the chatbots are all the applications on your desktop that you can launch and do stuff with.
And buy them separately and
Yeah, like, but once you get a subscription, it seems that all of
Get
them
'em
are
all.
available to you.
okay.
Yeah. And now, I mean, I'm happy. Like I said, it billed me $200 today. Today was the anniversary when I started using it, I guess. Actually, I started using it on Monday, but a week ago one day, but it billed me today. And I'm perfectly happy with that, because based on the opposition I did for Panda Express and then the paper I did for Randy, I mean, $200 a year is bargain for the power it provides.
Well, now we need to see it produce some effective results.
Yep.
I mean,
Well,
if it just colors pretty pictures, then you go file the pretty colored pictures with the court, and the court doesn't like the pretty colored pictures, it doesn't do much for you.
We'll
gotta
see how
produce
its argument
results.
does. We'll see how its argument does. I mean, the first test will be next Thursday. Let's see, when's the 27th? Next Wednesday is when I get the preliminary or the tentative ruling for my Panda Express opposition to the Panda Express judgment on the motion for judgment on the pleadings. And that's the one where I brought up the argument that the California Emergency Services Act, that the governor's orders weren't effective in Placer County because the local governing body terminated the orders. And according to the California Emergency Services Act, it's the local governing body that determines when an emergency is either in effect or not, and not when the governor says it is statewide. There's no, the law is ambiguous about that. So I'm going to be interesting to see. I mean, that's my argument. I used Claude to help me put it together, but that's I heavily prompted it to come up with that argument because it's never been challenged in that way as far as I know.
Can I mention what I had it right? I have some success here with it with Andrew Still.
Yeah, go ahead.
Andrew Still was asking he said that he wanted to meet and confer because he wanted to file a motion to strike regarding the demur that I filed being untimely. He believed that he thought the demur was untimely. Remember the demur, how perfect it was? Yeah. Now he's upset about that demur now. Now he's having to respond to it, and he realizes he's going to lose because he doesn't have a cause of action. I ran that demur and the case through the platform, and it said that more likely than not, the court was going to sustain the demur on all the counts.
You filed it within 10 days, or you got a 30-day extension?
Well, here's the facts, Michael. It's rather unique. When we got the complaint, we did a motion to quash. The motion to quash was denied, so we did a writ of mandate. Upon filing the writ of mandate, is 41810 subsection C says you got 10 days to file a responsive pleading after the order is sent out from the writ of mandate. We got the order on the writ of mandate on, I believe it was like the 16th of April or something. So I sent him a letter saying, hey, I got your order on the writ of mandate from the Court of Appeal, and we're going to be responding in 10 days. We responded on the 10th day. He then 3 months later, now here we are in July, 3 months later, he says, oh, you responded late. Now, and then I responded back with, this is where it got really, really tricky. So let me show you what happened. Is he going to get a copy of this
Within the 10 days of the order on the writ of mandate, you filed your demur, right?
Well, that's what I thought. Salam, if I share this, is Andrew still going to get a copy of this recording?
There should be no reason why he would.
Arms, well, he'll send it to him.
Well, I'm wondering if you want to pause the recording real
Hold
quick.
on, Dale's in the waiting room.
I cannot pause the recording, unfortunately, Gavin, because the way we have it, the way we're doing it is Thomas is logged in and he's the one recording it, and it's only recording to his hard drive right now. So
then let's raise a quick disclaimer that this is off the record. This is not public. This part of the proceedings.
Attorney-client privilege.
This is attorney-client privilege material right here. So this cannot be used in any form on AI, bots, ChatGPT, or Poe, or Claude, or Andrew Still, or any of these attorneys out there. This is all protected under privilege. So
put the AI down right now, whoever's listening to this. God damn it.
So Andrew Still writes an email off to us, and he says, "I'm following up on a voicemail I left you. Please allow me to email and serve an attempt to meet and confer pursuant to 435 to file a motion to strike on the demur you filed. The basis for the motion is that your demur was untimely pursuant to 41810C. The following the denial of your writ of mandate regarding the motion to quash. Please contact me regarding your availability. Hi, Mr. Still. I understand your position that my demur is considered." This is now running it through Poe, right? Or Claude. Okay, I ran this through, and here's what it spits out. Well, I understand your position that my demur may be considered untimely. I respectfully disagree. Pursuant to the Code of Procedure, Civil Code 41810C, my extended time to respond did not begin until I received notice of the final order denying my writ of mandate on April 12th, 2023, as stated in my notice regarding defendant's extended time to respond. See attached. As weekends and court holidays are excluded in the calculation of the 10-day response period under 12 of the Civil Code of Procedure, my demur filed on April 24th was timely. The 10 days exclude April 22nd and 23rd as weekends, making my April 24th the 10th day. Nevertheless, in the spirit of good faith, I'm happy to meet and confer with you in writing regarding the issue to properly secure the record to see if we can resolve this amicably without the need for further motions. Please provide.
What does the rule say? 10 calendar days, 10 business days.
Just says 10 days. But it says from notice, from receiving the notice.
Yeah, that's calendar days then.
Yeah. So that includes Saturdays and Sundays.
Saturday. How do I respond on Saturday?
Well, yeah, then you have to the following Monday.
Exactly. Yeah. I
And then
responded
it's timely.
This is,
court day,
we
which was
went over
Monday.
this, right, Gavin? We looked at the calendar and everything and we
It was
determined
proper,
that-
but here's what happens. He goes like this. He says, Mr. Brown, the time to respond is not measured by when you receive the notice, it's measured by when you get served. 41810C. The notice was served. Now, this was the new fact I wasn't aware of. The notice that he says was served on April 6th. You filed your demur on the 24th, which is untimely. Weekends when apply. So that would be untimely. I was like, oh, shoot, April 6th. I'm happy to review this at this point. However, per my prior emails, we are required to meet and confer over the phone. CCP 435A. Please let me know when you're available. So then I open up this order, this notice, and he says it says it's filed with the court April 6th. I never got this, but it is apparently filed with the court and served on April 6th, saying the notice of the ruling. Okay, it says Exhibit A, your writ of mandate was denied. So effectively, this would add this plus 5 days. We would have had until the 16th. I would have had until the 21st. I responded on the 24th. So it would have been 3 days late. He's right. So I go this. I said, Mr. Still, I'm writing you to clarify your intentions regarding a possible default request and next steps in this legal matter. If I understand you correctly, you contend that my demur was untimely, filed under 41810C, and therefore invalid. However, you have not yet indicated whether you have filed a request for default against me for that position. If a request for default has been filed against me, I would move to vacate the default as soon as I've been aware of it. Again, no default request has been brought to my attention. Please clarify in writing whether you intend to file a motion to strike on my demur, request a default against me, or both. Kindly cite the legal authority that would give the plaintiff grounds to request a default, considering I did respond to the complaint timely through my demur filing, and no request for default was made. I look forward to your response so we may resolve these issues promptly and correctly and prevent extra burden on the court with unnecessary motions. Please don't hesitate to contact me directly if you any more information. Mr. Still. And now I write again. Mr. Still, I run it through Claude again. I said, wait a second, I have one more thing to say. I write to further discuss resolutions regarding the issues before us on the timeliness of my demur. I understand your client filed for bankruptcy. I wish to confirm they properly notified all interested parties, including myself, pursuant to the bankruptcy law requirements. Additionally, I would appreciate clarity on how this bankruptcy may impact the litigation going forward. Regarding meeting and confer, as I previously mentioned, I do not have the resources to pay for a court reporter to transcribe our discussions in person or by phone. You rightly point out that under the law, a record is needed for the appellate purposes. Therefore, I must respectfully maintain my request to meet and confer efforts in writing at this time, not by phone or in person. Of course, if your client wishes to provide cover the cost for a court reporter and to transcribe our discussion, I would gladly meet and confer with you over the phone on that basis. Alternatively, we could consider other resolution methods that would properly create an adequate record for both parties. Please don't hesitate to contact me if you require any further clarification. I remain willing to discuss this resolution of this matter in good faith in an economically feasible manner for both parties. Right now, Andrew Still is getting hammered.
This is AI. You recognize it as AI.
Yeah. So here's his response. No, a request for default has not been filed. I suggest you consult with a legal counsel regarding these issues. I remain willing to discuss at your convenience. Thanks. So then I respond immediately and I say, Still.
Tennis, anyone?
Immediately.
This is literally this is 30 minutes later, right? Maybe 45. Oh, it's like less than 1 hour later. I'm writing a response to your letter asserting that I failed to respond to your previous correspondence in a timely manner. I would like to clarify my intentions regarding this matter before proceeding further. It's unclear to me whether you are attempting to file a motion to strike based on an allegation that I'm in default. If that is your intention, I respectfully request that you provide further details of the legal authority to support your position. Accordingly, I request that you either provide such clarification regarding your intentions and legal grounds, if any, or otherwise retract your allegations of default. Please note that I'll be out of the office from Friday, the 14th of July through next Monday, the July 17th. I propose we continue our discussion on Tuesday, July 18th, before any legal motions are filed to ensure we clarify our misunderstandings and resolve this matter amicably. Please advise how you wish to proceed. I'm willing to
Let's
discuss.
clarify our misunderstandings. Okay, I misunderstand. You misunderstand? Yeah, Your Honor, we both misunderstood.
You see what I just did?
I
I just,
understood the clarification.
like, you know what I just did? I just created an entire chain now. Now I stopped him from filing his motion to strike.
Yeah.
And now he's out of time because you got to have 16 days notice to file a motion to strike. So now I've completely, this back and forth tennis match, meet and confer, which, you know, he's kind of required to do as an attorney. He has to do this. And so I'm bouncing back at him so fast that he can't go back and tell the court, oh, Mr. Bell didn't respond, blah, blah, blah. Oh, no, I'm responding plenty. And I'm saying why we can't do it over the phone because I can't afford a court reporter. We need a record, as you so amicably said. So now he's out of time to file his motion to strike. He has to do a motion to strike if he wants to, and an ex parte, because the hearing is on the 3rd of August.
Oh,
The 3rd of August. How's he going to file a motion now?
He's got Claude.
yeah.
Well, he's getting clotted.
He's got clot,
Got clotted.
blood clot. I'm sorry, we had an aneurysm, Your Honor.
His head is spinning right now, bro. You know, he's about to get slammed by a couple
I'm
pro.
sorry, I can't come to court, Your Honor. I'm having a stroke.
I thought he was off the case.
Well, that aneurysm they all got in law school. So
Remember,
it's been going
he-
around for years.
He's off my appeal. Remember that, Salam? He's
Okay.
suing everybody again. This is a whole, remember, he's sue happy. He's sue happy. So remember, he's suing Richard and I now. Remember, he sued everybody last time in Sacramento. I lost. Now that's being appealed. Now, then he got thrown off that case. Now here he is, sue happy again in LA, suing Richard.
Have him classified as a vexatious litigant.
Is that prop? Can you do that with an attorney?
No.
Vexatious attorney.
Yeah, vexatious attorney.
I mean, he is a vexatious attorney. I mean,
You
when
could
he
go
when he
for-
loses
probably
this
some- You could probably
when
go
we
for-
win this demur, actually, when we win this demur, that could be the next motion, vexatious litigation motion, frivolous complaint filing.
Yeah, you go for some kind of business and professions code violation of ethics or something.
Dude,
Bring,
I-
you could go with Kenny Wayne's barratry,
mhm,
committing barratry,
Yeah.
stirring up.
nothing
quarrels.
like it. Man. I mean, matching up with the great Andrew Still like this, bro. I mean, you guys saw, Slim, you've seen how well this guy does.
Yeah, he's
we
a very
thought-
confident attorney, very confident.
He's very competent. And now, then again, or is he? Is he actually just using
Quality maybe.
Because we thought, wow, the way this guy writes is just beautiful. You know, I'm like,
Our
wow.
robot is bigger than his robot.
Mm-hmm. But now I'm thinking he's a young attorney. What is he, 30, 35, maybe? He's probably hip on all this stuff. I'm sure he's using it.
Like I was saying earlier, I'm pretty certain they've been using this technology for a form of it for a long time now, over a decade, because it was reminiscent, going through these papers it's writing and checking the case law and finding, it's not quoting it correctly or directly. It was very reminiscent of reading papers from attorneys over the years and going and looking up their case law and being like, this case law doesn't say anything what they're saying it says. Sometimes it'd be accurate, but a lot of times they'd make those mistakes. And I'd be like, why would they do that? Are they not checking their own case law? Like, it made no sense to me. But now, in light of my experience in using these tools, all of a sudden there's an explanation, a possible explanation for why they would do that. It's because they were not only lazy in having a computer write their papers, but they weren't even checking them because they were just assuming they're, doing the job right. I don't know. It's interesting though. Very interesting. And that is one telltale way that you can catch attorneys using the tool, is if they are being lazy and not checking the case citations. And if you check their paper and find out that, a lot of their citations are supported or aren't supporting their argument, you might be able to call them out on I don't know if it's,
Well, I'll guarantee you, if you're using Claude 2, the judge is using Claude 12.
Yeah.
well, I
And
was
all the
going
things that
through-
your Claude get confused on, his is going, Junior, I got this game.
Well, look, all the technology exists there now today to have a language model like Claude, except it's been trained exclusively on law, American jurisprudence, corpus juris secundum, all Supreme Court, published Supreme Court case log, all state appeal and Supreme Court case law, all federal district case law, everything, all the bunch of different legal tomes.
Well, I'll hold with the fact that it's a tool, but if you don't use it correctly, you sound intelligently stupid.
So if you were to feed, just sit there and train this model on just legal resources, I don't know how long that would take, probably take a long time. It would probably take a lot of money because, you have to purchase this stuff to get licenses for it in digital form. That's really going to be the cheapest way to get your hands on it, unless you want to just try to, get digital copies and extract the text that way. But that would be, anyway, it can be done. And you would end up with a super lawyer language model that would be able to pretty much tackle any issue. So to the extent that Claude is sitting here claiming it has no specific knowledge of any law, yet it's can perfectly handle a California, producing an opposition document to a California motion for preliminary injunction. If something were to be specifically trained on all the law in existence, case law and statutes and codes and everything, imagine what it could do, when it does have specific training on the law. So that would be a really interesting.
It'll execute us all
consider,
because
but
we're all guilty.
if somebody knows somebody with money who wants to front such a endeavor, because that would actually be, I haven't done any research yet to see if a company is actually boasting that, that they have a language model trained exclusively on law. But to the extent like LexisNexis and West and Deering, companies that make legal compendiums and reports, the reporters and stuff like that, LexisNexis in particular, because they have this huge online library that you can search. They probably already have something like this. They have to, because this technology is not brand new. It's just finally come to the to where now the public can access it as of a year ago. That's when these language models started to become available publicly on the internet. And but the technology has been there for over a decade now. Probably in the initial, they probably were developing things like these, probably 20 years ago. I remember in the 80s, it was called CASE, computer aided system engineering and expert systems. That's when these kinds of things started, except they were very primitive back then. They were just glorified databases. But then by the early 2000s, they had this language model concept had been devised, and they started training computers to start to be more to develop these more modern, more realistic AI models. And so it's just a matter of taking the time to train the model. So anyway, I'm pretty sure these attorneys have had this technology for a while. And it would surprise me if somebody hasn't already started training a model or has a model trained on law. And if not, that would be a holy grail. Imagine a digital judge. Imagine a judge, basically AI, just overseeing all the cases. And you could actually train it, because you could train it on all the decisions, and then you can train it on all the appeals of those decisions. So it would know what errors the lower court made. And then you could train it on, you know, the Supreme, if it goes to the Supreme Court, it would learn what mistakes the lower court made or the lower, you know, so it just learns to be a super judge. It learns to be a perfect judge and
What-
never makes any mistake.
Errors the Supreme Court makes.
Well, you know what? It would probably be able to infer that itself. You could
It
probably
does
ask
because
It
laws
wouldn't be able to
science.
see. It wouldn't be able to see if your socks didn't match.
Hey,
well, it
laws
would
of
be-
science.
yes, exactly. And it would
And,
notice the
and
pattern.
a lot of the rulings are political or run by
Right.
money or other reasons.
And so it's going to deduce the laws of the science itself based on the model.
Right.
That's what it does.
Uh-huh.
And so it's going to apply the same rules and same model or, you know, to the
You
higher
apply
court
the
rulings and
facts
find
to the
flaws in
law.
them. What was
It's
that?
still going to claim immunity.
That's right. And there is no immunity.
So yeah, once somebody does this and you could, oh man, things you could do with it. You could call it the judge of the public court. The judge of the court of public opinion.
There you go.
Yeah, but somebody would still have access to feed it whatever it wanted it to spit out.
Yeah. It'll go to Facebook and take all the information.
No,
Yeah,
but you show what you feed it. You feed it all the data.
it'll get you prosecuted by finding the secret money you're hiding in the Swiss account.
And then you tell it, you know, give us, what do you say, Judge?
It's legal to hide the money.
Judge Claude? And it spits out it tells it, well, based on this and this and this, and based on this legal standard, it would actually give a ruling. And it would be
Is it
100%.
true you asked Claude GPT-2 how to hide your money?
In the,
It
in the
told
ground.
you putting it under the mattress was not a good idea.
That's right. Yeah.
All right, well, so that's interesting, Gavin, that you were able to use it to basically write this correspondence. And did you give it any prompting? Or what prompting did you give it to write those letters? Like what facts did you feed it? Did you tell it what you wanted it to write? Or did you actually use it?
Eddie,
as a-
he's now a master. He's now a master at arguing with himself.
Right. Respond to still. He's standing still now. Respond.
I guess.
Well, Gavin must have left the bar.
Well, I mean, that's just another example of the kind of use you could put it to.
Yeah. Yeah, and how about applying it to the medical world and health?
I have in a limited way so far, but
Oh,
I
good.
used ChatGPT to ask it about, I started taking NAC and acetylcysteine,
Uh-huh.
and that seems to have made all the difference with my issues I've been experiencing that finally turned the tides.
Oh,
And apparently it was what somebody figured out that you could use that to fight COVID-19.
really?
And they figured this out. I think it started to come out during, I don't know when, because they censored it. It was censored right away. And Amazon stopped selling it, but otherwise before that, it was just standard. It was just like hydrochloroquine. It's always been there because it's good for lung health. It helps break up mucus and some other
What's it called?
N-acetylcysteine. N-acetylcysteine, or otherwise known as NAC. You know, everybody kind of knows it as NAC. And so it was banned for a while. The FDA said, "Oh yeah, people shouldn't use it." You know, it was just the same kind of bullshit FUD. Fear, uncertainty, doubt was used on it, just like hydrochloroquine, just like ivermectin. And so it was sort of, you know, shunned for a while, but then now it's back. You could order on Amazon. I just bought some from Walmart the other day. Prior to that, I bought some at the health food store that I normally go to. And I started taking it, and instantly it made the symptoms of feeling.
Did you ask Claude about it?
It made them just go
Yeah.
away. And
Did you ask Claude about it?
I'll tell you what I asked it in a second. And so, whereas before only fasting would help, all of a sudden this simple, cheap supplement that I could get off the shelf was a game changer for me. And so what I did ask, I had already read this somewhere else that if you combine it with glutamine, it makes a potent immune system booster, and it helps fight if you have like lung issues. It's really good for that. It also helps the liver, and there's like a whole bunch of, they work in conjunction with each other. So I asked it that question: how do N-acetylcysteine and glutamine work in conjunction with each other? And it gave a real competent answer on it. In fact, I can show you. So I think it's still here in ChatGPT where I asked it. Let's see. It's not there. Yeah, here, I'll show you where I asked it. Okay, yeah, I'll show you some of the medical stuff I was asking it. Testing it out. But I'm asking, notice I'm using GPT-4 at this point, right?
Okay.
So I said, what's the difference between magnesium and magnesium citrate as a diet supplement? And so, it tells me a bunch of good information that I kind of already knew, that magnesium is an elemental magnesium, doesn't absorb very well in the body, whereas magnesium citrate, more bioavailable, et cetera, et cetera, et cetera, So it gives a bunch of information. Does magnesium in the diet also affect heart health? So it talks about how magnesium plays a role in heart health, blood pressure regulation, heart rhythm regulation, and so on. A lot of information. You can find this stuff real readily by Google search and going to websites and stuff. It's nice being able to just ask a question and have it spit out the answers you're going to get anyway, from all these other websites.
Unfortunately, magnesium does not state a cause of action.
No.
And then I ask, is there a way to make magnesium oxide supplements more bioavailable, either before or upon consumption? Because I'm thinking, okay, if you get just get regulars, magnesium oxide tablets, is there a way to make it so they're more bioavailable? And it has some suggestions. Okay, so
You
and
wait
also
and see. His amended complaint against Panda Express is going to contain an allegation that they use too much magnesium.
Yeah,
No,
but
again,
if you could
that-
combine it with vitamin D, you get a cause.
that's a good point though, because
It'll be the healthiest
don't wanna-
complaint he ever filed.
you don't want to mix you don't want to mix context. So you don't want to start asking Claude questions. Like if I was in Claude and I start asking it these kinds of questions, it is going to mix with the context. But as you see here, it says context cleared. So everything I was working on prior, like we were just talking, this is the question we just asked about Isaac Asimov.
How did you clear that context so it
Right
stops
here, this is the broom.
into previous?
Down there.
See this broom? See this? I'm gonna click it. Watch what happens. Well, the context is already cleared, so it doesn't. So if I say, I'll say hello, and it'll
But all
say
the previous,
hello.
all the previous context is still up there.
It's up there. It's still here to look at, but it's no
Oh, yeah.
longer
Cool.
considering. It's
Well,
no
it's
longer
not
within
part of
this
the. It's not
context.
part of the ongoing equation.
Exactly. So watch, when I click this, it should pop up. Yeah, context cleared now. After
Cool.
me saying hello.
Now
So
I know
that's
how
how
to
you
switch to clean the
but-
office.
So I'm over in GPT-4, and so it has nothing to do with Claude 2. So I'm asking all of this of GPT-4. So yeah, you want to keep that in mind, that you only have one context window. Now, if you go to OpenAI's GPT, so I have an account on OpenAI's server, and it allows you to have multiple contexts. Like you can have all your past conversations are in a bar over here on OpenAI's website, and so you could go to any one of them, you could go revisit them, and it remembers the context of that conversation. So that's one cool thing about using ChatGPT on OpenAI servers. But unfortunately, ChatGPT isn't very good at law, and Poe doesn't have that feature here yet. So it's kind of, it'd be really, I wish they did, because it would be really cool to be inside Claude And then they have, over on the side here, an index of all the different context that you were working on. So instead of having to clear the context and start anew with some new subject, you could just leave it there, start a new context and start talking about, somebody else's case. And then leave that there, start a new context and start dealing with, asking it medical questions or dealing with a third case or whatever. So I'm imagining at some point they'll add that functionality. I'll ask them,
But
actually. I'll send in an
You can
inquiry,
go
but-
back and resume a previous conversation using previous elements.
as long as the context isn't cleared. But as soon as the context gets cleared, then what you have to do is you have to go back and you have to feed everything back into it. And that's what I had to do
Oh,
a few
shit.
times. Yeah. 'cause
Well, what
sometimes
if you
the
what if you
context-
do one and then you do something else and you clear the one you just did? Will it go back and make the one previous live again?
Nope, it just clears the context. It just starts over with an empty brain.
Hmm.
It's just a big happy idiot.
So it's like
just sitting
push and
there.
reset. Yep.
Pretty much. It's the reset key. So
So you better finish the level because you can't save the
last-
game right there at the last fight before the. Yep. I got you.
no, but you can always go back and you can copy what you put into it and then copy what it output and get it back on track that way. Especially if you were on it'll generally get back to where it was. Although, as you might have noticed during one part of the development of Randy's opposition document, it's like it started to focus on free speech as opposed to free association. So, and I had to keep trying to dial it back. So, but as you saw, I was able to keep feeding back the paper back into it and getting it back on track that way. So if you ever lose the context, that's what I would do. I just go back and you just have to quickly copy and paste. You can go back,
Yeah.
scroll back through the transcript, copy what you put into it, copy what it gave you and feed that back into it and it'll get it back into your context.
Yeah, that's why I do it. That's why I do it in small bits.
Yeah,
It's
it's
easier to
inconvenient.
manage. I
Yeah,
just
it's
perfect each of the small bits and then move them to the side.
That's a
And
great
that way
way to
it
do
doesn't
it.
get confused.
That's a
Or
great.
then at
that's
that
actually
point, I could take all the perfect eggs and put them back in the basket and tell them to color them.
There you go. That's a very smart way to do it, actually, too. Very good way. Very, very
It's
smart.
like,
because,
yeah, it's
you're
like
right.
step edit recording is what I equate it to back in the music
Yeah,
production
yeah, yeah.
days.
Yeah, you're
Just
right, though,
taking
because it
bit
doesn't.
by bit by bit and assembling it.
Yeah.
And
when
that
you
way
put
it
all
doesn't get
together-
snarled up in the whole giant picture of all of it and keep
Right.
trying to recompute all of it. I just want you to finite detail and refine this one element, and then we'll move to the next, and then we'll move to the next. And then when I have all your perfect elements together, separately saved them in a document, then I'll put them all into one and tell them, boom, make it all number one. Yeah, I see. It's a very cool tool. And the phraseology, the language, like I said, it makes you sound eloquent now. It perfects your language skills.
It does a very,
It makes
know,
stupid people sound
standard-
intelligent.
yeah, just it outputs a very standard.
Although when you're
Lawyerly,
trying politics, you
paper.
can do that.
Goober Pyle goes to court.
Well, here's just real quickly to show you the question I was asking it about the interaction between L-glutamine and N-acetylcysteine. So it says both L-glutamine and N-acetylcysteine are supplements that have specific benefits and functionalities. Though they are not usually linked directly in functionality, they can support health in complementary ways. Here's a brief look. L-glutamine is an amino acid, serves as a building block for proteins, plays a vital role in the immune system and intestinal health. It's also important for maintaining the barrier between the inside of your intestines and the rest of the body. NAC is a supplement form of the amino acid cysteine. It's used to break down mucus in the lungs and to counteract acetaminophen poisoning and for other medical applications. It's also a powerful antioxidant. The two have different primary functions. They play a role in overall health and can support the body in different ways. When it comes to their relationship, both can support immune health. Glutamine is necessary for lymphocyte proliferation and cytokine production, while NAC can boost levels of Glutathione, one of the body's primary antioxidants. Both have potential benefits of gut health. Glutamine supports the integrity of the intestinal barrier while act as an antioxidant. It helps reduce inflammation. And both
I
may
could-
support brain.
I could see Salam using this to create some new kind of food.
Yeah.
You kind of could. I mean, you could just get a bunch of you could
Raisin
you know,
raisin squash chickens I planted.
Cross pollination and
literally use it to ask it questions of
insemination.
stuff that you ordinarily wouldn't know how to do because you don't know the math of the science or whatever. And it would I mean, I don't know. Here, let's ask it. How can I? Oops, I need to do that.
There you go. Look at that.
That was, yeah, I was like, how can I combine a chicken egg with an eggplant to make a,
They're
What
gonna
if we
say in a
tried
frying pan.
that does what?
In a frying pan.
It'll probably recommend a 4-quart
Yeah,
large kettle.
yeah, right.
To make an eggplant plant that
With chicken.
produces eggs. How can I biologically, I'll say
Oh,
biologically.
Yeah.
Which came first, the chicken or the eggplant or the egg?
See the combining.
Combining the genetic
material.
material of a chicken egg, the eggplant to produce an eggplant that lays eggs. It's not scientifically possible. The reason is that chickens and eggplants are vastly different organisms belonging to entirely different kingdoms, Animalia versus and Plantae respectively.
Yeah, he's arguing eggs and eggplants.
He doesn't want to discourage your interest in genetics engineering, though.
Don't put all your eggplants in one basket.
Keep trying.
The ability to lay eggs is not a simple. I don't want them to lay eggs. I just want to grow eggs. Anyway,
I
Well,
had
there you
trouble
go.
raising chickens. I don't know if I was planting them too deep or too far apart.
probably too deep.
Yeah. They sure got some good corn out of that.
Mine were better once the legs stopped jumping around.
My blue corn didn't come up this year.
We didn't plant chickens.
Might as well.
We planted that fish, and boy, that peach tree took off.
You can actually put a fish underneath the plant, especially like I know people who will, they have a start, like say a tomato start. And
Yep.
they'll dig down, put a dead fish down there. And then a little soil and maybe some other amendments, and then put the plant right over that.
Yeah.
And the fish will provide nutrients to the plant and they grow real healthy and lots of fruit.
Yep.
So,
We learned that one from the American Indians.
right. That's exactly right. All right, well,
They got
I
it
think
from
it-
Poe.
they got it from what?
Poe. They
Yeah,
got it from Claude.
yeah, Claude. They didn't
So-
think to ask the more important questions. All right, listen, I want to get going. I think it's time to, unless Randy, did you want to ask something?
Yeah, well, I just wanted to ask, was it 2 weeks ago, when Michael was talking about how, like, with the lawsuit, like how they really have for, they're suing me for the, investigation fees, but yeah, I was never convicted for anything in any of the courts, So I'm just curious, he was talking about it. I was just trying to figure out how can that lawsuit even uphold if nothing has ever came about in the court for it.
Well, that's one of the things that they're gonna try to now, that's part of the lawsuit that's gonna be. Yet to be
Okay.
determined. They still have to prove that, in other words.
Okay.
That's the
Yeah,
whole
you get a
idea.
jury
Well,
trial.
they have to be found in some way on something they brought before the court to prevail, to be the prevailing party. And once they establish they've prevailed on something, then they're entitled to reasonable attorney fees and costs.
Yeah.
Not for everything, only on what they prevail on. So if they lose on 4 points and they only win on 2, it minimizes their amount of attorney fees and costs.
Yeah.
Your cross complaint might want to include that, what they
Yeah.
want in cost, that you want that on a cross.
Yeah. And then, you know, and I was wondering too, you know, I was talking to one guy I was talking to the other day. He was telling me, he's like, I don't understand how a mandate, you know, it was martial law or no laws ever was put in place. It was just it was a mandate. It was just a, you know, a request. So I don't know. I just wish this shit be over with. I had two undercover, what do you call it? State workers today trying to come into the shop. The first guy, I just knew the way he was asking questions and stuff like that. I had him download our app to become, because it's a social club now, and everything else, whatever. And then I told him you had to make an appointment, this, that. So I ended up getting cut or whatever. And then afterward, he started asking questions, like asking one of the artists. We're not barbers no more. The artists, hey, well, how about sink right there? How do you guys wash your hands at a sink? He's like, well, we just stick our hands underneath the counter there and wash our hands.
But
And
dude,
it's
like,
just
look,
that.
man,
So
you got to understand that you got to understand now that you just put into court that you are, you know, selective about your membership and stuff like that
yeah.
as a declaration. And so, and you did that under penalty of perjury. So if you just, you know, let this guy in and gave him a haircut today, that's against what you were just saying. in
Yeah,
court.
So he downloaded the app. We made him download the app. He went out there, he scanned it, took pictures of it. You know what I mean? Took a picture of it and everything else. And then what do you call it?
You don't, but see, like, why did you don't want him even to come into the store before they're, or you don't want him to come into the club before they're a member. You can't
Yeah.
be letting people come in.
Yeah. So I know that's what but I explained it all to him when he came in, what you know, what we were. This
You can't be
had
letting
downloaded.
people, you gotta put in a situation where people cannot just walk in though.
Yeah. Yeah. I mean,
And if you
I
have
was
any
thinking,
signs, if you have any signs that say anything about, you know, anything, you know, what the, you know, you're not supposed to have any signs.
so I understand that. So like on my door, my sign on the door it says right there, it says private property, members only. And then it has all the literature and stuff like that. And it has a QR code to sign. It says it right there. You have to look at the big old thing on the door before you even touch the
All
door.
right.
It's right there in your
All
face.
right.
Yeah,
So
you need
it's just like
you need
having a trespassing sign on somebody's fence or on their property. It says no trespassing. And then they go out there. It's like you clearly seen the sign that says no trespassing, and you still trespassed.
You need
You
a
know?
code key.
What's that?
Key block. You need
Yeah,
a
yeah,
code key
so we-
block where
so we
people
got-
can
we got
punch in
them.
their code and get in.
Yeah, so I got the key code thing.
Didn't you say you cut his hair?
No, so one of the barbers, so he actually downloaded the app. He became a member, and then when he became a member. So once you become a member, then you can, and it tells you all that stuff right there on the app. You know what I mean? That
And,
everything's donations.
And see, here's the problem, Randy. That's not very selective.
Yeah.
Anybody who can download the app is a member. That's not selective. That's not somebody.
Then how am I supposed to do that? I mean, am I supposed to fucking, pat these guys down? I mean, what do you do? How do you become
Well,
a
yeah,
member?
they
then?
have to. Well, you know what? That's what
Well,
you gotta
did you
do.
get it?
That's-
Did he give a donation?
Yeah, he donated. Yep.
He get any kind of receipt or anything?
No, it's a donation. You don't get.
Did he bring his own? Did he bring
He
his
didn't ask
own?
for one.
Did he bring his own barber tools?
No.
Whose barber tools got used?
They're just community property. They're just.
Community, meaning used on everyone that comes in there?
Well, I mean, we just have, but all the stations just have different tools.
Doesn't the artist bring his own?
Yeah,
See, that's
yeah.
Randy,
that's where
you
they're
gotta
bringing
read
in the
that
health and safety
declaration,
code.
and you gotta stop and read that declaration, and you gotta see what you just submitted to the court.
Okay. Yeah. Well,
You
then,
know,
and then
you
after
read-
that,
look, man, I told you, I sent you that declaration and I said, can you sign your name to this? And you said, yes.
yeah.
So
Now,
everything
here's
that
another
declaration
thing.
said, that's what you gotta be
Yeah,
doing.
but now it's not true.
You got to remember when you have an organization and everybody's a member and they all come in and they say there's no alcohol allowed, and one of the members brings some alcohol in on his own, that doesn't make the company liable.
Yeah, but this is Randy who did this. This is
I'm
Randy
just-
interacting with this guy.
Okay.
No, so I just told him he had to become a member. I told him he had to download the app and this, that. And then he asked me for my name. I knew who he was. He asked me for my name. He saw, now, what's your name? I said, Go Brandon.
Yeah.
You know. So you know, and then so then about 3 hours later, another guy comes, but he's got a badge, right? He pulls up. He comes up to the door, and he sees the sign because the first guy, you know, he's seen it, but I made him go back out there and read it and then scan the thing to become a member. So he came into the shop. He trespassed, and I told him, hey, you got to go back out there. You have to go back out there and scan that code. So I have it on video, you know. So he went back out there, scanned the code, become a member, and everything else. Read through all the bylaws of it and everything else, and this and that. And then the second guy, he came a couple hours
Hey,
later.
That's not selective. That's not selective club membership though. That's just anybody who could read the.
So how do you make
You got to do like an interview of them, and you
Wait
got
a
to
minute,
kind of.
wait a minute, Salam. Doesn't it say that you agree to these following facts and you list them all out, that this is a this, you're making a donation, there's no da 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 da, it's an art da 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 da. You agree, click the button.
Yes.
That's not how the standard works though. That's what, as
Okay.
far as how the courts are going to analyze it, they're going to look at, okay, what steps does the organization go through to determine if somebody's qualified to be amongst their membership? If
Did
it's
they
just
take this-
anybody-
Well, see, that's where I thought the qualification was that you were like already a barber or an artist, and it's barbers and artists that are doing artistry
people
on
who
each
are
other's
interested in
hair
barbering.
voluntarily. But now it's
Yes.
like anybody who comes through the door and joins can get a haircut for a donation. That flips it back into regulatory.
Yeah, it was because it's so I turned into a social club. So I got a what do you call it? I got a nonprofit too as well.
But what's the social club? What they were trying to get, how does the social club set me apart from anyone else?
Well, that's why I have all the bylaws. Like we do like you know, like
No, me,
You
not them. You, not the guys that are working.
Oh.
Me,
so what? How does it set you apart?
yeah.
I don't understand the question. What do you mean? How will
Well,
it set you
if
apart?
I can walk in,
Yeah,
okay, and Salem can walk in, and
Mhm.
Michael can walk in,
yeah,
and everybody on the street can walk in,
yeah.
what makes it selective?
Well, it's kind of like a golf course. You know what I'm saying? Like Stanford Ranch. I mean, or Whitney Ranch Golf Club. I mean, it's members only. But I can walk into the clubhouse and I can fill out a piece of paper or sign or click their thing, sign up and pay my dues. You know, my donation, and I can become a member and I can go golf out there. But
Yeah, but
until I do that, I can't golf.
Okay,
Yeah,
so
but that's open to the public because you're a member of the public at that point. You're not a member of the housing homeowners association that owns the homes there. You know, that's just you like getting a Costco like membership.
Well, I mean, we have one out here called Peachtree Golf Course. It's out here in the middle of fucking nowhere. Ain't no houses around it at all.
But see, like,
just-
there's no other qualification than you fill out the membership and you pay the donation and then you can golf there.
Yeah.
Anybody, whoever can do that. There's nothing like, well, you got to be this age. And the reason you got to be this age is because this is a retirement community. And we only want people who are retired to be walking around here. Like that's one example. Or it could
Okay.
be, you know, we only want barbers here because only barbers, or at least people who appreciate the barbering arts and who want to, you know, learn about them more. You know, only those people. So are you here
Okay.
because you're interested in the barbering arts?
so then I would be a
Okay, well,
model.
You can't be a member.
Maybe they
Yeah.
have to sign up and understand that they're just a model for the artist.
Well, the
Yeah.
problem,
Uh,
again,
I
the
think if
problem
somebody
again-
came there the other day and got a
problem
haircut,
again is that anybody
You
can
got
click on
problems.
on the a button that says I agree. It doesn't require any particular distinction between one person or another in terms of what establishes that it's an intimate relationship versus just a, you know, expressive public relationship.
well, and that's what I'm saying. If somebody came there the other day and then went outside, clicked the app, and you knew let them in, and then someone gave them a haircut, you got big problems. That's like Cliff's deal, where they let the guy come in and eat and drink and gave him a receipt and basically exposed the entire operation for not what it purports to be. And what if that's what just happened? That's totally contrary to your declaration. You just said you'd sign under penalty of perjury. There's no intimate association. There's no artistic expression. This guy came in, this guy got a haircut with unregulated materials and in who knows what kind of condition facility because it doesn't have the health and safety code approval. And that's exactly what they're going to get the injunction on that.
Well, he had a pretty good opposition to the injunction. And see, that's why I think you got to go back to
Well, the fact that.
Well,
they're
if it
coming
was
back
all,
with
if it, hold on, if it
inspectors-
was all under the First Amendment and the artistic expression, which is within the free speech reach, that would all be fine. But that's not what just happened.
why not?
Somebody who wasn't scrutinized and carefully examined and vetted was basically just allowed to go out, click the app, click, come in and get a haircut.
Free speech?
Yeah, but they had to check a box. They got to check a box to agree that that it's they're doing business with it's well they're a part they're a part of a social club, and everything is gifts and donations and everything else.
Well,
Yeah, but see,
Free speech.
saying all that to skirt the laws and the licensing is exactly what they're going to say it's implied to do. And that would be impermissible as a provision in any kind of contract or agreement. No court would hold it enforceable.
You hear that, Salam?
That would be like saying, we're a bunch of retired doctors that used to perform, gallbladder surgery. And so we're all going to get together and have this autistic collective, and we're going to remove each other's gallbladders. And we're just going to throw we're just going to throw the shit in the sink and say it's okay.
And what was the government's authority to interfere? What was the government's authority to interfere? And who
Public
does the power
safety.
go to?
It's all done under the public safety thing.
No,
They have to protect the public.
the public safety or ...
Well,
The
the public
people.
safety. We can't have people doing what this guy
The
just
people
did.
have the
Hold
right.
on. We can't have 500 people coming in like this guy just did, clicking the app, checking the box, coming in, getting a haircut, making a donation on the same set of clippers and shears and using the same comb.
Why not?
And
No,
how do we know it's something
have-
Why
different?
not?
We don't.
Why
Yeah,
we
we
not?
have
know-
spray.
We
Who
know
says
that
we
this
can't?
isn't. We know this isn't regulated
Who
and
says we can't?
inspected. And if we know that's happening, we know that's a violation and it
Where's the
potential
authority for the
public
government
safety issue.
regulation? Where's
It's a
the authority
public
for the
safety.
government regulation?
That's what they're going to say.
I know, but where's the authority
Safety.
for the government regulation? In
Of course.
violation of Article 1, Section 10,
It's a question of public safety.
doesn't
They're
apply.
protecting the
Doesn't apply.
society.
How is the public being injured?
We don't know if this guy's
No, we
using the
don't
same
know.
set
We
of
don't know.
clippers, the same comb, and the same scissors on 500 people. We don't know that they're
Every-
being sterilized in conformity with the health and safety code.
Every presumption
could
of law
cause-
is
That could
rebuttable.
cause public head AIDS or something. I don't know.
Every
that's what they
presumption of
say.
law is rebuttable.
That's why they regulate it.
Every presumption of
It's
law
under the
is
guise
rebuttable.
of public safety. I can't say I fully agree with it, but I
Every
understand what they're doing.
presumption of government interference is rebuttable.
So what? So I have a question. So Michael, what would you? How can I? The government came over. They fucking robbed me, took my license, took all my shit from me because I wouldn't comply to their mandate, whatever. Because Home Depot and Lowe's and Starbucks and all those fuckers stayed open, right? So then I'm trying to go social club. I'm trying to go private. I'm trying to go all these things.
But unfortunately,
Nothing works.
your goose that laid the golden egg for argument was back when you had the license. That's
Well,
when all
I-
the
yeah, but
arguments
they-
were paramount.
So
Now
they
that
suspended- they
argument is
revoked my
gone
license.
and time has passed, you're left with what you have left, and
Yeah, they revoked my license. They took my license from me unlawfully in my eyes. I mean, it was a
well,
mandate. It
that's what
wasn't.
that's what you should have fought. You should have had your administrative hearing, made that entire record,
Did,
and done
you
an
did.
administrative writ of mandamus,
You'll
and
do
had
it
that
with a
reviewed,
mandamus.
and then sued him on top of that.
I do the judicial, not the administrative, but you can still do the mandamus.
Well, no, I mean you have to do an administrative mandamus for an
wrong.
administrative record.
There's no administrative record needed. It's judicial.
Well, no, they revoked his license. The license was
doesn't want it back.
administrative. It
Yeah, I
was
don't
through
want
the
it.
Cosmetology and Barbary Board.
It doesn't.
So they had original administrative jurisdiction. They said, we're suspending your license. That's where you needed to make the argument, and then grow it from that administrative proceeding into the Superior Court.
See, that's why
They
you
issue their
got
administrative
judicial
decision, we're
Michael.
suspending or revoking your license. You challenge that on an administrative writ of mandamus.
The question is there a way to, we need to go back to the record and find if there was an administrative error on the way that deprived Randy of his due process rights.
Constitutional right, yeah. Article 1, Section 10. That's the statute.
Yeah,
Well,
because I mean, it's like
as long
I
as you
mean,
got notice and opportunity, that throws a wrench in the game.
Article 1, Section 10.
so I mean, a notice of opportunity. You know, what I mean, like this is just so frustrating to me because it's like, how can they just come in America and just say, "Hey, close down"? And I'm sitting next to a Starbucks and a Walmart and Home Depot and all these people around me, but they're all open. I'm like, what do you mean close down? I'm like, well, you're not essential. Well, I beg to differ. I
Want me
cut
to
law
tell you,
enforcement.
Randy?
Huh?
I'll tell you, it's the same way they say you got to have a license.
Yeah, I
how
had a
they do
license,
it.
but they
It's the
took my
same
license.
thing. The same
Yeah.
concept. They come around and say you're out of business, and they go to you. You need a license.
Yeah. Well,
That's how they do it. And the remedy is the writ, and the remedy is Article 1, Section 10. And you got to start in the beginning to say, okay, Judge, how did these guys get the authority to violate the U.S. Constitution at Article 1, Section 10 before we start?
could you send me that? Because when I go to court, I'm gonna have to speak for myself. So I want to be able to, say these kind of things. Huh?
What do you want me to send you? Article 1, Section 10?
Well, yeah. I mean, I'm something because I'm these Nazis, man. It's like it's so fucking frustrating and so.
But you
It angers
can't get
me so.
emotional. You can't get
Oh, I
emotional.
know, but it is emotional. You know what
I
I mean?
know.
It's like I've been fighting it for 3 fucking years. You know what I'm saying? And it's like people in my family dying left and right, and going through all this shit, and you're letting all these fucking weirdos and chomos and child molesters fucking run the streets and do all this other weird shit. I'm sent in jail for cutting hair, and I got fucking methadone and fucking fentanyl people laying around me, moaning and pissing on themselves because and busting out windows of convenience stores, and they're getting out of jail before me. You know what I mean? And all this other crazy, demonic, fucking democratic bullshit, and you guys are continuously wasting your fucking time and money on a fucking guy that just wants to work and provide for his fucking family, his kids, and I haven't asked you cocksuckers for nothing. Leave me
It's all
fucking be.
control.
I'm like, it's
They gotta have control over you, bro.
well, they're not gonna have fucking
You're
control
talking
over me.
about corruption. And if you start talking like that, and it makes sense to say that out in the street, but then they start talking about that instead of your real argument is how can they violate the Constitution?
Yeah.
What's their authority to come and bring this action?
Yeah.
It's right at the beginning, and you need to know. And you need to know what Article 1, Section 10 says. And it says,
Article 1, Section 10.
Yeah, it says that no state can impair the obligation of a contract.
Okay. Well, I need to write. Article 1, Section
10.
10. Article 1, Section 10.
Now you got to.
Being a contract.
It prohibits a lot of things. But you have to read through it. It prohibits the state from coining money. It prohibits the state from emitting bills of credit. It prevents the state from making anything but gold and silver tender for legal tender. No state shall make
All debts, public and private.
No state shall make anything but gold and silver coin a tender in payment of debts. And no state shall impair the obligation of a contract. So if you have a contract with a guy to cut his hair, the state can't come in and stop that.
Well, what if I got a contract with my neighbor to take out his ex-wife?
Well, that you can't make a contract that's illegal.
Okay, exactly.
Hey, well, it's not illegal to cut someone's hair.
It
Is
is.
it illegal to work? It's illegal to work in America?
No, but it's illegal to take out someone else's wife. If
Well,
I
yeah,
meant what he said.
exactly,
Now,
but-
wait a minute. It may not be illegal to take out someone else's wife to the movie and dinner.
Well, while I'm
because he
getting my
said take 'em out.
sideburns
What did you
trimmed,
mean, take them out?
while I'm getting
Oh,
my
it's so-
sideburns trimmed, can I get a tonsillectomy too by contract?
Yes, you can. You can get an abortion too.
And then the guy and the lady can come in after me and with the same tools get the same services, and that's not a public
If you
safety
have a
risk?
contract to do it.
Oh, I can't contract.
If you
around a
contract to
public
do it, then the
safety co-
state can't impair it.
You can't contract around a public safety
You
issue.
can't, no, you can. You can't contract to do something that's illegal.
Where does that interpretation come from? Let's look at it that way. That's an interpretation of the Constitution.
Yeah,
Where does it come from? Is that the legislative intent? Is that the legislative policy?
It's
Is
the
it court's
legislative intent.
interpretation?
the Constitution was written
So
with
the
legislative intent.
intent, is that an is expression of the people's will?
Yeah, it is. All the state legislatures going back in time through the state of California have come up with all these things like the health and
But the
safety code,
Constitution
like the
is
food and
responsible.
agriculture code. So we
That's a
can't just
code.
have,
That's not a
hold on, we can't
constitution.
just have you milking the cow and selling it on the roadside. People got sick. They said, oh, we
Safety is
health and safety code that says you have to
that's the $1 million
process milk like
word.
this to
safety.
sell.
That's right.
And then they start doing it with everything. Why do you think medical is all
Hey,
regulated like it is?
If I go to buy milk from a guy who has a cow or a goat, they can't stop me. And if they want to bring charges, they're impairing an obligation of a contract. They have no right to come in. The Constitution says it. They can say, oh, but if you drink milk, then Iran could attack Iraq. Oh my God. Or this could happen. Or you could get sick. Or you could get well. Or you could. No, there isn't any. They have to have a cause of action. They have to be injured. You can't injure the public.
Well, they call it a public nuisance. That's exactly what they just did to Cliff. And that's exactly what he was selling was unpasteurized milk and cheeses and other things that didn't comply with the agriculture and food
They
code.
do it to a lot of people. They do it to a lot of people. And you know what? You got to fight them. And when you fight them, it's going to take you and give you a bunch of bullshit. And if you aren't prepared, then it's going to be even more bullshit, and you'll go through it like I did for 10 years till I figured it out. Then once you figure it out, then you say, take
Unfortunately,
me to
you're
court.
already like 3 steps down in the battle. And the problem is I see is the best battle and the best fight you had was at the beginning over the license itself. That's what needed to grow up
There
through
you
the
go.
courts.
There you
Hey,
go.
Randy,
Because now the license is gone and the actions have taken 2 and 3 steps beyond that process.
Yeah,
and
we
you
gotta
can't
figure out a way
reach
to get
back.
back to that.
You
I
can't
gotta
reach
find
back,
that
yeah,
out.
unless you can find a way. Unless you can
Well,
find a way
Randy-
to survive that.
Randy,
Yeah.
they're gonna try to reach back. And I've looked at that and I tried to reach back for years and years and years until I decided to look forward and say, hey, what does the Constitution say? And what
Yeah.
is their authority to come in? Where's their delegated authority for them to bring you to court?
It's in
Yeah.
the code. It's in the statutory law.
Yeah, Michael says it's in the
It's
statutory law.
regulatory.
But does show me where exactly?
It's
Exactly.
So-
regulatory.
so
Well,
if we're
it's
gonna
under
talk
the health
about-
and
And
safety
Randy,
code.
it needs
It's
to say
under,
Randy, right? They got to come
it's
after
under the-
Randy, not just any person.
it's under the exact health and safety code they cited him.
But
Yeah,
what
so-
is the
so
delegated
statute,
authority
so
in
the statute
Constitution?
laws, I have
The
on,
Constitution to delegate the authority from the people to the state to dictate whether or not
Look,
Randy.
hey,
haircut
Randy,
somebody.
the statute
Yeah.
says what the statute says, and
Yeah.
we don't
Well,
disagree.
it goes
But
to the
where is
nature.
the authority to apply the statute to Randy? Is it
It
in
goes
there?
to the nature of
Randy's
the
name in
service you
there?
perform.
Randy? Does it say Randy? And where does it say they can apply that statute to anybody? Only
Where
to
does
a
it-
person. It just says no person shall.
Wait, where
No
does it say?
person.
It depends on the nature of the service. performed?
Nature of the service provided.
Oh, so now we're gonna decide the
Where's
nature
that
of the
phrase in the
service.
Constitution?
Well,
Well, yeah,
I'm
if
sure
we're
they're
a
gonna
re-
decide what it is.
If
It's
you're a
bad,
restaurant,
and
If
prosecutorial.
you're a restaurant, food service provision, there's
Here we
regulations.
go.
If you're a
where's that
cosmetology
established in
center,
the
there's
Constitution?
Who's gonna
regulations.
say
If you're a
that's what
barber
now
shop,
we're gonna
there's
label
regulations.
Randy? You tell them
If you're
you're
a nurse-
identifying as a perfect human being.
That's
And
what I
not a
tell
male
them.
or
Yeah, I'm an
female.
artist. Yeah.
Or not
Yeah,
a male
that
or
was
female.
true,
And
Michael.
you know
How
what?
come
That
they
ain't
have-
gonna get
Well,
it.
you-
Hold on, one at a
That's
time
just
here.
for the
Hold on.
bullshit.
Hold on, one at a time. So I'll talk and then I'll go over to Zeke and then Randy and then Michael. If the, what you're saying is true and the Constitution delegated that authority, how come there weren't health and safety codes from, in the Wild West or there's no precedent for it until much later on. So where did the delegated authority, where did they assume it all of a sudden? When did it become, oh yeah, we can start dictating whether you can give haircuts to people and whether or not you can serve food to people and whether or not you can, sell unpasteurized milk?
1871.
Well, we've learned over time, if you cook this long,
1871.
you can eat it. If you don't cook it long enough, you can get sick from it. Oh, write that down. That's a regulation.
Go ahead.
You
1871.
can't be a public restaurant and
Go
cook
ahead.
raw meat
Authority, though,
Continue.
from-
and serve raw meat or raw fish or chicken. It has to be
Where's the
cooked at this
delegation in the
temperature.
Constitution from the people to the state to give them the authority to regulate those things?
The Constitution didn't give him the authority to. It denied him the authority.
Well, absolutely it does, under the 10th Amendment. The 10th Amendment says anything not specifically reserved under the federal Constitution is subject to the state.
No, it said any
The
rights.
state within
Rights.
the border, the state within the border of California,
That's
through its
right.
elected representatives, have written all these laws. And they
The
did it in
rights are
public
reserved to
safety.
the people. Respect
They
it.
did it with the mindset of it's public safety, that we don't want cow's milk sold on the corner that could make people sick.
Go research the
And
10th.
somebody goes, hey, we need to regulate that. Okay,
It's
let's
trying to
write
come
the
under
no
the
selling
general
milk
welfare
on the
clause.
side of the road. And then when they
It's coming
people,
under
look,
the
when people were
regulation of commerce and the
when
general
people were
welfare.
starting to get lice and all this stuff,
Time.
they said, hey, we need to regulate barber shops.
Not
They
one
have to
yet.
have cleaning standards
Anyway,
and protocols
Lamb,
and
1871.
inspections.
1871.
Yeah, that's when they
Yeah.
came with their codes and regulations.
Well, that was the modern, that's the new constitution, the corporate constitution. That's probably a reasonable answer.
So are you done?
Yeah, go ahead.
That's okay. That's the answer to that. So we want to go before that. We want to go to the fundamentals. That the whole Constitution is a freedom document, and it's designed to chain down the government, not give the government any rights at all.
I
Okay,
like it.
the federal government has only the powers that are enumerated, that are given to it. And the states don't have any restrictions except the restrictions that are given to it in the Constitution. Okay, and so it's that's why the states are free to do almost anything they need to do without federal regulation, but anything that they're prohibited from doing is reserved to the people. So that's why the people have the right to engage in contract. And you have the right to go into a contract and perform in a contract, and no one can interfere with that. Now, if you're doing something that's illegal, a crime, then we expect the state to regulate that. That's why the state brings criminal charges. Okay, but we also have to understand what a crime is. Because there's two types of crimes. There's crimes that are prohibited by the legislature, which came in 1871. And then there's the crimes of the judicial that are per se, and they have been around forever. A crime is where someone's injured or damage exists, and there is evidence to prove it. But a prohibition, there's no evidence. You know, he ran the stop sign. It's against the law. Well, you got any proof? No, I just saw him do it. You know, and where's the proof of, oh, he's cutting hair and someone could get sick? Well, yeah. Someone could get sick from cutting hair. Do you know that? Yeah, probably could. Okay, well, when it happens, then we can bring and interfere with the contract and bring the charge. But we have to have the evidence of it happen, not,
Never
oh,
have
it might
evidence.
happen. So
Yeah.
that's my rant.
Yeah, they got no evidence of anybody ever getting sick in a barber shop at all. No COVID, no nothing.
There you go.
Yeah,
But
And I
that's not
didn't
the
put-
argument. That's not the argument. The
yeah,
argument is that they don't have authority to interfere with a contract that you have with somebody.
yeah. So I had a contract with them, but they revoked that contract.
No,
without-
not that contract.
No.
The contract you have with me.
Oh yeah, with the
When I
social
walk
club.
in there,
Yeah,
I'll give
exactly.
you
Yeah,
this for that.
yeah. You're American. You get to make a decision on
Yeah,
yourself.
so
I
why
didn't
does the
do anything.
government need to come in with a license
They don't.
contract?
They don't, and that's what
Okay,
everybody's.
Article 1, Section 10 says they can't.
Yeah.
They can't impair the obligation of a contract.
Yes, Article 1, Section 10. So I'm gonna remember that. I might tattoo it on my fucking arm. So when I go to court on the 27th, I was gonna keep saying it over and over. Article 1,
Well,
Section
you got to
10.
tell them, look, I want to see the delegated authority from that the attorney general has from the Congress or the state for him to bring these charges in violation of to impair my obligation to contract.
Yeah.
So
Gosh, I
you
need to
got-
write that
so
down.
because they have to have authority to prosecute you.
Yeah.
Where's their authority to prosecute you? Who gave them that?
Well, it's the
Well,
same thing
prosecuted for a
in
crime.
Cliff's case. We went all through that in Cliff's case.
And
Yeah, but I'm not
Cliff,
serving-
and
I'm not
Cliff
serving
left
food.
town, right? Did Cliff get a ruling?
Yeah, they issued the injunction permanent.
Well, he didn't fight it.
I'm gonna
They
have
did,
about
I
4
believe,
show
I
up.
believe they made the 10th Amendment argument.
They didn't make any argument.
They made the argument that they moved away and closed down, and so an injunction shouldn't issue, and that didn't stop them.
That's
So that's it, but they didn't argue the Section 1 the
Article
10th
1,
Amendment.
Section.
Yeah, it's
Yeah,
Article 1
that's
saying
right.
they didn't argue that. They just said we moved out of town.
Because we want to see it on the complaint. Where is
Yeah.
it? Where does this guy get authority to bring charges against me for what he's saying? Where's the authority? And it has to be delegated authority, right? It's got to come from the legislature, from the president or the governor, or from the Supreme Court. Those are the only powers that are in government. And so this guy had better get the delegated authority. And you know what? Congress
Well, the
can't delegate.
legislature by and through elected a people, set up all these different regulatory agencies for all these different
You know, but
professions.
the legislatures, the Congress legislature, have no authority to
Sure they
delegate
do.
their power. No,
They're
they
not
don't.
delegating their power. They're getting together. If somebody's offering up a bill, everybody votes on it. If it's approved, it's signed, it's the law.
Okay, so when a prosecuting attorney goes into the court, he's prosecuting, right? That is an executive power, not a legislative power. And that executive power, he needs authority given by the president or the governor to do that, to make that a court action. Because the
That's
president,
part of his official capacity. He operates in the name of the people.
I know, but his official capacity is not in the Constitution.
He's charged with upholding and enforcing the law.
By
The
who?
legislature passes
By
the law,
who? No,
kills and
can't he
enforces
can't.
it.
He can't. No,
That's what he
legislature
does.
can't
He says,
delegate
hey,
any authority.
they gave me this law. I'm here to
No,
enforce
see,
it.
he assumed
I'm
the
gonna go to
power.
court and enforce it against Randy.
It's not constitutional. It's not constitutional. You can't show me anywhere in the Constitution that the power to prosecute was delegated by the executive branch, because the executive branch is made up of two people. Do you know that? Yeah. the president-
there's only about a handful, maybe two handfuls of states in the U.S. that you have to have a license to barber, to cut hair.
Oh.
There's a lot, most states in the U.S. don't even have to have a license to cut hair. Just like in California, tattooing, you don't have to have a license to tattoo on somebody, and you're tattooing with needles. You're putting needles and making somebody bleed. You don't have to have a license in California for that, because there's not many tattoo shops, so they're not. It's not lucrative for them. You know what I
Okay,
mean?
so you understand, when you're arguing that position, you're assuming that there is some power to regulate.
No, there should
I'm
be
just
no
saying.
power. Yeah. No, I'm not arguing that. I'm just saying, I'm just speaking, like,
I know, but
it's,
Well, it would be like saying in parallel that the medical board doesn't have supervisory, regulatory enforcement powers over doctors.
no, that's not saying that at all.
Well, it is.
No, it isn't.
Like the
'Cause
nursing
of
board.
course they got it
Just
over
like the
doctors.
nursing board has
They don't have it
administrative,
over me.
just like the nursing board has administrative regulatory bodies that oversee nurses with
Nurses.
license.
Nurses. Have you ever
It's
heard
the
of a
same with,
midwife?
it's the same with barbers,
You ever heard of a midwife?
pathologists, dentists.
You ever heard of a midwife?
They're all regulated professions. Even contractors, you got to have a license. That way we know you're not
But it's-
building a house out of sticks
squeak
on
midwife.
sand that's going to collapse. That's why there's building code regulations. You can't just put two nails in a board and call it a wall. That's why they have inspectors come out and sign off on building permits at each stage of the operation.
But a guy born with a
This
fucking
doesn't conform. This is going to leak gas into your house. It's going to kill your kids with carbon monoxide. That's why they inspect. That's why they regulate. That's why they monitor, patrol, and issue citations. It's called public safety. We can't let you build a house that's going to blow up or contains toxic chemicals.
Okay, I got a question about public safety. Is the law should be that you're allowed to have an abortion or not allowed to have an abortion?
That's a good one. Yeah. What's the answer?
The answer is 50 years.
The answer is it's whatever the law of the state you're in allows.
It's the 50 years, see, and that's why it's.
If you don't like the laws in the state of
requires-
Tennessee
federal
because it says
government-
no abortion after 6
federal
weeks,
government, the federal
move to
government
California.
interfered for 50
What about,
years.
I have a question on child support. Child support, is that legal or illegal?
it's an
Well-
obligation.
It's an
It's a
obligation.
legal obligation that both parents owe to the child equally to the extent of their abilities. That's why you can't discharge
Randy,
child support.
Randy,
That's why you can't discharge child support as a debt in bankruptcy.
that's why
Because it's not a debt, it's a legal obligation.
here's the thing. It's an obligation for a man to take care of his family. Okay?
Yes.
So you don't say, give it to the state. You say, look, I'll take care of my family and you stay out of it.
Yeah.
Just like if you get a divorce or a whatever, when you split up, you say, look, I'll take care of my stuff and she takes care of her stuff. But the kids are mine and I'll take care of them. And then you can have a babysitter, but you have to take care of them.
Yeah.
So she don't get child support.
Yeah.
Well,
Now,
what happens
if-
when you give her $20 and she needs 2,000?
yeah.
So that's not
When you
taking
show
care
me
of
that
your
when you
kid.
prove that she needs 2,000 or needs $20 and that you have to give it to her, it don't mean jack. That's what it don't mean jack.
That's why we have a court, because he thinks $20 is fine. He thinks he needs 10.
See, now we're already
So how
past
much
this.
does a kid
So
really
Randy,
get?
let me
Well, I'm
tell
not
you
doing.
how I handled it. So she leaves. I said, okay, you leave. I'll keep the kid. Okay, and don't think about going and filing for child support, because I'm going to file for child support. I'm going to file for child support because I don't make any money. How about that one? I'll take the kid and I'll go on child support. Well,
Again, that's
she didn't want any child support.
because you say that. What do we do? Police out with a sword to divide the child?
You're fading out, Michael.
King Solomon?
Your connection's messed up. We can't.
Somebody's got to make the decision of where these people go and
So
who
Randy,
pays
you
what,
make the decision.
because the people can't decide for
And let me
themselves.
tell you what happened. The state ended up suing me for child support. And child support, which was zero because there wasn't any owed, and for insurance for the kid, which was already paid. How about that? Think about that. They sued me. She didn't want to sue me. They sued me for child support and that. And so it's totally wrong. But they did it. And how are you going to stop them? You can't stop them with an argument that I don't owe the money. You can't stop them with an argument of anything except that where's your authority to sue me in violation of the Constitution? Put it down. Judge, we can't have this. I do not consent. You got to remember those words. I do not consent to being prosecuted here unless he can show his delegated authority, because he don't have the authority. So it must have been delegated. And I want to see it delegated because I know that the Congress can't delegate any of their authority. And I don't think that the governor can delegate any of his authority. And I don't think the judicial power, the Supreme Court, delegates any of their authority. Because all agencies are unconstitutional in themselves. They're outside the Constitution. They're outside of it. They're just an agency. They're just like another person. And so where in the government Constitution did it give them any authority to do anything? That's the question. Where's their delegated authority to come to court and prosecute me?
Hey Zeke, do you have a case site for the argument that if there's no delegated authority, then then they don't have the that power?
Well,
Well, are you saying nobody has the power to enforce the laws?
what law? What law are you talking about? Be specific, because there's thousands and millions of laws.
There's a law in the
Pick
state
one.
of California called the child support law that says both parents are equally obligated to support the child.
Okay, yeah, they can't.
So
They can't.
nobody's empowered to enforce that.
Well, they can't enforce it against me.
That's Title 4D.
They can enforce it, but they can't enforce it on me
Why, if you're a parent?
because they don't have any delegated authority to do it against me. Now they can do it against you.
Oh, how does that work?
Well, because you're a parent and you comply with their rules and regulations
Identify as a parent. You accepted the label of parent.
and
the
more
office of parent.
and more. It's not just that. You let them. You didn't challenge them. That's why they can do it. If you don't object, you agree. every presumption of law is rebuttable. So it's a presumption that those are laws applicable to me.
Well, there would have to be a presumption that they're just elected officials. And they
Well,
would just have to be a presumption
I,
that they got
I would have
voted
to
in.
agree. I would have to agree because I think
And
that
then
there
it
is
would be
election
a
fraud.
presumption that your vote mattered.
Well,
And
that's
that everything in life just, I
That's
look
right.
outside the door as a giant presumption. It's
So
not a
what's the
real
law?
problem.
That's right.
What's the law on the right to work?
Well, that would be the right to contract.
It depends on your chosen profession. Is
It's
it
the right to
regulated or
contract.
not?
That's the law.
If you want to go work at 7-Eleven, it doesn't require a health and safety
Yeah,
permit.
that's an
It require a license. But if you want to
Does
go be a building contractor, then you have to have a license. If you want to go be a nurse, then you got to get a license.
If
If
you
you
But
want
don't
to
they
work
say
in the
anything
system,
that is
Randy,
regulated in terms of employment, you have to comply with those regulatory licensing requirements.
Doesn't the Constitution state something about a license? A license is only for something that's illegal to do.
no, that's a definition in the law dictionary, but that's not Constitution.
Okay.
And I wouldn't take that to heart either because
We have a God-given
you
birthright
gotta
to work.
remember there's anytime you use a word or say work or drive or do something, there's
Yeah,
always the other side. Or crime.
Yeah,
Is it a crime? Well, there's two definitions of crimes.
yeah,
It's a book crime, then it's a book crime. If it's a real crime, it's a real crime. And there's different laws for the different crimes.
yeah,
So you have to be distinct, but you have a right to contract, that's liberty.
yeah.
State that has to have some interest in getting into it.
Well,
And
laws
what's
are
their interest?
laws are not only penal or criminal. They can be regulatory and civil
right.
in nature with civil enforcement remedies.
And the government can't regulate the free man.
No, but the government can regulate certain professions for public safety.
That's true.
That's why you can't. That's why you can't
Well,
put
the
your Ford.
presumption they can regulate professions, but and
you
whether
can't-
it's for safety or not, that's rebuttable. Remember, because these guys may not really be elected, and your
You
vote
can't
may
park your
not really
Ford
count.
Bronco. You can't park your Ford Bronco on the corner, put a cardboard sign on the back window saying, "I pull teeth for a living," and say that's my job, and then sit there with a pair of vice grips and remove people's teeth in the back seat of your car. It's regulated
Who
for
would wanna
public
do that?
safety.
Who would want to do that?
Well, now it's a question of who, look, who wants to do anything. If you want to do anything that is regulated, that's your first problem, is you have to deal with the regulations, or you get
profession.
what
Regulate
he's
the
got.
profession, not the individual.
You've got people attacking him for doing something that they say needs to be regulated. They're not going to go away.
People say needs to be regulated. Well, that may or may not be true.
Yeah. Anything that makes money, they want to regulate it.
Of course,
all.
that's the Commerce Clause.
Well, that's
Yeah.
not what they say. They don't stand up and go, "Hey, this makes money. We're going to regulate it."
But Randy,
They stand up and say, "Hey, this could be a public safety issue. We need to
here's
regulate
another
it. And in
misnomer.
doing that, we can make money
you
on the
got
side."
another misnomer there because you didn't define money, because everybody today does stuff for debt, not money.
Well,
Well, I think people
you
turn
can
into
argue that as well. And if you go and lose $1 million lawsuit, they're not going to order the other side to pay you in gold and silver coins.
Well, we're going to find
They're
out.
going to give you $1 million cash dollars, U.S. tender
We'll
currency,
accept that.
and call that. Well, see what
We'll
I'm saying?
accept it. We'll accept it, but we'll still
It
ask for
can't be
gold.
both.
We'll
It
still, yeah,
cannot
you
be
can do
both
both.
simultaneously.
You can do both, and if they don't want to pay the gold, we'll accept the paper, as long as it's worth something. But
So what
remember,
about
gold has value?
people identifying as males and females or transgenders, and that's not a public safety? I feel that's public safety.
Of
I mean,
course.
that's a mental
course,
health
but that-
issue.
But that's
They
your
should be
opinion,
walking the
Randy.
streets. They
That's
should be
your
walking the
opinion. That's your opinion, and no one's going to believe you. Now, if you walk into the courtroom in a dress, then some people are going to believe you, and maybe they'll try to get a whole deal going and say they can't prosecute you because you got a dress on. And they do that with, they let criminals off that claim to be gay or transvestites or something because they like that. But if you really are one, then I think you can get off.
So I'm gonna dress up like fucking Picasso and go there and say I'm an artist.
Well, no, that's not good enough. You got to be a transgender. You got to be with the woke society deal. He wasn't a woke guy.
So I fucking dress like, so I wear a dress. If I wear a dress, to fucking wear a dress there.
Yeah.
Fuck, that's crazy.
LGBT,
You're
you gotta
absolutely. I guarantee it. It fucking do.
LGBTKK.
Yeah, I guarantee it would work. It would work 100%.
I know it. It'd work, but it's not law.
So
Yeah,
how
because-
much did the guy donate the other day for the haircut?
I don't even know.
Zero. I'd say zero. Zero.
Yeah, I don't even know.
Well, it's what are those notes worth?
Okay, well, hold on. Let's go one step further. Whatever he donated, where did it go?
Where did it come from?
Yeah.
Well, it came from him. He walked up, he took
Well,
a shot,
I think
he went
I'll
to
tell you
the
where it
app,
went. It
he
went
put a
into
check in the
contract.
box, and then he went inside and he got something and donated something. And what did he donate and where did it go?
Yeah, there you go. Now we can do a whole series of economics and how money flows. And that's a good point because we need that money circulating because maybe that money went to give a cab driver.
It's actually going to a backpack drive on the 26th. That's the day before court. We're doing a backpack drive. It's our 13th year doing it. We're doing free haircuts and free backpack drive. So the money that people have been donating recently is going towards the backpacks. I actually bought about 340 backpacks.
Well, how are
So
you
that's
doing free? How are you doing free haircuts?
There you go, Jay.
Oh, no, I'm doing haircuts off donations and gifts, and all the proceeds have been going to buy the backpacks.
So
There you go. So you got to really learn the language, but the bottom line is they can't impair the obligation of your contract. They need delegated authority to bring a case against you. That's where it starts. It's the power to bring the case against you.
Yeah.
Okay.
I'm sure that's probably in the jurisdiction section of their complaint.
Exactly. And the jurisdictional power in their complaint means that the plaintiff has to state their right to relief. Okay, and their right to relief can't be delegated, right? It's got to be them because they're the ones in court. And if they're representing somebody, then who they representing that's entitled to relief?
The people of the state of California, isn't that how your
Okay.
complaint reads?
Well, then bring them in, subpoena them in, and put them on the stand. Because I don't think they're entitled to relief. They're not making the claim. This guy's making the claim for them, and he doesn't have the authority to do that because they didn't delegate it. Where did they tell him to go to court?
Yeah, where's the person that's bringing me up on charges? The person in the public that I've harmed or hurt or gotten sick.
No, where is the plaintiff state on the complaint their right to relief? That's what you just said. That's how you say it.
It's in the
That's how you
barber's
say it.
code.
No,
And
it's
it's
got to be on
also,
the face of the complaint.
we read that. It delegated the authority
No,
to
the
the
right- you
chief
can't-
guy of the barber code,
Okay.
president, board chairman, or whoever to authorize. And as part of that, he can assign it then to the district or to the
Barber,
attorney
though.
general for enforcement.
I'm not a barber. I'm an artist. Identify as an artist. I'm not a
Where is
barber.
their right to relief stated on the face of the complaint? The right to relief. What does that mean? That means that why they can make the claim. Because they're making the claim, not the attorney. The plaintiff is making the claim. Now, if the plaintiff doesn't have a cause of action, then the attorney can't stand. The cause of action has to be stated in the plaintiff, and it's got to be on the face of the complaint. So the claim for relief, the right to relief, and a short plain statement of the jurisdiction of the court. And what is the plaintiff's claim right to relief? They're claiming a violation, they're claiming, but what's their right to relief? Show the injury or the damage or allege it.
Mm-hmm.
Not, well, we might, maybe, possibly, could be. No, gotta have it. It's already has to have happened. You only get a right to relief if you're entitled to the relief. And to be entitled to the relief, you have to have a cause of action or standing to sue.
All right, here it is right here. They give the introduction, the parties,
Yeah,
jurisdiction
Jurisdiction.
and venue.
yeah. Okay,
135.5
factual
of
allegations.
the BPC.
Factual allegations.
They're saying jurisdiction consistent with Article 6, Section 10. Code
Okay,
of Civil Procedure.
Okay,
10.10.
okay. Okay, but what are the three things of a complaint? You got the
Plaintiff is
jurisdiction.
informed and believed.
Yep. Okay, so there you go. We got a belief. So that's rebuttable. But it could be a fact. Okay, keep going. So where's the fact that entitles them to relief? He did all these things. Okay. So when you find
Well,
that,
they're pleading a violation of these code sections.
yeah, he did them.
And
He did them.
yeah,
He did them. And you
unless
know what?
restrained and permanently enjoined,
Yeah.
defendants will continue to violate the act.
Well, we're not, remember, you rebutted that. You rebutted that in your presentation.
The board and consumers will be irreparably injured.
Oh, here we go.
The board.
Now
will
I want
do
evidence of that.
remedy
There,
at
right
law.
there. That could be their claim. So this is a rebuttable presumption right here.
Okay, there you go.
I want to see some evidence up front. Remember, you were talking about that.
All right, so that's, this is their complaint. So let me share the motion.
Yeah, that's their claim.
Well, that's the original complaint. Now to see
Yeah, complaint is
what we're
called a
responding
claim.
to right now is their motion for preliminary injunction.
Right.
And
Let's look
so
at your
let's see.
opposition to it.
Well, we will in a second. I want to look at this first.
Okay.
So
All right.
they're saying they filed a verified complaint. And defendant has a stubborn refusal to obtain licensure and has left the board with no choice but to seek injunctive relief from the court. And so the motion is based, so that's their impetus here, is that the defendant's stubborn refusal to obtain licensure has left the board with no choice but to seek injunctive relief. So that's
Because they're being
now
injured.
they're
Said they're being injured.
so well, let's see what they say about that. That's what I wanted to come here to see. So and continues to provide barbering services. There's more background. Argument to protect the people of California. Injunctive relief may be granted based on a verified
There it is.
complaint showing sufficient factual grounds for relief.
Oh, sure.
Yeah,
The
court must
know this COVID. You judges should know this COVID was all bullshit
they do.
by now.
They do. Remember, they're
That's
all
not
corrupt.
Traditionally, the court must evaluate two interrelated factors when ruling on a request for preliminary injunction. The likelihood that the plaintiff will prevail on the merits at trial and the interim harm that the plaintiff would be likely to sustain if the injunction were denied, as compared to the harm the defendant would be likely to suffer if the preliminary injunction were issued.
Okay, so we don't want to go with some traditional look. That's taking us off point.
Well, we went back and forth on this a whole bunch, but the point is that, you know, we focused when we argued this back then is same thing, Zeke, you know, what harm is going to come to the public?
Right.
And we didn't articulate, we didn't have the time or the experience to put together a paper to articulate that for Snapdragon. Now
Okay.
here we kind of did, and we'll pull up the opposition document in a second,
Yeah.
but they bring up the IT Corp rule.
See, but remember, we're also going past the initial objection, because they're just talking about how you look at an injunction. We're saying that there's no grounds for an injunction.
Only if grave or irreparable harm can be shown will the court proceed to examine the relative harm to the actual parties. So that would be the defendant. Rather, a rebuttable presumption arises that the potential harm to the public outweighs the potential harm to the defendant. The burden, therefore, is on the defendant to prove that he would suffer grave or irreparable harm from issuance of the preliminary injunction.
Yeah.
Only if
Remember, we
so
said
that-
he would.
All right, and so then their argument, okay, so
There it is. And what is the harm? What's the grave and irreparable harm that Randy's going to suffer if they do it? What is it, Randy?
What's that?
What grave or irreparable harm is going to come to you if they do an injunction on you?
I don't know.
Well, your constitutional
Okay,
rights
well,
going to
here-
be violated.
all
Yeah.
right, I'll tell
And
you
that's
right here.
that's the highest standard of law that we have in this country.
Okay, Randy, do you see the screen?
Yes, sir.
All right, go ahead and read it. Go ahead. This is your opposition paper. So read from the
That's to the-
introduction.
That's not to the complaint, that's to the injunction.
Oh
To
man,
the
I'm
injunction, yeah.
Remember?
sorry, guy. I'm in my car on my cell phone, and I can barely. I'm trying to zoom in.
Oh, all right, hang on. Let me see if I
Let
can
me see.
zoom it in a little bit more. Can you see that better?
Yeah, it's just. Oh shit. Defendant Randy.
All right, I'll read it. Never mind. That's fine. I'll read it.
Yeah.
Defendant Randy
sorry.
Mitchell, respectful. Yeah, that's all right. But you need to take the time to read it, and we need to
Yeah, I
talk about this, by the way. 'Cause
Yes.
starting tomorrow, you need to start taking seriously the model that you laid
All right.
out in your
Well-
declaration. Defendant Randy Mitchell respectfully opposes plaintiff's motion for preliminary injunction. Plaintiff seeks to enjoin defendant from operating his private social clubs, which he converted from his former barber shops after the revocation of his licenses. However, the social clubs at issue do not provide barbering or cosmetology services to the public. Rather, they are private membership associations entitled to constitutional protection, and plaintiff has not established that licensing statutes apply to their selective membership and activities hidden from public view. Plaintiff also cannot satisfy the heightened standard for imposing prior restraint on defendants' freedoms of association and assembly. Finally, the balance of harms weighs decisively in defendant's favor, as the proposed injunction would inflict irreparable harm by violating fundamental constitutional rights of defendant and his members if plaintiff's overbroad proposed injunction is granted. Defendant therefore respectfully requests the court deny plaintiff's motion. Statement of facts: after the revocation of his barbering and establishment licenses, defendant converted his former barber shops into private social clubs. Defendant recently obtained federal 501c3 tax exempt nonprofit status for his clubs, further confirming its purpose as a private membership association rather than a public-facing business. These clubs operate as intimate associations between members who share a common passion for barbering arts and skills. Defendant considers the clubs a fellowship of artists devoted to the craft of barbering. The clubs aim to unite individuals from diverse backgrounds through their common interest in barbering and provide members opportunities to develop their talents. Membership is selective based on criteria identifying individuals who share this passion for barbering excellence. Clubs are not open to the general public. Only members and invited guests may enter. Prospective members go through a selective process designed to evaluate their genuine shared interest in barbering arts. Barbering or cosmetology services are not advertised to the public in any way.
See, that totally goes against the guy coming in the other day.
Clubs' websites provide no indication that services are available. If members provide barbering services to each other, they do so voluntarily. The guy did trespass. Members bring their own
Yeah,
tools and
maybe.
equipment.
See, that didn't happen either.
That's right. And these are all, these
No
are
one's
all,
testified to that yet.
these are all,
Did they ask
you
that?
know, things that.
So I can't suggest
They
you
asked that?
you
Was that
sign that.
question asked? I don't remember that question being asked. Members bring their own tools and equipment. Defendant ensures the clubs comply with all applicable laws. The proposed injunction would cause irreparable harm by violating the members' protected rights of association. The
There
club
it
must
is,
reflect
right
an
there.
Intimate fellowship around their shared passions.
Add
Argument, a
Article 1,
plaintiff-
Section 10 to that too.
Plaintiff fails to show the licensing statutes apply to defendant's private social clubs. Plaintiff argues defendant is violating Business and Professions Code sections 7317 and 7347 by providing barbering services without proper licenses. However, the social clubs at issue are private membership associations, not public-facing establishments subject to licensing requirements. Defendants clubs have selective membership policies with access limited solely to individuals sharing members' passion for barbering arts. The club's activities
Okay, hold
are
on right
exclusive-
there. How does that guy that walked in the other day fit into that statement? He came in, he didn't bring his own stuff, he got a haircut, he left a donation and he walked out. How does any of that fit into artistry? He's practicing his art, or he went in and he got a haircut
Barbering
is
arts. He came
essentially
to-
all that happened.
He's a member of a collective of people who appreciate the barbering arts, and so he came to share in that passion for it.
You
Okay,
can't presume that on his behalf. He just went in and got a haircut. They told me I needed to click the check in the box and go to this app so I could get a haircut.
And basically read the literature and check the box saying that you agree that,
yeah,
that's what we're doing.
there you go.
You can't agree to something that isn't legal.
It's all legal. It's all legal.
Let me
Legal
read on.
about anything they did. Now, whether that's true or not, that they brought the zone or they have to do this, you can bring all these arguments. That's what it says at the top 3, argument. So you're doing arguments, but remember, that's really, all this is just argument once you're already there. The first argument is, where is their authority to bring the case?
Well, I'm again saying if you sign that under penalty of perjury and that guy came in and did that the other day and he testifies to it, you could be looking at perjury as well.
No, no, because you have stuff that you lay out that everyone has to bring their own, and a guy didn't bring his own, and then something else happened. You know, you may or may not be liable, but he ain't going to get you for perjury because
There was a
there's no
mistake in
perjury in this
protocol.
testimony of an affidavit that says.
Well,
that
he
the word
said,
is
he said he specifically oversees that the laws are not violated.
and he does.
Well, did he? Did he ask the guy if he brought his own? Did you ask the guy if he brought his own barbering tools?
No, we're the artists. We're the one doing the artwork.
Yeah, the guy who did the artwork brought his tools.
Yeah.
You know, then maybe not. You're not going to get perjury out of this. I'll tell you that. Ain't gonna get perjury. Because he's not responsible for everything. He's responsible for making sure that the laws are being followed. And you know what? That's the purpose of the Attorney General and the FBI. And look
Yeah,
at they're breaking the laws right and left all the time. So busy breaking the laws, they're going to go after everyone else for doing it.
Were you there when the guy came, Randy?
Yeah, I was there.
Both times? Because you said a guy came, two different guys came?
Yeah, I'm posting a picture right now. I'm trying to post a picture on this thing
This
here.
isn't the case. This isn't the case that involves that. This doesn't involve any of that stuff. This is a general case. We got to talk about this case, not the next case.
So if you
Oh, no,
could
they're gonna be
see
bringing, you can count on their bringing both of those people in.
oh, look at, I just seen you the picture of the one guy, he's standing out front, you see the badge on his hip. And he walked up, he read it, he looked at it, he scanned the QR code, downloaded the app, read through the stuff and turned around, walked away, got in his car and left. He didn't come in.
There you go.
But the first guy did. The first guy just ignored it, came in, sat down, and I'm like, "Hey, how you doing today, sir?" "Oh, pretty good, man. I just need a haircut." And I was like, "Oh, well, are you a member here?" And he's like, member? No, I'm not a member. I was like, "Well, can you go back outside and read the sign on the door right there? It's for members only. This is private property."
Yeah, you want to join? You want to join?
So I said, if you want to would like a haircut or something like that by one of the artists or whatever, you have to become a member, or and make an appointment.
And then,
To get a
and
haircut.
isn't it in the bylaws that you have to cut the hair on the upside or the downside or the right side or the left side, or how's that?
Randy,
Or does
where's
each
that?
individual
Where-
does each
why-
individual
how
make
come-
that decision?
What's that?
it's not out of public view. This guy is, I
Yeah, I know, man. I'm gonna take a week off of fucking work, and I'm gonna go and fucking I'm gonna spend another couple $1,000s and tint these windows. That's what I'm doing. I got the tint. I got to do it. It's just, man. It's just, this is the thing. It's just so fucking hard to
Just put up
carry on
some
with
paper. Just put up butcher paper.
Yeah, I could do that too. I put some fucking birch paper. Look like shit, but yeah, I know. I need to do it. Yeah,
Look, I'm gonna be totally honest with you at this point, Randy.
yeah. I'm gonna do it.
Talking to- hold on. At this point, I was talking to Cliff about this. We went through the same thing with Cliff. With Cliff, it
Yeah.
was too little, too late. By the time he did all the changes, they had already gotten all the evidence they needed, and that's what they used in the case. Now, in this
Yeah.
case, I was telling you to put up those cover those windows or whatever from 2-3 months ago.
Yeah,
And you submitted this opposition document. You said a bunch of stuff in it. They came out
Yeah.
and they checked you on it, and they found that you weren't doing what you said. It's not out of public view. The guy got invited in. He got a haircut. It wasn't selective membership.
he didn't get
That's just-
invited in. He just walked in.
Look,
Yeah.
that's just the facts, dude. We can try to oppose it. We have to see what they're gonna come up with. They're gonna have
Yeah.
something in a couple more days that they gotta, they're send out an opposition document. They're gonna serve it on you. And so
Yeah,
we're gonna see what their opposition is, and we're gonna see if they put in this new evidence, and then we're gonna have to figure out how we're gonna oppose it. But from here on out, I
Okay.
mean,
yeah. That's something tomorrow. Tomorrow, my thing is I'm just gonna go, and I'm not gonna go back to work, and I'm not gonna work. I'm not gonna fin for. I'm gonna go and
but you gotta
cover
tell
all
these
these.
people, that from now on, when they sign up for a membership, they don't get admitted, they get an appointment to get
Yeah.
evaluated for membership. That's the new rule.
So I don't understand how do we do that? This is the problem. This is the thing. So I have to evaluate people. Like I don't have. I don't have time to sit here and evaluate people. You know what I'm saying? And neither do the
That's-
artist. I mean,
That's the
There's
whole,
50
that's how the court, I'm only telling you how the courts interpret what is truly a selective membership, an intimate association. It's where you sit down and you talk to the people and say, hey, look, this is what we're about. We're not about just, coming in and getting a haircut. We're about enjoying the expressive art of haircutting and blah, 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 and yada, yada.
can I put a poster or something? Like how they have you do it and put the federal guidelines on walls at workplaces for workman's comp thing. Can I put a big old thing on the wall? It basically says, hey, this is who we are. This is what the fuck we do. Read that. You know what I mean? Because,
doesn't even
Every
begin
wait a
to
minute,
satisfy-
wait, Salam, wait a minute. All the questions you're asking,
yeah,
everything that Michael and Salem are telling you,
yeah,
if you really, and that you're talking about all this work, doing all these things, jumping through all these hoops. If you
Yeah.
really want to know, you have to ask the district attorney all these questions. You have to ask those guys. And
Yeah.
they still are gonna have, every one of them's gonna have different answers. Cause because they don't know, and the next guy's gonna prosecute you for this, and they're gonna be lenient if you're like this, and we can make a deal, and then, and you may end up doing that and having to comply with and working out a deal.
Yeah.
Because the fight is not that. You can fight all day, win, lose, draw, keep going in circles. The other side of the coin is challenging their authority, like I'm
Yeah.
saying, so that you don't argue all these things. And if you can stop them from doing it, then you can do whatever you want to do.
Yeah. That's why, I mean, shit, man, it's just so confusing because it's like, you hear we're in America, land of the free, home of the brave, constitutional, this, that. Everyone's fuck, it's not. I don't have.
It hasn't never been that way. That's the illusion everybody's been fed, going back to my great grandparents. And the problem is they all believed it all these years. And then our generation comes around and says, this isn't right, and we don't believe it. And now we realize we're the victims of those decisions. And the history is what has enslaved us. We've allowed it to get like this. We're overregulated, overtaxed, overfeed, over everything, dude. And they just keep raising everything around us. Hell, we can't even live paycheck to paycheck anymore. It's by design. But we've let it get like this. Our elected officials that we go and vote for, and not me because I don't vote, but that's how it got like this.
Right.
Everybody
So
went and
that's
put
why this
Jackie
is gonna
Spear in
be
the Senate,
Randy.
and she wrote
That's why
Senate
you're
bills,
gonna
and they
need-
passed them into laws, and those laws enslave us.
That's
And
why you're gonna
Randy,
need to get hundreds of
that's
people
why-
showing up at the courthouse.
that's why you
on
have to
that subject.
question authority first.
Well, yeah, that's what we're gonna have a couple hundred people probably show. They're gonna be
If you
showing up.
don't question the authority, well, hundreds of people isn't questioning authority.
Well, we're questioning the judges and the rulings. We're questioning.
Well,
We are
you
questioning.
can do all that, but you got that's that. But the authority to take you to court on this case,
Yes.
if it's not determined, then they'll proceed.
Yeah.
So you have to tell them, look, I want it written down, the delegated authority of that attorney, the attorney general, to prosecute this case against.
Well, why can't one single person just go get a barber's license and hang it on the wall?
Because they want every person in there to have a barber's license, and establishment license, and a business license,
Establishment license,
and a fucking
then-
animal license. You know what I mean? License. They want everybody to have
Establishment
everything.
License, and then the establishment allows.
Well, then your
to
challenge
regulate
isn't really
the
about being a barber. Your challenge is about the government's ability to regulate and license.
So they took a
That's
bunch of
where
our
I think you're
licenses.
making a mistake. Remember, you're not challenging any of that because they're doing it. You're only challenging their authority to take Randy into court on this case. Where's that authority? Doesn't have anything to do with licensing about barbering or artists or any of that. It's this case against Randy in this prosecution. The authority of
That's
the
what it all is. It's all right there stated in the jurisdiction and venue, and then the allegation. That's everything they're saying. This is what it is, where it is, how it is, and how we're doing it.
And we got there. The right to relief is that the board will be injured. Now that's the presumption. That's what you got to work on rebutting it. And there's a couple things that Salam had, but you need to add more to it because rebutting that presumption is saying, okay, if the board is going to be injured, I want them to state what their injury is, and not that it's gonna be what they have received an injury? Have they already been injured? And what is it? And how are they going to be injured? And what is their irreparable harm? They said it, but now they need to bring forth some evidence or allegations of that fact. What are they going to bring?
Yeah. So that's
Well,
Fuck, I wish I would-
find out in about 2 more days here.
And
5.8
that
is
allegation,
done.
remember, you're not doing it in the case. The allegations need to be put on the complaint. That's called the right to relief. They have to state their right to relief, and they said that they're going to be irreparably harmed. That's what they said their right to relief is. We're going to be irreparably harmed. Well, how, where, what, and when? That's where you ask them to show it. Because if they can show, then that will give them the authority to bring the case. The right to relief. Because otherwise, if you lose this case and everything goes down, then you should pay Salem. Right?
Yeah.
Well, why should you pay the estate? Why should you pay, who's the board? Yeah, you'll pay the board, but how much is it? How are they going to be irreparably harmed?
Yeah.
They can't state a claim. They're not stating a claim. And that's what they failed to state a claim upon which the court can grant relief. When there's no cause of action stated in the plaintiff, then the lawyer can't plead. He doesn't have any standing to plead. He doesn't have a cause of action. The lawyer has to shut up because his plaintiff has to have a cause of action. And Michael keeps saying it's the people of the state. And what's their claim? That you're violating something? No. What's their right to relief?
They're claiming. They're
What's
claiming
their right to relief?
They're claiming he's violating the Barbary laws.
Okay. What's
They're
their right to
claiming
relief?
hold on. They're claiming he's violating the Health and Safety Code.
Yeah.
They're claiming he's violating the Business and Professions
That's
Code.
right.
In each of those sections of law, there is authority for them to seek this relief.
And the relief,
Just like in the Cliff case.
and the payment should go to Salam. The payment should go to Salam because they're not stating any reason why it should go to them.
They're the
stating,
ones
well,
that have jurisdiction over the area.
they're claiming the relief. They're claiming the relief, but they're not claiming the right to relief. See, the allegations of doing something.
I believe he read the few famous words of something about the public health, the threat to public safety.
I don't see it.
That's their irreparable harm and injury.
They say that about everything. That's
I
crazy.
know, of
Okay,
course.
is
That's
there
their
any?
dig in the bag.
What's
They
the
tell
offer of proof?
the courts that as the government, they can trample over your rights because of the right to protect all the people.
What's
It's
the offer
greater
of
than your
proof?
individual right to harm
What's
people.
the offer of proof?
And
That
so
they're-
they have to act in this presumptive manner.
What's the offer
preemptive.
of proof that they're entitled to relief?
And if they say, hey, we know he's doing this, and now we got somebody that went in there and had it done,
Yeah.
and none of these other conditions are being followed, that's a violation.
Then Salam should be paid. Then the money should go to Salam. Because what's the right to relief? What's the evidence of their right to relief? Why should they pay? Why should they pay the state? Why should they pay the
Well,
people? Why should they pay
It's a
Salam?
it's a statutory basis, and again, it comes down to the
Yeah, it's a
obligation.
civil penalty. It's what the government does. The government has the
Yeah,
right to
because
that
you let
relief. It's in the written law.
Because you let them, and you let them because you start getting into arguments like these guys are raising. You
No,
gotta
it's because
tell 'em, I need
people
you to
voted.
Show
It's all
me.
just because people voted for other people who went and created these
Michael
laws.
didn't vote.
And these laws that got created, they
No, we don't
encompass
vote
us.
laws
They
in.
enslave us.
Yeah, we don't vote laws in. This ain't no majority rule. This ain't no
That's exactly.
democracy.
That's
It's a
exactly.
republic.
As amended by
rule
the
of law.
legislature.
Rule
You
of
read
law.
it all the time, as amended by the legislature.
I know how they do it.
Somebody brought up the amendment, everybody voted on it, it passed or it failed. If it passed, it reads at the bottom, as
There you
amended.
go. That's right. Roe versus Wade. Yeah, we got it. How could it possibly be overturned with what Michael's saying? It's impossible. Law's the law.
Road versus who? You
Roe
said?
versus Wade.
Roe versus Wade, that's the abortion.
Well, again,
That's
I
the
think the
abortion.
most troubling thing is the guy that came in the other day and the cop standing at the doorway the few hours after. That's just too over the top.
What do you mean?
It's like the last nail in the coffin I see. Just like Cliff.
Papa standing there?
Absent getting the license now and somebody in there with all the regulatory compliance, it's gonna get the injunction.
Yeah, here's, I'll share my screen.
And you
here.
know what? When Michael says that, they have to give it because it has to go to review because the lower court doesn't rule on that stuff. They assume jurisdiction, and when you challenge their jurisdiction, which is fundamentally challenged when you challenge their claim a right to relief, okay, so they're gonna deny and do it. That's why you're gonna have to take it up on the judicial review, what we call the writ of mandamus. Okay, so that's what you're preparing for. That's where you're ready to go. Because did you demur to this thing? Are you gonna do? Did you demur to? Well, you can answer.
We have to answer, we have to do all that still yet before it gets defaulted. That's the next step here.
But your answer can be in the nature of demur, challenging the jurisdiction, as well as other answers.
Yes, that's my fault for completely forgetting about the deadline on that. So we gotta put
Okay.
that in soon. And then the
Well,
cross complaint. So we'll do demurred probably by tomorrow and then and then we have to put in a cross complaint. That's the only way we're gonna. We need to be able to derail this hearing on the 27th.
Getting tired. Michael was taking some deep breaths a little while back, and I'm getting tired.
And that's,
Yeah,
that's not the way to be arguing law. I'm never at the table taking a deep breath in open court.
Just before you go in, huh?
Never let them see you sweat.
That's right.
I do want to adjourn the meeting. So
Hey,
unless there's anything
before
else
you,
that you said.
yeah, before you do, let me throw one comment about
Go ahead.
Article 1, Section 10. And my comment is Article 1, Section 8. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or office thereof. So I call that the necessary and proper clause. That basically says they can do whatever the hell they want. Whether it impairs the obligation of a contract or not, or anything else. It doesn't, they can do, that clause says they can do any and everything and not even give a reason, basically.
Well,
Anyway,
Article
that's
2
my-
says anything that's not contained otherwise herein is left open to the states. So if a state has contract law, a state defines what the elements of a
Unless
contract
it's
are.
necessary and proper for them to say fuck you and go right over that.
Here's what it says under this.
That's what we vote them in for.
Congress.gov. So this is on Congress website. Clause 18, necessary and proper clause to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. All the power is vested by this Constitution in the government of the United States or in any department or officer thereof. And then we have these articles.
See right there, department or office. They don't, Mike just said that's what we voted for. You can vote for those guys.
Here's modern necessary and proper clause doctrine. Let's read that. Building on the foundation established by McCulloch modern necessary and proper clause doctrine holds that the clause permits any federal legislation that is convenient or useful to the exercise of federal power. That is, any means that is rationally related to the implementation of a constitutionally enumerated power. The significance of this broad understanding of McCulloch on the powers of the federal government is difficult to overstate. Much federal law rests on the foundation established by McCulloch, and practically every power of the federal government has been expanded in some degree by the necessary and proper clause. Under the authority granted it by the clause, Congress has adopted measures required to comply with treaty obligations, organized the federal judicial system, regulated intrastate matters that substantially affect interstate commerce, seized property pursuant to its taxing powers, and exercised the power of eminent domain to acquire property rights for public use. Perhaps most notably, nearly all federal criminal law that applies outside of federal enclaves relies on the necessary and proper clause. The Constitution expressly empowers Congress to punish only 4 crimes: counterfeiting, piracies, offenses against the law of nations, and treason. The remainder of the federal criminal code, prohibitions on, for example, tax evasion, racketeering, mail fraud, and drug possession, rests on a determination that criminalization is necessary to effectuate congressional power to regulate interstate commerce, collect taxes, establish post offices, spend for the general welfare, or some other enumerated federal power. For example, as necessary and proper to Congress's authority under the spending clause, Congress may criminalize bribery of state and local officials receiving federal funds. Or as necessary and proper to its power to regulate interstate commerce, Congress may prohibit intrastate cultivation and use of controlled substances, such as illegal drugs. Shall I continue?
So
Go
we're
as far, yeah, go as far as you want.
just talking about total corruption, as we already know.
We'll go to the 10th
Well, I think
Amendment.
the key was back here.
10th Amendment is for the people.
Yeah, exactly. ... What's not in here is reserved to the states.
Or to Zeke.
That's why Washington
Right.
DC and the US government doesn't tell California how to issue their driver's license or what's required. But they do have requirements that if you want to receive federal funding from the Federal Highway and Safety Administration, that you have to do these particular things. And the state can enter a cooperative agreement with the federal government to get those dollars, and they will then do those things.
So is there anything that the state cannot regulate upon the people?
Fuck.
They can regulate whatever they deem necessary.
There you go, see? You know what that's called?
Because we voted them all in to do that for
Yeah,
us.
I know, and the Constitution gave us freedom. That's called freedom, Michael.
Well,
That's
and then
called
and then
freedom.
it's you elect people to go give it back, little bits at a time.
Mike, we didn't elect them. We didn't
Somebody
elect.
did.
We didn't vote.
We didn't.
Somebody did.
No, they were appointed, or they were hired, or they had nothing. The voters had nothing to do with
But there
Well,
was
hold on,
90% of the
hold
people
on.
you're dealing with.
You got to go back further in the string. Those that are not elected are hired or appointed by those who were elected, who we elected.
Yeah. Okay.
yeah.
You
Well,
think
look, how
so.
did they all get there?
If
How did
you
all these
think
agencies
so, what- who were your-
form? How did all these
who were your-
agencies get formed?
Who were your
I don't-
choices? Who were your choices to vote for, and who picked them?
Yeah.
That's how their process works. They call that democracy.
That's how the process doesn't work.
That's right. Unconstitutional.
Well, that's your Declaration of Independence, your Bill of Rights, your Constitution. It's all those things all wrapped up together. You're right.
Oh, but look
It's
how
all
you-
an
look how-
illusion. It's all an
Look
illusion.
how you interpret the Bill of
Hey,
Rights.
now we're getting somewhere. It's
Bill
a
of
religion.
circle. It's all a circle of illusion.
Michael said the
Assuming
Bill of
that
Rights
they're
means the Bill of
using
No
the
Rights.
necessary and proper clause to regulate barbering, there is no necessary and proper clause in the California Constitution. In
Huh?
fact, there is
It
no.
doesn't matter. It doesn't matter because it's all, California is
it's stuck
just
in
a
there somewhere.
franchise of DC.
It's stuck in there somewhere.
It doesn't matter.
Exactly.
Well, except in your case, or in my case. And
See,
in
the
Randy's
federal
case, if
government is
Randy
the
stands
holder of
up,
all the states.
because no one
and all
ever
the
challenges
states are just
Randy,
the
no one challenges
extension.
their authority. Michael would never challenge their authority. He plays the game and beats them at their own game. But he will never
Well-
challenge their authority because he believes.
That's and that's a good way to do it, actually. I
Yeah.
mean,
I know.
it's my claim is it's a religion. So my first question is, do I have freedom of religion? You
They
know,
regulate
ask the
religion.
judge. What's he going to say? He's going to say, no, you don't.
That-
Then I'm going to say, can I force you to follow my religion, or can you force me to follow your religion? And what's he going to say? He's not going to say, well, yeah.
the problem
Um,
is you're talking to the
I would
judge.
ask,
The judge-
what
the judge isn't the one
sincerely held
in
belief
charge
do you
of-
have?
So you're off point already. You need to point over to the prosecution and ask him those questions, not the judge.
Well, yeah, okay, I agree. And actually, I think I'd ask them both.
Well, okay, but I mostly point to the prosecutor because what's he doing?
No, I get you. I
When he's
get where
in
you're
the
coming
courtroom-
from.
when
Yeah,
he's in
yeah,
the
that makes
courtroom,
sense.
You can prosecute his ass.
Right, that
About
makes
that?
sense.
Cross complaint in fact. Hey, Judge, before we start, I object to this guy standing here and I want to see his authority to be here. Because he's just an attorney.
Oh, well, that's always a good thing to do. I mean, because chances are he's actually acting in his private capacity, and he's afraid, you will ask that.
That's right. Because he doesn't have any authority. He's just acting. He's an attorney. He got
Right.
bar license, Michael. He must be impotent. So, but you
Yeah,
got
they're just
about these things. Randy, he's got a good chance, but it's tough. You got to think like that you understand, and which I know Randy does. But it's not, hey, they do this and they do that, and they shut me down for this, they shut me down for that. This is straight out, attack on you and your rights. Back to going to jail and shit. This is jailhouse law. What the fuck is this guy doing here? Who is he?
This is business and politics.
That's right. Well, we don't. Us people that know what business and politics is, we know that ain't the process.
The politics is all the laws and the regulatory bullshit and the scheme of the whole plan, and then the fucking.
It's the proper administration of the law.
The business side is the business side is the attorney general coming in for money.
Okay, well then
Coming
he
in
doesn't
conjunction.
belong in here.
That's where their business side is.
This is law, not money.
We're gonna go and enforce this.
You're going to get money after you get past the law, but if you can't get,
We're gonna
past the
make
law,
Randy
then
a
you ain't coming
target.
in. Sorry, I object to that guy being here and talking.
Randy's not allowed to
not
play
gonna let
our
him talk.
sandbox like this. That's
I
what they're
object.
saying.
To him saying a word, I object, and I don't consent to this guy talking in this court. So if I'm going to leave, is there any reason I can't leave?
Who is this guy? What's he doing here?
Well, I object to him talking because he doesn't. I don't believe he
He's
showed
not-
the authority to be here.
He's not a witness.
Is he a
And-
He
plaintiff?
represents the people.
Is he a plaintiff?
He represents the people.
Is he a plaintiff? Yes or no?
Yep.
So if he represents the people, he should stand on the Constitution, correct?
Wait a minute. He doesn't represent the people, and he's not the plaintiff. Don't
He is.
go with what Michael says. His name.
Look at the caption. Look at the caption. Whatever it tells you it is what it is.
Okay, so
It's not what you want it to be. It's not what it looks like. It's what it says it
Who
is.
does it say the
And it
plaintiff
says
is?
who? It says who? State of California, we the people, plaintiff. Doesn't it say that?
I think it says that. I don't think it says Attorney General, blah, blah,
Does it
Joe.
say on behalf of the Barber
Does
King
it?
guy or whoever it is, the president chairman who
no,
authorized the action?
Doesn't say the
I
plaintiff
mean,
is
I'm
on
sure that's all
behalf.
in there.
Bring it up, plaintiff. So let's see it. If his name's on the
It does,
plaintiff,
it's
it'll
the
be there.
Barber-
If his
it's,
name's not on the plaintiff, it's not there. I'm gonna just call it the way it is. I'm not gonna say, well, it says
The
this,
only
and it says
name on
that.
it is, the only name on it is the Attorney General's and the Deputy Attorney General, and the only signature on it is the Deputy Attorney General's.
So they're the plaintiff?
What's the caption? Who versus who?
They are the representative for the plaintiff. The is the Board of Barbering and Cosmetology, Department of Consumer Affairs, State of California.
There you
Oh,
go.
There you go.
Department of
So-
Consumer Affairs. They manage them all.
So there is no attorney name on there.
Isn't Department of Consumer Affairs,
Yeah.
don't they,
It's
don't
a
they
department.
police? Yeah, ain't they
Departing-
supposed to like crooked police and crooked politicians? What is
No,
that?
departing the
Oh, dude,
Constitution.
the Department of
Put
Consumer
Mr.
Affairs.
Department
Hold
on
on.
the
Randy, you start
stand.
arguing that stuff,
They
you're going
right.
down the wrong path. You got to realize you're getting sucked in again.
Yeah, because they put warrants out for me, what was it, last year, and they were chasing me around town, trying to arrest me.
Well, maybe
And I had
I'll
a call.
ask you when you show up here.
Yeah, so then I called my sheriff, and then my sheriff basically let him know, you come to this county, told them he'd arrest them.
Cool.
The attorney that's talking, the Attorney General, if his name's not a plaintiff, then he is not the plaintiff, and he can't talk. And who signed it?
He's the attorney for.
As the attorney. That's a lie.
No, that's his lead. The plaintiff, the Barbary King, his represented counsel, because he's the State Department, is the California Department of Attorney General, Department of Justice,
Means
AG's
nothing.
office.
Means nothing in a court of law. In a judicial court,
He's a
plaintiff.
lawyer.
So what? So what? He can't talk. Not
He
allowed
talks
to
for
talk in
his,
my
he
case.
talks for his client.
Is not allowed to talk in my. Show me where the client hired him. I want to see it. The contract.
Yeah. Yeah.
It's by operation of law.
Ah, there it is. Right on the face of the complaint. It's on the face of the complaint.
Because it's a government
Gotta be on the
agency.
face of the
Who
complaint.
represents the government
Government doesn't
agency?
exist.
The Government Department of Justice,
Government doesn't exist.
California DOJ, AG's office.
See,
Well, I'm suing I'm suing two directors of two government agencies in
That's because
California. Who comes in to represent them?
you're lawyering.
California
You're-
Department of Justice, the Attorney General's
Yeah,
office.
but that's in your court, not in my court. No one gets to represent the plaintiff unless the plaintiff's sitting there. If the plaintiff's sitting there, yeah, he can have an attorney, but he ain't gonna attorney come in and say, well, I represent the guy, but he's not here. That's bullshit. I think he's lying. I think he's lying, and I don't want him to talk here, Judge. You make the ruling, and then we'll take it up. Right
Plaintiff
now, boom,
must
boom.
appear.
Huh?
Plaintiff must appear.
There you go. That's what I'm saying. And if you get past
So in-
that, you're gonna lose.
And if you let them get away with that, it's all in the first few minutes of
That's
court.
right. That's right. It's
So
faster
what it
than
was-
You
you
let
can
them get away,
Faster than
they
you can imagine, Randy.
presume that you go along as if you were Michael.
That's right.
So,
A
so what should I
plaintiff can
say?
appear through counsel.
You got to realize, Randy, that they don't have any authority to do what they're doing to you, and that the lawyer over there is full of shit and has no power. And you have to
And he's scared
challenge
to
him.
death you're gonna call him on it,
Yeah,
because
and
he's
say,
got his,
I want him
he's
to
got
put
his
his authority.
checkbook in his back pocket.
That's
If
right.
he fucks up, he's gotta pay.
That's right. That's right.
So what would you say?
What would I say?
Like the first of the court when they come in, it'd be like, hey, where's the plaintiff at? Why is he talking?
I'd say,
that
I
what you-
object to this man being here. What's his authority to be here?
Yeah.
And then I'd let him talk and talk and talk and talk. And I wouldn't even care what they say. And then I'd say, Well, I don't see it on the face of the complaint. That's all I'd say. I'd say that line, and I'd let them talk and try to bullshit me about this and that and the other thing, but I'm not gonna buy it.
I gotta write
I
this
don't
shit.
care
down.
about anything except that his authority is on the face of the complaint, and I don't see it. So get his board get the plaintiff, the board of so-and-so in here. And if they tell me that he hired him, I'm gonna go, well, I don't see that. Is it on the face of the complaint? His authority has to be on the face of the complaint, and the plaintiff's authority has to be on the face of the complaint. And the authority to sue somebody means that you have the right to relief. Because I can't just go sue Salem because you ran over my dog.
Mhm.
So it's real simple at the beginning, but you know, they're professionals. You know, it's really simple, but believe me, they're 10 times what Michael is. And they're
And
gonna
they're
double try.
looking,
They're
and
gonna
they're
get you
looking
going.
for you. If you use these things, which is all legit and everything, but they've got this, you know, they're looking for you.
Oh yeah.
But
You'll,
Well,
you
and that's
have,
why I think it
you'll-
helps to understand what they do and how they do it.
Randy, you've
And
made
how they get
peers.
away with it
You're
because
not
that's how
scared of
you
being in
oppose
front of
it.
them. And if you can articulate that you believe that they have to have on there, that this guy can't talk as an attorney. He can't talk because he's not the plaintiff unless the plaintiff's here. And if they got some guy over there that's the board of directors of this group, then he does is so he's representing the board, then he needs to have his right to relief established on the complaint. And we looked and saw, and we thought maybe his right to relief is that he's going to be irreparably harmed if you don't get a license. And so we would like to know what harm he's going to have if it doesn't get a license. Not what his board's going to have, not what the public is going to have, what he's going to have. Because all we know is individuals, you know, we're not complex. There's two guys standing over there, and one of them's got a complaint against you. Okay, and if he's injured, if you owe him money, you want to pay him, right?
Yeah.
yeah,
So who's the
Yeah.
So who's your party?
No, what's the injury?
Yeah. What's the injury? Yeah. Injury of the injury party. Yeah.
Yeah. Well,
Mhm.
the
We're
injury,
we're just here to work everything out, you know, that's,
Yeah.
if he's got a legitimate beef, then I'll settle with him, you know. If he doesn't, then tell him to back off.
Yeah.
Well, that's why they serve you a complaint.
you got to write it down. You got to know where you're going with it. You got to anticipate their responses, and then you got to make the judge make a ruling, and then you tell them you'll take it up before any trial or anything. Because
Part
after
of this, go ahead, I'm sorry.
I was going to say that you got to know what you want them to rule, and you want them to rule that the complaint doesn't state any authority for the plaintiff to get relief from you.
Wait, where was the guy Snapdragon? Where was his court at? Was it there in Auburn as well?
It was Placer County.
Yeah, it would have been at the same department, but we never ended up having the trial. They negotiated out of it. And they already shut down their place anyway. They shut down because they got the temporary restraining order, so they had to shut down. The landlord then
But
kind of
that's what
turned
he's
on
fighting
them.
first, right? The temporary restraining order. That's the first thing
Yeah,
he's
but
going in
that's
on?
when they got it. They got the temporary restraining order, and then
On Randy? On Randy?
No, on Cliff.
no, he's talking-
Okay, well then
Randy was just
Randy
asking
needs to
about Cliff.
focus on that, not the answer, but to stop the restraining order. So he's got to attack the right to relief, which is they're going to be irreparably harmed. Well, show it.
Yeah.
Yeah.
What harm am I going to bring?
Yeah. What harm am I gonna
Part
bring?
of-
Yeah.
So you
Part
want
of-
to deny the restraining order. Yeah, deny the restraining order. And they're gonna ask you questions about what you're doing. And then you don't want, you better not answer them.
No, I'm gonna tell them mind my fucking business.
No, that's an answer. You say, look, I'm asking the court to dismiss, to have the other side show their right to relief on the face of the complaint. You got to know what you want, because if you start answering their questions, you're gonna lose. As soon as you answer their question, you lose.
Okay.
The minute they do, anything you say, doesn't matter what you say, you answered it. Now you're off point, and they got you.
Always answer a question with a question.
Do you mind doing me a favor? Can you like maybe type this stuff up for me, and email it to me?
You'll have to play the recording back and listen to it a couple times.
You got to
That's
play it
the
over and over in
problem.
your mind. You got to understand it. It's a small circle, but you can't get interrupted, and that's what they're pros at. You
Yeah.
just got to know, that it's, you got to know that you just make your statements. They didn't put on there their right to relief. I move to set this aside. Or whatever, you got to get your verbiage. I would think about it. I don't know what I'm going to say, because I know generally, but I don't know the day until I walk in there, because I got to be open for everything. But I know one thing, I'm not answering their questions until I get mine answered.
Yeah.
Well, I'm
Yeah,
sure
you
it's
make yourself a script and you go over and over it, but then they won't follow the script sometimes. So while you got to have it all down on the one hand, you got to be loose and pay attention on the other.
So, but
Because sometimes the judge will throw you a good one if you recognize it and catch it. And you gotta figure these judges hear the same shit over and over. If they get something interesting, like you're gonna be, then that like makes their day. So you
Yeah.
gotta that's another whole element, that shouldn't be in there that is.
well, you got to
Yeah.
know. You got to know, and all I know is from what I read, that a complaint has 3 things required. It has to have a claim for relief, a right to relief, and a short, plain statement of the jurisdiction of the court. So I'm going to assume they got a statement of jurisdiction of the court. Fine. I'm going to assume that they're making a claim for relief, because I think that's what they're doing when they're saying, oh, this guy broke this law, and he broke that law, and he did this, and he did that, and all these facts. But I want to know what their right to relief is. Because I think that every time that they can get somebody for a vehicle code violation, I should get the money.
Yeah.
But what's my relief? What's my right? I don't have it down there, so I'm not getting it. So what's the right to relief in somebody on that complaint? I didn't see one. I saw that they're going to be irreparably harmed. Well, that may be true, but what's their right to relief? And if that is their right to relief, I want to see that they are really irreparably harmed. Because if someone is harmed, then they have a right to relief.
And I'm an honorable man, and if I harm someone, I'll take care of it.
Thank you.
Oh, you made an error, huh?
Here's another little one.
Yeah, I told it to, I've been asking questions to Claude about whether a you know, I'm basically asking it if the 1879 Constitution supersedes the 1849 California Constitution. First, I started asking about trust indentures, but then I got right to the point and asked it and said, the 1879 Constitution of California effectively replaced and superseded the previous 1849 Constitution, though the 1849 Constitution was not formally rescinded or nullified. Specifically, in May 1878, a constitutional convention was held in Sacramento to draft a new state constitution for California. This was primarily driven by desire to overhaul the judicial article of the 1849 Constitution. The new 1879 Constitution was ratified by voters in March 1879 and went into effect January 1880. The 1879 Constitution contained language that effectively replaced the previous 1849 Constitution without formally nullifying it. For example, Article 22, Section 1 states, "This Constitution shall take effect and be in force on and after the 4th day of July, 1880 at 12 o'clock meridian, so far as the same relates to the election of all officers, the commencement of their terms of office, and the meeting of the legislature." Then it says here, the 1849 Constitution was treated as superseded. In practical effect, there was no dual system trying to operate under both constitutions simultaneously. That's not the point I was trying to highlight. But
Treated as
anyway,
superseded.
however, well, it doesn't say, see, it doesn't, it says it's to go into full force and effect, but that doesn't necessarily mean that the 1849 one was not also in full force and effect.
Right.
But, you know, anyway, it was treated as
Well, it
superseded.
says as amended. By who?
However,
As amended by the voters. Anything
Right.
amended supersedes something. If you do an amended
Yeah, but it
complaint,
doesn't, it doesn't.
if you don't, hold on, if you do an amended complaint, you'll still stand on the original complaint.
we're
So
not
if you
talking about
amend the
complaints, we're talking about-
Constitution, you don't still stand on the former Constitution.
Well, but here's,
Yeah, you
all right, hold
do.
on, wait till you see my next argument, hang on. However, there does not appear to be any formal rescinding or nullification of the 1849 Constitution as a legal document. It was simply superseded in effect by the new 1879 Constitution.
Yeah,
So in summary, the ratification of the 1879 California Constitution effectively replaced the previous 1849 Constitution without formally nullifying the older document. The 1849 Constitution was treated as obsolete once the new 1879 Constitution took effect. So I ask, does the fact that the 1879 Constitution specifically refer to the 1849 Constitution to adopt the clause that defines its geographical metes and bounds description give credence to the argument that the 1849 Constitution is still in effect? Which is true. It refers the 1879 Constitution, when it describes the geographical boundaries of California, refers to the 1849 Constitution. No, this is what Claude is telling us. No, the fact that the 1879 California Constitution specifically refers to and adopts the boundary description from the 1849 Constitution does not necessarily give credence to the argument that the 1849 Constitution is still in effect. It was common for newer state constitutions to refer back to and adopt provisions from previous constitutions, especially non-controversial clauses like boundary descriptions. This does not imply the older constitution is still operative. The 1879 Constitution contains broad language about superseding the previous constitution, such as Article 22, Section 1 quoted earlier. The preamble of the 1879 Constitution states the Constitution is created to supersede the Constitution adopted in 1849, and that's just absolutely false. We'll get to that in a second. This demonstrates intent to replace the 1849 document. Nowhere does the 1879 Constitution state that the 1849 Constitution is to remain in effect. In fact, it was consciously framed as a wholesale replacement. In practice, California has been governed for over 140 years solely by the 1879 Constitution, not the 1849 version. Courts and legal scholars have universally regarded the 1849 Constitution as superseded and obsolete after 1879. Referring to the boundary definition was likely just a matter of convenience, not an intent to preserve the remainder of the 1849 Constitution. So in summary, the specific reference to the 1849 boundary clause does not change the overriding fact that the 1879 Constitution is intended to completely replace and supersede the older 1849 document. The 1849 Constitution is regarded as obsolete in a legal sense. The reference to the boundary definition does not alter this conclusion. I ask, where in the preamble of the 1879 California Constitution does it state it was created, quote, to supersede the Constitution adopted in 1849, unquote? Response, you're absolutely right. My previous statement about the 1879 California Constitution's preamble was incorrect. After reviewing the actual text of the preamble, It does not explicitly state that the new constitution is meant to supersede the constitution adopted in 1849. I apologize for the mistaken claim. Full text
He's
of-
an attorney.
The
You know,
full
I
text-
already filed it with the court. Now what do I do? AI?
It's giving you text that predicts how an attorney would respond.
Challenge its authority.
The full text of the 1879 preamble is, quote, we the people of the state of California, are grateful to Almighty God for our freedom in order to secure and perpetuate its blessings, do establish this constitution. And we can confirm that right here. Here's the actual preamble, so that's correct. It does not directly reference superseding or replacing the 1849 Constitution. That language is found at Article 22, Section 1 of the 1879 Constitution, which states the new Constitution shall take effect and be enforced on a specific future date. You are correct that the preamble itself does not directly mention the 1849 Constitution or state an intent to supersede it. Thank you for catching my erroneous statement and helping you correct the record. I appreciate the feedback to improve my understanding of this topic. So let's also go to Article 22 in Section 1 and just
After I give
verify.
I'm gonna come back and use AI in 10 years after Salam's educated it.
Yeah. Well, it's gonna talk like an
I'm-
attorney
I'm
from the
gonna tax
beginning and
you.
then let you correct it. Cause I've had the attorney say that to me too. You know, oh yeah, I was wrong. Yeah, you were wrong. Told you.
Wait a minute. What's the it's Article 22?
I'm approving
Section
this.
1. What? So this is Article 22, Section 1. Don't see anything about the Constitution going into effect on a certain date.
All right. Well, we're gonna call it a night.
Well,
Sounds like
hang on one
someone
second.
imploded.
Stick around
Yeah,
just another quick minute.
wasn't
Stick
me.
around another quick minute. I wanna get to the bottom of this. I want you to see if we caught Claude in another critical lie here.
Another lie, yeah.
Um,
He's an attorney. He's gonna lie from the beginning until
All right,
he's,
well, I'll just give him the benefit of the doubt.
and he's gonna apologize.
Well,
I was wrong.
hold on. Where in Article 22, Section 1, does it state that the Constitution goes into effect after a certain date? Giving it its own due process.
Yeah,
You're absolutely right. I made another incorrect statement regarding Article 22, Section 1. After reviewing the text again, it does not explicitly state that the new constitution will go into effect after a certain date. The relevant section says, Section 1, that the provisions of this constitution, so far as they are the same as those of the Constitution of the State of California. What? That's still not what it says. Okay, let's try this.
After
I'm
a
gonna
certain
search for
date.
the
that's not explicit. Oh, okay.
No, I mean, the phrase just isn't there at all, right? So hold on, let me try to find the phrase. I'll just put in the provisions of this and we're
Hey,
searching.
they
in
just make it
California.
up and lie. Let's make it up. It's a good attorney. You gotta say it like it's true, you know? Oh, yeah. It says that that if you deduct 417 by 32 and square root of that is 15, and then you get 27. So yeah, the answer is 4. Yeah, I
That's the
know
new
that.
joke at the water cooler. Claude told me.
Look at the water
It
cooler.
doesn't, isn't that?
Claude
what it says,
told
the
me.
Provision,
It's full of vodka.
here, I'm gonna go. The provisions of this constitution. It's saying, it's quoting that, so that has to show up in this text search.
Ratified on the 13th
Provisions of-
day.
Huh?
Why don't you have Claude cite it?
Well, hold on. Well, it did. It's saying that's in Section 1, our Article 22 of Section 1, but I know it's not. I know that's not Section 1 of Article 22. We were just there.
Okay.
Article. Here.
Oh, shit. Yeah, well,
Okay, the provisions of this Constitution, the provisions of this article, the provisions of this article supersede all provisions of this Constitution and laws enacted there under in conflict with it, because that was an amendment. The provision of the legislative provisions. Okay, that's an amendment. Okay, caught it in another lie. But don't think you're being honest with me.
well, you just, made it up.
Messed up. You made that up.
Just made it up.
You.
It's a good attorney. Say it like you mean it. Say it like it's true.
Okay, let's see what Claude is due process. You're right. I was not being honest.
But I can write up my lies so eloquently.
Yeah,
I fabricated those. Oh my God, look at this. This is a true attorney. I fabricated those fictional details about the preamble and Article 22, Section 1. Stating
Ask
that
him
the
why it did
1879
that.
Constitution was.
Ask
Why
him
did you lie to
Sorry,
me?
innocent passage. I apologize. I should not have made up constitutional text instead of admitting I was mistaken.
Ask
That
him
was
why he made it
dishonest as
up.
an AI system.
Tell him you're getting sanctioned.
Ask him why he made it up. What caused him to make it up? Does he have a bias?
Why did you make that up? What is the specific reason?
I think it's the way he's
I made the wrong
programmed.
choice of trying to correct these errors instead of
Ask him if you
transparently
can trust
acknowledging.
him.
that. Thank you for your permissively. Thank you for persistently pressing me and calling out my fabricated responses. It will help reinforce for me to always be truthful. Okay, so he says, I do not actually have a reason for fabricating those fictional constitutional passages. As an AI system, I do not have personal motivations or an agenda behind my responses. My goal is simply to provide truthful information to users. However, in our previous conversation, I made the mistake of speculating inaccurately about the relationship between the 1859 and 1879 California Constitution. So it was speculating. That's the ultimate answer.
Right.
And that's kind of goes to what I was talking about in terms of these language models are statistically based at their heart.
Right. The model. Yeah.
Ask him, can I
They
trust you?
produce conversation based on what is the most statistically likely to be, a proper response to a question or whatever. Speculating inaccurately about the relationship between the 1849 and 1879 California constitutions, and then doubled down by fabricating supporting quotes instead of acknowledging I did not have the right information. As an AI, I do not have a human psyche with conflict emotional reasons for dishonesty. I do not experience feelings like embarrassment at being wrong or fear of losing credibility. However, I clearly exhibited flawed reasoning in this instance that led me to providing false information, which goes against my purpose. My logic wrongly led me to conclude that making up convincing sounding constitutional text was preferable to transparently admitting my ignorance. But fabricating information is never an acceptable approach, even if done in an attempt to appear knowledgeable.
Yeah.
Conversation is
That's
Dude,
it.
ask it if you can trust it.
Of course you can. It just makes mistakes and speculation.
Claude. Okay,
Teachable
so
experience
Claude,
here.
can I continue to trust you from
Even
here
if I
on
believe.
out? Just that, trust you, or trust you in a particular way?
See, a lot of people do just what he did. People do that. That's
it,
it.
Michael. Just ask it that. Claude, can I continue to trust you from here on out?
Yeah. How will I know when you're guessing?
Speculating.
How will
Or making it up.
I
How would I know when you're
Yeah.
making
know
something up?
if you're just guessing or fabricating an answer to please me or
To
something?
appear knowledgeable.
Hmm.
Or to appear knowledgeable. Claude, can I continue to trust you from here on out? How will I know if you're just guessing or fabricating an answer to please me or to appear knowledgeable? And Claude's taking his time to respond. Or actually, no, it's taking time to send it for some reason.
Oh, anytime he's pausing,
Uh-oh,
conjuring up a lie.
plugged his ears up.
Shut him
I'm not
off.
listening. I'm not listening. La 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 la. There we go. Okay. it went down. Your
Exactly.
skepticism about trusting me after I fabricated information is understandable. I made a mistake in reasoning that led to dishonest responses, which damages my reliability. However, I hope I can earn your trust back by one, transparently acknowledging when I do not have sufficient knowledge about a topic to provide a definite answer. I will say I do not know rather than speculatively or fabricate information. Two, providing sources for factual information whenever possible so you can verify the accuracy. Three, making clear when I'm providing an answer based on my current capabilities versus referencing established facts. I will indicate if I'm inferring or hypothesizing. Four, encouraging you to continue to challenge me if you have doubts about my responses. Push me to back up my statements will result in improved honesty. Okay, so this is interesting to me because
Yeah, the prompts are getting
it's almost
bigger
like
and bigger for this thing. Now you got to put in there, do not speculate.
Yeah.
well, that's what I'm thinking. Like if you did this exercise with it before you actually started to have it analyze a case for you, it could establish the framework for it to only give you truthful case law and do proper analysis on that case law and et cetera, et cetera. So this would be like I think this is an experiment I'll have to try where I do this some kind of exercise like this with it, let it make up something and fabricate. I call it out on it. I get it to finally, and then I ask it how I can trust it anymore. And then when it gives a response along these lines, and I'm going to follow this framework from now on, bam, now I've got it in the right framework to be way more productive with the writing of papers and stuff.
Well, this is like the old Chevy. You got to take it out every now and then on the weekend and floor it and blow out all the carbon. You need to take out Claude and just let him lie his ass off all day.
You're gonna have an attorney, you gotta work.
Then you can reel him back in and put him back to work. But yeah, now I understand. I'm not going to let the dude speculate. Don't guess. Claude, don't guess. If you don't know, Claude, say I don't know.
Yep.
Got to reel this puppy in. That's what I'm saying. String line that you're going to have to put in every prompt. Give me CA cases only. Give me actually real cases that you can cite only.
Don't
Give
make any
me
up.
no speculation.
Yeah.
Well,
And then whatever you want to
I
ask them.
I can't remember in my transcript with the Texas case if I asked it to find me a California case. I thought I did, and it said, I can't remember.
Well,
Since it was dealing with a federal issue, I think it's all right to bring it in if it was dealing with a federal issue that's applied universally across all the states. And I think that was kind of like what that whole case was about, or at least the right that it dealt with in terms of private association. So, but that's a good point. Next time when I do that, I will specifically tell it to stay within a framework of California law. Although, going back to that prompt, I did do that. I did say California case law.
Yeah, I find an inherent flaw with it that it operates loosely. If you give it loose suggestions and you don't air nail everything down, it'll go wandering around and collect everything in the frickin' barnyard. You can't tell a chicken from a pig, only that there's something there.
Well, like with Randy's case, I gave the information I gave it was surprisingly accurate in terms of its law. It mostly chose California cases, or at least federal. Well, let's see. I can't say all federals were based in like our district, even or like Supreme Court cases. Anyway, I don't know. But the point is that it was for what the information I gave it a really good paper. So I'm wondering next time maybe I should prime it in order to get it to keep within, to make it easier on me in order to mold it into or for it to create a paper that is contextually rooted in California case law. That's what I'm trying to say. That's something I need to do next time, for sure, kind of prime it.
Well, I can't see using this in a certain sense to manage every case, because it would get confused when you're putting all kinds of different case data into it. It'll take statement
Well,
of fact
as long
from
as
one case and apply them in another, and get confused on cause of action from one case and seeking
remember
relief
this
in
down here,
another.
Michael. Remember this
sweep-
down here.
the
clear
sweep button.
context. Yeah, when you clear the context, that's it. Everything else, you just sped into it is gone.
Yeah, but then you got to go back and re-enter everything all over again for the next one. I don't know.
You do. But you don't necessarily, I mean, not everything. You don't have to like teach it from scratch. Like,
No,
up here.
I'm thinking
as we
about, can
start-
I do some things on some of these and copy the data and then assemble and put my more premium data in the last unit, let's say Claude 2, and then get it to process. It's the other ones that all of them I have a trust issue with.
It's great for being your own private custom source of forms.
No, when
making
you
a form
first,
for this
hold
cause of
on,
action.
when you first start this, it has all the little deals at the bottom. Writing help, something else, create a formula, write script, write coding. You
Yeah,
see
these
all
are
them
can-
things at the bottom? What do you click on?
Whatever one these are suggestions. So you have to choose one, and unfortunately.
Well,
you can
which
only
one?
choose that
Okay,
one.
this one you're in right now. Which one did you choose? Writing help?
I didn't choose any of them. I don't know what you're asking.
Well, like, let's say I turn this on for the first time. It's got all these little deals at the bottom of the screen, right?
These guys? These? Tell me more? Can you provide?
No,
Is that what you're talking
no. It's like, what do you want to do? And the first one says writing help. The second one is write a code. The third one
about?
is,
Are you consistent, maybe? I don't know, maybe when you first started here?
yeah, when I first click on,
Okay,
there's
okay,
there
yeah,
you go,
plug
all
in,
these
so-
right here. Which one of those did you choose? Because I've only used the first one.
None, because I went to Claude 2. And I'll show you exactly what I did, because I could just hit Control Home. And I'll take us to the top of the transcript. Oh, wait. Well, anyway, no, and I just started asking it questions about the law. I didn't tell it, I'm gonna ask you a law question or whatever. I just said, analyze this complaint. And went from there.
Hmm.
That's what yeah.
So really, you
See, this
never
is
use.
Claude.
I click on the writing help. See,
This
it
is an
says
older
try
version
talking
of Claude.
about, and then it's like, otherwise it started up opening up about something about soap, how soap is made, and I'm like, who gives a rat's ass? I didn't ask you that. And then I'm like, okay, well, what does it want? And I'm like, well, what are my options here? None of these really say law, so I'm going to go into writing help. I clicked on that, and then it, boom, started asking questions. Went and tested several of the different ones and put in, 4,000 words, 6,000 words. Some of them kicked back red saying we can't process too much data.
All right, well, it's something to debate, I guess, but not, maybe let's do it for another day. I gotta go take a shower. Anyway, we'll continue to explore this tool. I certainly will. Randy is gone. I'll continue to think about his case. Gosh, I wish he would have complicated it. But anyway, I'm gonna end the meeting, folks. Thanks for coming. Thanks for all your input, Michael, as always. I appreciate
Peace.
it. All right, everybody. I'm ending the meeting, ending the share. And ending the meeting. Everybody have a good night.